Hey, what's up, guys? Welcome to Lost-Planning the Interwebs. I don't need these yet. I'm your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. And today we will resume the trial of Kyle. Kyle Rittenhouse, accused of recklessly murdering, and then intentionally murdering two people, and then severely injuring a third, along with a couple other violations. So we are here. We are here to see how it goes. Thank you all for joining me at this early hour. I am not great at mornings, but it is it is a morning. If you are not familiar with the show, if you're tuning in later, I think most of the people who are watching right now probably are familiar, who are watching live. But if you're tuning in later, or you're watching from the beginning at some other point, that would be later, I suppose. I am a lawyer in central Minnesota, and I am watching the Kyle Rittenhouse trial. I typically do a live show every weekday at 11 p.m. Central Time, 11 p.m. till about 2 a.m., including last night. So it is almost 9 in the morning. I had a nice short night, and we will continue on with Kyle's issues. And on this channel, we will be watching basically all of the trial that is findable, we'll say. I think that's the wording to use here. Findable. But welcome to the show, everyone. Let me just, I'm just getting things set up in the background. I wanted to make sure we were starting on time. We will be borrowing the live stream today from, whatchamacallit, Yahoo Finance. As a preliminary matter, who's stealing it from Court TV? Maybe I'll go find the Court TV one real quick. As a preliminary matter, if you, here we go. Perfect. What the hell is this? You are here and watching this stream to receive commentary and analysis from me, and we will be joined at some point by Uncivil Law. Uncivil Law is another legal YouTuber. So that's why you are at this particular channel. If you do not want commentary and analysis, if you want someone else to, or you don't want someone talking about what happened or what's going on in the courtroom or anything like that, go watch a different stream. Just go, that is fine. You'll be happy there. You can watch this whole thing on Court TV. You can watch it on Yahoo Finance, and there will be no dummy sitting on the screen talking about what's happening and trying to help translate what's going on for you. That will be very easy for you to do. But you are here for the commentary and analysis, or you shouldn't be here at all. There's not much else to it. And so if you tell me, don't talk over this or don't talk, the answer is no. The answer is no. As a preliminary matter, just to get things out of the way. Okay, let me tweet this out. Kyle Rittenhouse trial coverage resumes now. I'm joined. In case people didn't see the link yesterday. What are you talking about? Oh my gosh. Okay. Almost ready. There we go. I think I'm set. I think I am now set for this show. Ugh, I just got out of the shower. So nice to be freshly showered. And whoo. So as a recap of yesterday, they did finish jury selection in Kyle Rittenhouse's case. Oh my. They did finish jury selection in Kyle Rittenhouse's case. The jury is paneled and they are ready to go. Today will actually be the opening statements for the prosecution and the defense, and we'll see how far we get with that. But that will set us up for this trial. These opening statements will be how we discern the sort of framing that each party is bringing to the case, how they are going to set the tone. They will be setting the outline of their case, and we'll get the basics of their argument, what they plan to show as evidence as this trial progresses. And so that will help us discern kind of the posture. My initial impressions of this case are that Kyle has the stronger case here. Kyle has a pretty strong self-defense claim. There are not a lot of holes in the self-defense claim. Kyle is also charged with 2 criminal acts that they might actually be able to stick on him. And they are both small criminal acts. But as a refresher, Kyle is charged with carrying a gun illegally as a minor. So it's actually minor in possession of a dangerous weapon, or possession of a dangerous weapon by someone under the age of 18. Now, I believe there are certain legal exceptions built into that law, written into the statute, that should disqualify him from being convicted of it. However, the judge has not at the present time chosen to dismiss that charge. Though I fully believe it should be dismissed, I'm not sure if it will be dismissed. And if the judge does not dismiss that charge, it is very possible that Kyle Rittenhouse will be found guilty of that charge. Because if it goes to jury, the basic jury instructions is Kyle Rittenhouse under 18 at the time that he's carrying the gun, which the answer is yes. And then, is he carrying what qualifies as a dangerous weapon under the statute? And the answer there would be yes. A firearm of any type is considered a dangerous weapon under the statute. The reason I don't think it legally applies at the end of the day is because the statute itself has an exception built in for long-barreled rifles and long-barreled shotguns, which long barrel just means not short barrel, which means standard issue barrels. And all evidence indicates that Kyle's carrying a standard AR-15 style weapon. And so if that is the case, then he should fall under this exception, which would then change the reading of the law a little bit. But the jury instructions remain the same. So if the case is not dismissed as a matter of law, it will go to jury with the basic jury instructions of, is this a dangerous weapon? Is he under 18? Both of those are yes. And then he would presumably be guilty. Now, the other thing that he would likely be found guilty of if it goes to jury would be the fact that he was in violation of the city's curfew order. These are both misdemeanors. The curfew violation may even be a petty misdemeanor, which would be just a small fine. The other charge might carry with it the potential for jail time, but as I believe Kyle's a first-time offender, he probably would not get jail time from that. That just seems a little bit harsh. He would probably get probation. It would also not preclude him from owning guns in the future. It's not a violent gun crime, and it is not a felony. So that being said, the other charges, I do believe he can have fully justified self-defense claims. Now, I think there is also the possibility that a jury would nullify all of this, or would nullify those 2 charges as part of the overall self-defense claim. Remember, the jury has a lot of power to to make Kyle not guilty of any of these issues. And all Kyle needs is one juror who says not guilty to the charges means Kyle Rittenhouse wins effectively. As he would, that would then be a mistrial, and he would probably not be charged again. Zypher Warrior says curfew can be argued against since they never sought to apply it to anyone else. Not effectively. Selective enforcement and selective prosecution are fully allowed under the law. You do not have to charge anyone else with a crime to charge someone who is guilty of or who has probable cause to be guilty of the crime. You're not required to charge anybody else to charge one person. If 50 people are speeding, police officer only has to charge one person ever. They don't even have to charge that one person. So that is not an effective defense. All right. There are also super chats available for interacting with the show, and I will try and tackle those as we go today. We'll see how that happens. Oh, and finally, I will be on Adam Krigler's show right after this. That'll be around 5:30 p.m. Central Time. I'll be joining Adam Krigler to give a recap of what's going on in the case over there. Because I'm a moron and will be choosing to go on yet another show after streaming for approximately 8 to 9 hours on my own. Next, Viden the Cold One says, been in the hospital almost a week. I'm tired too. Oh, okay. Sure. Upstage me and my sleep schedule with your hospital thing. Got it. Okay. NGE fan says, how trashed are you and Uncivil gonna get? I don't want to get trashed at all. It's the daytime. So hopefully not. Hopefully zero. Angry Baneling says, so the judge came back yesterday after all. Yes, he did. They stayed and finished somewhere around between 7 and 8 p.m., I believe. Very, very long court day. Yesterday, at the end where we had stopped watching, they actually went and did private hearings with some of the jurors. The jurors could voice their reasons that they maybe wouldn't be able to be qualified as a juror privately to the judge. If they had some embarrassing family issue, or if they had some really private medical issue they didn't want to talk about, they could go ahead and do that. And that they did come back after that. It wasn't really clear at the time that they would. C Goody 564 says the only holes in the self-defense case are the holes in the ones that got self-defensed. But yes, Kyle the perforator. Kevin Dorr says Barnes talked about how critical in these types of cases jury selection is. Are you worried about the jury being seated in one day? I don't know. I don't know who they seated. We're not really able to tell who was there. I was not in the courtroom taking notes on the jurors and keeping track of their answers. So it's hard to say. And ultimately, I don't know who got seated at the end. Plus, the lawyers in the case would have been privy to those private discussions about why jurors would maybe not be qualified to participate. So we just have to hope that the jury selection was done effectively by Kyle's lawyers. I know there's a lot of controversy surrounding Robert Barnes' removal from the case or whatever. However it's framed, I don't, that is a side discussion that is no longer relevant to Kyle's case. Right now we'll be left with the speculation of what could this have changed? We don't know because we don't know the outcome yet. So let's see. Bill Bonius Bag of Donuts. Welcome to the membership status. Very, very happy to have you here. Ibney00 says, I'm a mock trial competition. Your coverage of Dr. Black really helped me format my questions for our expert on witness perception. Thank you. Oh, hey, cool. Glad to be of assistance. Hopefully you just said, whatever that guy said, I'm going to do the opposite. Scrape says, hit a deer on the way to work this morning. Wish Kyle would have gotten it first. Padria says, how long do murder trials normally take? Depends on the murder. I would expect this one to wrap up in the middle to the end of next week. They have given 2 weeks of time. They've given 2 weeks of time as an estimate. The judge was hoping that that was conservatively estimated on the long side. So we will see. Let's see. Waiting for this stream to start here. But yeah, the estimates in this one is 2 weeks. Those times are based on witness lists typically. How many witnesses do we have to get through? That's the question. Okay, I'm going to switch feeds from Court TV over to Law and Crime because it's actually there. All right, here we go. Oh, hey, my man.
How you doing, man?
My headphones on so I can hear you.
Excellent.
Welcome to the party, pal.
Fair enough. So they actually managed to seat a jury yesterday. I'm kind of impressed that they were able to do it in a day.
The judge said to the media they were going to do it in a day. So, he was like, I'm going to make it happen.
I guess, but still.
Let me welcome to the stream. Uncivil Law. How's it going, man?
I'm doing fine, thank you. I just built a new computer. We had a 4-hour live stream of my struggles in torturous ways, but yeah, just built a brand new PC. So I'm very excited about that. It's running. I'm talking to you from it, so that's nice.
That's good news. Did you do it like I did, where you were drinking whiskey and pouring the whiskey into the glass over the open motherboard?
No, I had enough issues with it to do it. So I was reusing the old case, and it took me like 3.5 hours. And there were many technical issues involved. The worst of which was one of my hard drives, one of my SATA hard drives. The data plug in the hard drive itself snapped off.
Oh,
so the pins are still there, but the little plastic thing that holds the thing in place is gone. So it's now being held in place with pressure and zip ties, and it's working, sort of. So yay.
You should get that fixed.
I'm working on it.
Okay, let me read these last two super chats that have come in real quick. And then we're just waiting on coverage to begin here. 200 Watt Studio says, Nick, been on the SCOTUS website looking for oral argument audios from before 2009. Site only goes back to 2010. Any help where I should check for those? I don't know that they have them anywhere. Do you know of anywhere to find pre-2009 audio for oral arguments of SCOTUS?
Oyez.com or oyez.org, oyez.org.
Oh, okay. Yeah, they I didn't realize they kept the oral audio or the oral argument audio there.
Yeah, I think they have all of it. So since they started recording, I think they have all of it.
Well, there you go.
And what's really nice about OYEZ is that, at least for the modern cases, I don't know for all cases, but for the modern cases, they have the transcript and they sync it up with the audio, which is really, really nice.
Perfect. We've done that commentary, and that's awesome. Yeah, because it like highlights the lines as you're going.
Yeah, people are talking about the SATA cable. They don't understand the issue. The problem isn't the SATA cable. The problem is the drive itself. The SATA cable has nowhere to clip into because the little plastic bracket on the hard drive has snapped off. The problem isn't the cable. The problem is the drive.
You're making a $3
or $5 SATA cable. I have SATA cables. It does not solve my problem.
You're making a critical error right now. You're accepting tech recommendations from the chat.
Yeah.
Never do it. They're always terrible. They're the worst. The chat is not helpful on tech issues.
Yeah.
Ever. That's a rule.
Yeah. But for those of you interested, I got an AMD Ryzen 9 3900X. I have 2 times 32 gig of memory on an MSI Tomahawk Max board. And I just got an M.2 drive, which is the 980 Samsung, which I'm still at this moment still running from my SSD. I've got the operating system installed on the M.2, so I'm switching between drives as I'm migrating. But yeah, that's the setup. So it should help a lot with the rendering time.
Yes, that's a big one. Do you get a graphics card? Do you have?
I'm reusing the same graphics card, so I have the 1070 Ti FTW edition. So I'm still using that same graphics card. I'd like one with RTX, but finding new video cards is hard, and the one I have is sufficient for my needs at the moment.
Yeah, it's a mess trying to get anything new. Frega Boom says, "Looking good, pal. Hey, what's up, man? How you doing? Oh my gosh, I owe that guy pictures of me in Fear. Dan, sorry. I was going to do them, and then I got COVID, and then I forgot." Dapper Wolf says, "Nick chug whiskey." No. No, thanks. BG Willia 21207 says, "Army Sarge, present kazoo. Sound reveal." Okay. CJ says, "Have Uncivil wash it in warm soapy water." Oh yeah, that's how you fix your hard drive issue. You just wash it with warm soapy water. It's perfect.
It doesn't seem like that would be productive to my mind.
Look, the chat is the worst tech support by default, because they can't see the issue, and then you'll get 500 suggestions on how to fix it. All of them are terrible. And then you do something that is similar to one of the suggestions, like someone's like, "See, I told you, idiot."
Yeah, what the chat may not know or may have forgotten is that I actually do have a computer science degree. It's my undergrad is computer science, so.
There you go.
There's that.
See, so. Chat, you're terribly wrong. You're terribly wrong. Yeah. Don't do that to this man.
Wasn't your undergrad in writing or something like that?
Literature and creative writing. Thank you.
There you go.
I didn't actually tag you in the video.
That's very rude.
But
rude.
I am tagging you. I'm changing it right now. I didn't mean to not tag you. It's because I started it on StreamYard and then didn't edit it in. All right. And then we've got President-elect Austin M says, "Binger is either masking his power level or he's king clown at the circus. Hopefully there's no more whamming moments. Pray for Bruce and his cough too." Pablo Castaneda says, "Stop insulting chat tech skills. We're the best at this. Also, Uncivil, have you tried to turn it off and on again?"
Several times. Yeah, and also one of the reasons I broke the HDMI connector on my camera, so now I'm running it off micro USB. So that was a thing too this morning.
Oh, good. You're breaking ports and connectors all over the place.
Yes, apparently.
All right, so give me your rundown of the case so far. What have you seen? What do you think? Where are you on this issue? So
I share your continuing confusion on the gun possession charge, because the way you've read the law seems right to me. I would consider myself open-minded on the issue though, because I'm willing to hear a good counter argument, and I really haven't heard one. So I think you're right, but I'm maybe not as sold as you on it ultimately, because it's like maybe there's an argument somewhere I haven't thought of, but none of them so far have made any sense. As to the underlying issues though, I think the self-defense claim is pretty rock solid. As you pointed out yesterday, the issue is subjective and objective. So we asked 2 questions. Did Kyle Rittenhouse experience a fear of death or grievous bodily harm? Probably. I mean, he just, in the first shooting, a gun had just gone off and he's being chased. Pretty good. And would a reasonable person in that position feel the same thing? It's like, yes, probably. Yeah. So the self-defense claims look pretty solid to me. Again, waiting to hear any sort of counter argument, because we only have the videos, but so maybe some eyewitness will testify to something that we somehow haven't come to our attention. That would be nice to understand the prosecution's case better. But so far, I think Kyle Rittenhouse is in the clear. Given what we presently know, a judgment of guilty would, in my opinion, not be legally sustainable. It is not legally viable. A reasonable jury, based on what we know, cannot come to the conclusion of guilty.
Yeah,
So,
I
change my
agree with
mind.
that. No, I got no reason to change your mind. I actually wanted your opinion on a different issue related to what you just said. So let's say we do get a jury who makes that decision.
Sure.
Do you think, from what you've seen from Bruce Schrader, the Honorable Bruce Schrader so far, that he would be open to a JNOV?
You know, I can't really say. I would say, as a general proposition, I think many judges are very reluctant to a JNOV. So if you had to predict, you'd predict against.
Yeah, I think that's safe. He just seems there is no audio yet.
He's got immerse.
It's not just you guys that it's muted for. It's muted for me too. Yeah. Okay. So JNOV is a judgment notwithstanding of the verdict. It's a way that the judge can basically say, okay, the jury said this, however, like, come on.
So the chat is saying it's 11 women. Is that the right demographics? Do you know?
I have no idea.
Yeah, we can look that up somewhere, I would think. Jury, Kyle Rittenhouse.
It's certainly possible.
Yeah, I mean, anything's possible. Let's see. Seated. Let's see. And they selected 20 people, which I don't quite understand. Oh, okay. So the 20 consists of 11 women and 9 men. So, yeah, we don't know. Are all 9? Yeah, it doesn't say which are alternates and which are not. So it isn't that specific.
Set forth what
okay,
is to
can
happen
you hear
or
them
how
now?
the court is
I
to
can.
work when there is
Okay, good.
An alleged exception, which we are alleging here.
Okay.
And I think that exception has to be put into and part of the instruction. And as it reads now, I don't think there is an exception. So I think that has to be included in the instruction if the court does not grant our motion for reconsideration.
And
Okay, this is on the gun issue
response is that
as a minor.
I have not been able to complete what I wanted to do on your motion for reconsideration. I didn't get it until later last week.
Mm-hmm.
Didn't mean you didn't file it. I mean, I didn't get it. And I didn't have a chance to, I looked at it somewhat, but not all of it. And there's one other thing I would definitely want to check, and some other maybe. So I'm not in a position to give you a final ruling on that. I think I should instruct on it. But what you're asking for is actually exceptional language, which the instruction is not going to be frozen at the time that it's given this morning. So I think in order to acquaint the jurors with that particular case, well, I don't know, maybe I just should leave that one alone because I'm leaving the ordinance violation of the forfeiture action alone. And I can just tell them I'll instruct them on everything at the end of the case. How do you feel about that?
Judge, I feel as though we've gotten a little bit lost in the weeds here. What the defense is alleging is an affirmative defense. If they want to raise that as an affirmative defense, they're welcome to do so. If it's not the subject for a motion to dismiss, the complaint need not deflect or address every single affirmative defense. And this, so I believe there's no basis to challenge the complaint to actually.
But even if it's an affirmative defense, doesn't the state have to prove it?
They wish.
Yes.
In a case, if they wish to raise
And if
an
it's
affirmative
a matter
defense,
of
which is
law,
that, he was
Yeah.
like, there's no
under
issue of
both
material
those,
fact in question here.
But I do like that the judge seems to be keeping an open mind on this issue. He didn't just slam him down.
Or the certificate of completion that the
This man is
second
not
part of
good
that,
at wearing suits.
third part of that statute
Nope.
calls for, they can do so.
What's going on with
But
his
they
neck
do that. I don't see
line?
why that should
Yeah.
be in the jury instruction. We don't have the self-defense in the jury instruction because that's another affirmative defense, and they should raise that. And if they raise that, which they certainly
What do you
will,
mean you don't have self-defense in the jury
they have to be
instruction?
in the charges at the end, or in the jury instructions at the end. So no, I don't believe that at this point there's any basis to dismiss it. I do have a brief that I could submit. I did not want to. I didn't want to be untimely, but that does lay out why we believe it's an affirmative defense and not a subject for a motion to dismiss. In terms of
I think you submitted that brief.
curfew violation, we're wondering how we're going to do that because that would be a 6-person jury, not a 12-person jury.
I don't think anything's precluding you from having a 12-person jury,
Sever
is
it.
it?
No, sever
Well,
it.
it's different
That'd be
standard of
funny.
proof.
Sever it.
Anyway, I can submit this brief and send it to the defense if the court would find it helpful, but it's an affirmative defense. I mean, it's clearly what it is. I understand the defense may not want this to be addressed at trial and may not want the evidence in front of the jury, but we've met our probable cause. We've met our standard in the complaint, and it's been bound over. And now it's
Also, just
defense if they want.
I don't like his posture, and I don't.
We disagree that being 17.
Well, also, what's with the sitting?
is
I
raised
don't.
up for defense.
While talking to the court, that's weird, isn't it?
Present the certificate
Yeah.
of completion
He's sitting very strange.
of a hunter safety permit as called for in the statute. Thank you.
Well, okay. Yeah, I think what I'm going to do is refrain from giving any instruction on either count 6 or count 7, and tell the jury that I'm not going to give them an instruction at this time on those.
Yeah, I'm not sure why you would give any jury instructions at the start necessarily,
Well, I don't know if that's probably not the best thing.
other than the standard instructions
Then
of
what
you
we're
can't
talking
talk about the case,
Um,
that kind of stuff. But why you would give
well,
legal instructions as to
what's your
law
reaction to the claim that it's an affirmative defense?
seems
Not an affirmative defense.
Yes.
For 16 and 17-year-olds, it's not an affirmative defense. The information that I've provided to the court
Affirmative defense is he
through
was
the
18.
legislative
defense.
history makes it clear it's an exception. It's not an affirmative defense.
It's in the statute.
It is an affirmative defense for people under the age of 16. I'd agree with that 100%. But if you look at the Senate Bill 7 and the 1991 Act, in 3 different places, it tells you in plain language that it does not apply. Not for hunting purposes. It does not apply, period, to 16 and 17-year-olds.
on just a purely presentational basis. Kyle's lawyer is much better. He's looking at the
and I
court. He's not
provided
hunched
that to the
over.
court, both in
I mean,
the Act and in the Senate bill, Judge, and in the Legislative Reference Bureau information.
Well,
So-
It's insane
I'm
to
going to
suggest
give the
that
instruction
an
as I
exception written into the
stated it.
statute is an affirmative defense.
These are.
If it was an affirmative
these
defense
are
written into the statute, it
educational.
would
They
say
don't
it
get a
is an
written copy,
affirmative
and
defense
they're-
to this crime.
Just so they know what we're talking
Yeah.
about when we talk about these charges. And at the close of the case, I can add whatever language is necessary, if assuming that the motion is denied, which you shouldn't assume, but if the motion is denied, then I'll add the language that clears up what exactly the full scope of the charge is. But I don't think.
Fact, the defense's hair is nice.
I don't want to leave them uninstructed on the one hand, and I don't want to misinstruct them on the other. But no matter what it is exceptional from the general language of the statute.
I'm not going to.
No, it's
in
in the language of the
liability
statute.
offense today. If you're under 18 and you have a gun, you're guilty. And I don't think that's what the law is. So that's the problem that I have. The statute clearly lays out exceptions for that. And to just say he's under 18 and he had a gun, those are not in dispute, then he is, the way the instruction reads, there is no affirmative defense, whether it is or not, there is no defense.
No, unless he has the.
No.
That's the last part of the statute. In
Yes.
Wisconsin, if you're under 16, you need to be accompanied by an adult to hunt, as long as you have hunter safety. If you're 16 and 17,
That's how you read it.
Right, not how we
That's how
read
we-
it.
Ooh, nice little burn there.
that's how they cite it.
Yeah, okay.
So in
all
16 and 17-year-olds, you can hunt alone with a hunter safety permit, which is what the last part of that statute calls for.
Yeah, well-
It's not
And
what the
that's
statute
completely
says.
ignored,
Not at all.
in Mr. Trofsky's argument.
Okay. I am going to
Grant the motion to dismiss. That'd be funnier.
give some very incomplete language to acquaint them with the fact that there's a charge on the information respecting the possession of a firearm, and that I will instruct them concerning the elements of that offense at a later point. Okay, and the same thing will happen with respect to the forfeiture action. So, any other objections or problems with the proposed instructions?
Judge,
Yeah.
I didn't see on count 5 that you, on 1, 2, 3, and 4, you put an except, or you give the self-defense instruction in some level. I didn't see that for count 5, however.
Didn't I have a general instruction on self-defense?
You listed them specifically for the charges or for the counts?
Did?
That's what I saw.
Boy, it was early this morning. It says.
Judge is writing Jerry instructions this
Counts
morning.
1 through 5. Oh, no, that's not it. You're right.
Nice. And I like the way he did it, just very respectfully, where he said, I did. He said, that's the way I read it. Instead of saying yes, or something more demanding.
Yeah.
That was smart.
Self-instruction as, same self-defense instruction as count.
Also, nice spot by the defense lawyer, to
Doing their job, at least.
Doing their job.
That's good news.
we'll give credit.
1, 3, and 4.
Very good. I just wanted to make
Yeah,
sure that.
you were correct in your observation.
Well, you tell me when you're ready, Judge.
I think he's cutting and pasting as we speak.
Yep.
Okay, what else?
One last issue, and that's the court has included, as it relates to, I think it's count 3, Mr. McGinnis. Count two. I'm sorry. 820. Jury instruction 820
Yeah.
is mentioned in there. So I guess the language in there that I'm having, maybe it's just me, difficulty kind of coming to some type of congruence with is the first full paragraph, the last sentence says the defendant does not have a privilege of self-defense as to Richie McGinnis. I don't know if you see that. However, later on in the instruction, it says if the defendant was acting in lawful self-defense, his conduct does not create an unreasonable risk to another. So I guess the
Confusing.
concern I have is one portion says he doesn't have a privilege of self-defense. Then another portion of that same instruction says he does have the privilege.
I stumbled over the same language.
Yeah.
And what I ultimately decided was intended, and I think I might add correctly, intended by the instructions committee was that he does not have a privilege of self-defense as to the third person, but the fact that he was, if he was, in exercise of his privilege of self-defense is a factor for the
Why doesn't he have a privilege of self-defense?
determining
Because it's reckless
whether his
endangerment.
conduct was criminally reckless, and also was a factor for them to consider in determining whether it
I
was
guess.
done with utter disregard for human life.
But the problem is the self-defense would
I
flow because
certainly don't
intent
think
follows
about
the
it.
bullet, right?
Should.
I would
So therefore, the privilege of self-defense should flow.
put a law school test together on this,
Yeah. But
that's how I
the
read it.
jury
Now tell me,
instruction
where you think
suggests
I'm
that you
there.
don't have the
Well,
privilege of
I'm not saying you're in
self-defense in
error.
a
I'm
reckless
saying that
endangerment
I think
shooting,
if he's in self-defense as it relates to Mr. Rosenbaum,
generally.
according
I
to
guess strictly speaking, that must be
According to
true
820,
because if
he
it's
then
reckless,
has
strictly
a
speaking, it's
public
not intentional.
self-defense.
So you can't be.
If the
You
defendant
can't
was
have a
in
reckless
self-defense,
self-defense. So I guess that must strictly
conduct
speaking
did
be
not
correct.
create an unreasonable risk to another.
Although that's confusing
Well,
as shit.
Let's give a situation where I'm out on the street and somebody confronts me, and there's a family of 4 little children right behind him, and the other person, the other actor, puts me in, I'm in fear of death from the assault by this individual. So I whip out a gun and I open fire, and I include in the zone. The danger zone is not only the actor with whom I have a perfect self-defense, privilege of self-defense, but also the 4 children who are behind him.
No, this is a bad
And
read on this. In
I
my
think
opinion.
this is how I reconciled that reading in my mind, was that when the jury decides about the charges involving the 4 children, the jury is to consider whether I was acting in self-defense with respect to the bad actor. That's a consideration in determining whether my conduct was reckless with respect to those children, and also whether it was showed utter disregard for human life. And the jury might reconcile that by saying, well, you should have tried to change positions so that your shot would have the children in the background.
That is an
That's how I
insane
reconcile it.
read.
But I
of self-defense law.
I agree. That's an insane read of self-defense law.
I read 820 to say that if the bad actor in your situation, if you were acting in self-defense, the instruction says that you did not then create an unreasonable risk to another. It's what it says.
I don't even understand. That doesn't make sense.
Then,
well, why did they? I'm sorry. Go ahead.
no. So I guess what I'm saying is I don't think if it's self-defense on the bad actor in your scenario, then by
Kyle,
that
stop
fact,
yawning.
according to 820, the instruction says your conduct did not create an unreasonable risk to another. So if we're talking about the children behind that bad actor, the statute says, or the instruction says, then if it's self-defense, it did not create an unreasonable risk. And
Right.
then period.
Right.
So
Correct.
Why does it say up above that the in the second sentence, the fact that the law may allow the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful.
I agree. That's what I said.
What you're telling me is that the fact that the law may allow the defendant, the fact that the law may allow Schrader to use force in self-defense as to the bad actor does not necessarily mean that recklessly endangering the safety of the children was lawful. Why isn't you're telling
It does
me
necessarly mean, as I, yeah, that's what he's saying. It does necessarily mean that.
the children.
Only if, according to 820, only if the conduct against the bad actor was self-defense.
Yeah. Right.
That's the part I've read to the court. If the defendant was acting in lawful self-defense, his or her conduct did not create an unreasonable risk to another.
Yeah, of
Correct.
course it can.
Period.
Right. He's right. This is like pretty basic self-defense theory too, which is confusing me. When the judge finally gets stopped talking, we'll talk about this more because it's weird.
Yeah. Well, we can briefly address what they're trying to reconcile is this conflicting jury instruction that says you cannot have self-defense in a reckless endangerment charge. You don't have the privilege of it, which I think if the charge is standing alone, that makes sense.
Right.
Because if they're recklessly endangered, you're not acting in self-defense, because if you're acting in self-defense, your actions aren't reckless.
Yes. Right.
In the scenario where you are acting in self-defense, firing a bullet at someone who is an aggressor, the people around them could, in theory, be endangered. And the self-defense should flow into that reckless endangerment because, again, you're not recklessly endangering person B because you're lawfully shooting person A.
Right.
That doesn't make a lot of sense if you're justified in shooting one person.
I'm a little bit surprised he didn't actually use the phrase "intent follows the bullet" as part of his argument, because this is intent follows the bullet.
Right.
I have murderous intent with respect to person A. I shoot at person A. I actually hit person B. Person B dies. I'm guilty of murder. Self-intent follows the bullet.
Right.
But it works the other way around. I have a valid self-defense claim.
Instructions Committee. On page, well, I don't know if you've got the pages there, but well, I have them, but near the end it says,
Yeah, so self-defense works the same way. I have self-defense with
for
respect to
example,
person
assume
A.
that a defendant is charged with causing reckless injury to the victim and raises the defense that he was acting in self-defense against someone else and thereby injured the victim. Criminal recklessness requires that the defendant's conduct created, quote, an unreasonable and substantial risk of death or great bodily harm, unquote. In considering whether the risk was unreasonable, the jury should consider the evidence that the defendant was acting in self-defense. So that's what I'm thinking is that what they mean is there is not what you're arguing, I think, becomes a perfect self-defense as to injury to others
Right.
during the
Correct.
exercise of perfect self-defense. And I
Correct.
don't think that's the law.
I think it is.
Maybe it was what we once thought, but I don't think it's the law now. And that the jury, when they approach the McGinnis case, looks at whether
The law changed somewhere along the way?
and
Just so the
if-
chat
even
knows,
if exercising
jury is not in the courtroom
perfect
right now.
self-defense with respect to Mr. Rosenbaum, that he doesn't have a self-defense as to Mr. McGinnis's endangerment, but instead the jury is told you consider, because, and I'm interrupting myself, because one of the things we tell the jury, and you've referred to it several times right here in our discussions in the last couple of weeks, one of the things the jury considers is what the defendant was doing, why he was doing it, how dangerous was the conduct. When they weigh those things with respect to the count involving Mr. McGinnis, they consider, if they decide that it was perfect defense, self-defense as to Mr. Rosenbaum, then they consider that in deciding what the defendant was doing, why he was doing it, how dangerous was the conduct, and then they make their determination whether the fact that Mr. Rittenhouse was,
Nate the lawyer has it right.
if they find that he was acting
Yeah.
in self-defense, they can weigh that in deciding whether or not he recklessly endangered the safety of Mr. McGinnis. That's how I read it.
But it's a confusing jury
Say
instruction
it.
to
It's
say
a very
you-
confusing jury instruction.
you don't get
Now,
self-defense,
but
but
I am
if you
going
get
to-
if you
I'm
did
gonna
self-defense,
try
to-
then the
Yeah,
jury
yeah, yeah.
considers
Put around
self-defense.
those
Yeah.
5th and 7th counts because we don't have an instruction for number 7 and
I'm also going to pick apart the judge's
Yeah.
hypothetical when I have a chance.
number 6 is. I've had lots of statutory issues come up over the years, and this is the naughtiest.
Is it though?
Okay. Other than that, any problem with the instructions?
Nothing, nothing else from me.
Histari,
State?
we'll try and
No.
clear it up in a second.
Okay. Let's get the jury down.
Okay, you want to
Okay.
quickly?
Go ahead.
No, I was going to say you want to hit that hypo.
Yeah, so I wanted to complete my previous thought since I kept getting interrupted by the judge.
Yeah, I guess.
If you have self-defense against person A
At the end
and you
of
fire person A and hit
last
person
text,
B, it's still self-defense because intent follows the bullet. So intent follows the bullet works both ways. So now let's pick apart the judge's hypothetical. In the judge's hypothetical, the way he described it is there is a person who is in fact posing an imminent threat of death or grievous bodily harm to me, right? But also there are 4 children behind him, or family that has 4 children, or whatever, right? So that's the premise. and he says, okay, so I have a right of self-defense against this guy. I have a perfect right of self-defense against this guy. Fine. But I might also simultaneously be reckless to the 4 children. Then he goes on, why? Well, maybe I should have moved and fought and shot from a different position. But wait a second. I have an imminent threat of death or grievous bodily harm. Where do I get the time to move to a different position from? The entire premise of I have an ongoing or imminent threat, but also I should move to a different position. Where's the time?
Any question or observation?
Yeah, it's a weird one. What just happened was the audio video guy
would have any
last
impact on
night
her
or this
ability to
morning
serve?
passed by a
I don't-
juror.
You
So
could ask
Binger
if you
is
could ask
informing the
me
court
to
of this.
ask her if you want me to, but I'll probably tell you no. Well, might as well be honest. It doesn't sound like anything, unless you have question about the accuracy of the report to me. I think it's a non-issue.
What, they just happened to walk by each other on the street or something?
No, when he was coming in to set up the
to go
camera and audio
But-
equipment
Okay, anything else? And I did get a note.
in the courtroom.
Do you know from whom?
I
this
guess it
came?
must have been yesterday, last night.
Well, I don't know which
And
one.
what did they do? Say good morning or something like that, and we're having a fight over it?
Did she didn't put a juror number on there?
I think the
Yeah,
risk
yeah.
is
And
that
then I like what Batman says too. Yeah, maybe I should have moved. Also because, well, we were establishing it from the judge's hypothetical. Like in this hypothetical where I'm on the street, it doesn't make sense. It even makes even less sense for Kyle Rittenhouse because, as you point out, he was on the street. It's like, oh, I should have fired from a different position as I was, on my back.
there's another subtle aspect of what happened. The judge read the comment, and it's probably from the same statute, but the comment was over a reckless injury, not reckless endangerment. So in his hypothetical that encompassed the comment from the jury instructions guide, it's talking about recklessly injuring one of the children, which would change the calculus from, well, he shot and put one bullet in the aggressor and the children were endangered because a bullet came their way, versus he shot and struck one of the children. So let's say hypothetically, you use your self-defense claim by firing an automatic burst, right? Burst fire from an automatic weapon, and you fire off 6
Only
or 7
suppress
rounds.
the sound while I hold it down, or does it click on and off?
What?
Press-
We're confused about microphones now?
And then if I put, and now I'm live again, right? Okay, I've got the nice hand signals here from the respectful hand signals from the court TV crowd.
I got some hand signals. No, that's a bit unfair. That's a bit unfair.
So that
But I do love what Nate was saying earlier, where he's screaming into the void in caps. Go back to read it, or see if I can find it where I can quote him. But he says, from several points ago, he says, "Perfect self-defense cannot be reckless. That's a legal impossibility. If it was reckless, it's not perfect," in all caps, self-defense because he was reckless. Yes, Nate, we're with you, and I'm enjoying watching you scream into the void as you try to reconcile the word perfect with the word reckless, and like me, have basically your brain stops working because it's a mutual conflict. It's one of those things where you tell the robot, "I am lying. I must be believed, and I am lying." The robot blows up because it can't deal with a logical paradox. Yeah, perfect and reckless have a problem in the same sentence. You are correct, sir. Perfect recklessness. Yes, exactly. That's where we're at. Perfect recklessness, or reckless perfection, or something.
Yeah, the entire that's the interesting thing is Kyle's claim is one of relatively perfect self-defense. No bystanders were struck. The closest that we have is McInnes suggesting he was briefly afraid that he thought he had been hit by a bullet, and we don't know if that was like a piece of concrete or something hitting his leg, or if it was just psychosomatic reaction to hearing gunshots at close proximity. Who knows? He thought he had been struck, but he was not struck in any way. He was not injured. So I'm not sure how we get to the judge's hypothetical.
Okay, well, I guess too, but
But it is a pew, pew, pew. But it is a very concerning or confusing jury instruction to say you
let's
don't
ask
get
the lawyers to
self-defense,
come
but
up,
if you
please.
did self-defense, then then the jury can consider it. I think it's covering the idea that you're like, someone in the chat says, or good logic in the chat says, you can't self-defense with a nuclear missile, right? So, okay, yeah. So if you have a howitzer or something and you self-defense someone and it blows through them and into the next county, I guess you're recklessly endangering the people behind the target.
I haven't really considered the self-defense implications of the perfect self-defense, but with a howitzer. So yeah, I haven't. You might have a point there somewhere, but let's, I don't know. I don't know how perfect self-defense works with a howitzer.
I have no idea. This is the issue, and this is why arguing over these jury instructions is really important and getting clarity to the jury, because we're confused by this. We're lawyers. The judge is confused by this. He's not only a lawyer, but a judge.
The fact the judge is confused, or the fact that the judge seems to implicitly acknowledge the wording is difficult to parse, because he just called it like the naughtiest legal issue he's had, and he's going to give this to a jury.
Yeah.
With these instructions.
It bothers me that Binger is by far the tallest Geiga Chad in the room because he's such an effete idiot. He's like a foot taller than everybody else in that frame. Oh, man.
okay.
Oh.
So make a copy of both sides and then pick it back up, please. All right.
When are we going to bring this jury in, Judge?
That to happen.
The jury's sitting back there like, what the hell's going on, right? We showed up like an hour and a half ago or something, probably. What time did they have to show up? Was it 9 or 8:30?
You can give it to her when she comes.
The jury.
All right.
I have no idea. They should be they should be here.
Who are we calling now?
He's calling the jury form or the bailiff or whatever to bring the jury in, I think.
Hello.
Would you come down, please?
You got it.
Or the
Thank
jury
you.
foreman.
We need the door open. I don't know if somebody's standing over there or not.
Would you come down? I don't know if that means bring the jury with you. Okay.
Well, actually, I read the commentary, and the instruction guide says if the judge says, "Would you come down?" The jury is free to interpret that reasonably as singular or plural. They're not privileged to interpret it as plural, but under the circumstances, they can read it as plural.
Are you serious? Is this an instruction?
No, I'm making fun of the last instruction.
I was just confused for a second. Is this a real thing? Are you? Yeah.
Here we go. Let me hit a couple super chats here. Padria says, just put it in rice and the magical Asians will come and fix it. Oh my God. He's talking about your tech issues. Silent Vash 27 says, wonder if we will have more crying jury members. Very possible, but we probably won't hear the jury ever again until they're rendering a verdict. Mean Sarton says, I've had cases where the alternate jurors aren't known until the end of the case. Maybe that's how he'll do it. Could be. Peter Bemis says, they said WOU is alternate and WOU is alternate will be determined post-closing arguments. Oh, who is alternate will be determined post-closing arguments.
Chair, please.
So they're going to bring in all 20. 8 of them will be alternate, but they won't know. It'll be mystery round. So that's weird.
Now, we say alternate, but unless I misunderstood, all the alternates will be dismissed once the jury goes back. So there are no alternates if someone has to be removed during deliberations, if I understood correctly.
Yeah, the alternates will be sitting in the jury room or sitting in the courtroom, and then once the closing arguments are done, they'll
Give
inform the alternates who they are, I guess.
Each side.
And then apparently go home, which seems odd. It seems odd that you wouldn't keep some in reserve in case you need to substitute out a juror. It happens.
On the ones you've got there.
Gen X Medic says self-defense with a howitzer would depend on if it's high explosive rounds or a
Give
canister
each
shot.
side, you can hunt it down, the photocopy with my response.
Europa Chronicles says, FFS, Schrader has been chewing on the illegal gun issue for several weeks. If he still doesn't know if it applies, he needs to dismiss it. Well, he said that they
You can be
filed
seated.
the brief
Good morning,
for
everyone.
reconsideration, but he didn't see
and,
it for whatever reason.
The gentleman with the scooter.
So that's
Okay,
why he
then
hasn't
we
ruled
have
on
to
it
swear
yet.
the jury. All right.
Silent Vash says prosecution forgot to remove the hanger from his coat. That guy was sitting so weird. President-elect Austin M. says dismissing the possession charge mid-trial kneecaps the prosecution. What do you think? So one of the arguments from the prosecution was how do we do this with the curfew charge, since it's a 6-person jury, since it's a civil charge is the issue.
Yeah, I don't know the law obviously well enough, but
I think they have to sever it.
why wouldn't a 12-person jury be sufficient for a 6-person
I
thing?
think year after next.
Don't
Seems
know, I think
odd.
defense should have said,
And, then the
I agree, Your
chair
Honor.
is
We should
original
sever this
equipment,
charge and it should be
some
tried
furniture here.
separately. Just get the
Can you,
curfew
move
issue
that,
out of the case entirely.
Which is the most comfortable location?
Yeah, maybe they missed a trick on that one.
Would it be comfortable down there? Right there in front of the officer there?
Seraph Creed says,
Well,
judge
let's move the
arguing
chair.
Kyle placed the
Yeah,
kids,
well,
then
that might-
shot.
I wonder what these, like,
Everything
papers
from there,
behind
that's
them
not
are.
really concerned. Okay, yeah.
Behind the
'Cause
judge?
the bottom one, yeah, the bottom one looks like it might be a book, but some of those top ones look like they might be in some sort of plastic wrap.
All right, great.
Either plastic wrap or,
I'll talk more about the building later.
yeah.
And
So I'm curious what that might be.
When there's a break, we're going to.
Maybe it's forms of some kind that haven't been opened yet.
Yeah.
Could be. Did I hear something about a sandwich? Gosh, I'm hungry. Means Arton says he's scared to change the jury instruction. Not the first judge to be reluctant to mess with approved instructions. Yeah, well,
Yeah.
those are issues that can be overturned on appeal. If you,
You know,
if you get it
fair
wrong.
enough. You know, jury instructions, particularly at this point, are kind of tried and true. They've gone through vetting processes, through many, many appeals previous. So judges are, I think, rightfully
Good morning,
reluctant to
everyone,
mess with
and
them.
I'm glad I told you not to come in until 9:45. I did tell you that, didn't I?
No.
All right, no, we were
Wow,
doing
he just made a joke about the jury. He's like,
And,
he's just to the jury. I'm glad I told you not to come till 9:45. I did tell you that.
that happens periodically throughout the trial.
And the juries think to themselves,
And
please kill me.
it's, nothing
Well, that is the Milwaukee
expected.
Brewers
Usually
Kleenex
ends up
box
saving
behind
some
him.
time, some of your valuable time, and so we hope we. Oh, I see how it's laid out. Okay.
This woman is the clerk,
We're-
or she's the
we'll
judge's
have much
assistant.
more of that today. Would you? We're going to swear you now, your
Yeah.
oath, to reach a fair and just verdict. So, if you would please,
Can I
Mrs.
ask all
Lehman.
the jurors to raise their hand, please, to take the second oath? Do you and each of you swear that you'll well and truly try the issue joined between the state of Wisconsin plaintiff and Kyle Rittenhouse defendant, and unless discharged by the court, a true verdict give according to the evidence given in court to help you God?
And please silence those phones if you would. If you've got
The jury's allowed to bring phones into the room?
What?
an audible signal. And before the trial begins,
The jury's allowed to bring phones in?
I hope will help you better.
Is that what's going on?
understand as jurors and how you should conduct
Do
yourself.
they get to take that into the deliberation room? Holy shit, dude.
To decide the case solely as the evidence develops, presented at the trial, and the law is given
My
to
brain
you
is
in my instructions.
Not working after that.
Anything that you see.
No, because that implies a whole host of problems.
Do not let any personal feelings about race, religion, national origin, sex, age, or politics affect your consideration of the evidence. Do not begin your deliberations and discussion of
just
the
saying
case until
generally
all
to
of
the
the evidence
courtroom.
has been presented
But I don't
and
think
I have
so.
instructed you regarding our law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. There are times when I need to discuss legal matters with the attorneys that do not necessarily concern you, or in some cases, it's something needs to be discussed outside your presence, and you'll be excused at that time. Usually, if it's going to be short, I'll just put you into the conference room back here, it might be a little bit tight, but I think you'll be okay. And otherwise, we may take a break, and you'll be up in your jury room. When you're in the jury room, you need to stay there. You can't be wandering the hallways. You can't be coming and going, except when you have permission from the bailiffs. And you do have, if you have permission from the bailiffs, you may go to the break room across the hall here, where they've got some vending machines. And
put the vending machines in the jury room, man. That'd be good.
Or smoke if that's
pop the top of that Coca-Cola, see if it tells you guilty or not guilty.
So you need to go as a group, and they know the procedure, and then go back directly to the jury room and remain in the jury room until you're dismissed for the day. Do not research any information that you personally think might be helpful to you in understanding the issues which are presented. Do not investigate this case on your own or visit the scene. Do not read any newspaper reports or listen to any news reports on radio or television about the trial.
Or on your phone
Do
in
not
the
consult
court.
dictionaries, computers, websites, or other
Is
references
it okay if I live tweet this?
for additional
Live tweet my
information.
thoughts as it goes
Do
in
not
real
seek
time. That'd be
information
helpful for my
regarding the public
mental
record
recollection
of
later.
anyone involved
Go
in
for
this
it.
case. Any
No,
information
I meant the jury.
outside the courtroom would be misleading, inaccurate, or incomplete.
No.
Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experiences as jurors while you are serving on the jury. Do not use a computer, cell phone, or other electronic device with communication capabilities to share any information about the case. For example, do not communicate by blog, email, text message, Twitter, or any other way on or off the computer. Do not permit anyone to communicate with you, and if anyone does so, despite your telling them not to, you should report that to me. It will be tempting when you go home in the evening to discuss this with members of your household, but you must not do so. This case must be decided by you jurors based on the evidence presented in the courtroom. People who are not serving on the jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case.
We're going to hear the evidence.
The trial
though.
has been completed. You are free to communicate with anyone in any manner. These rules are intended to ensure that you remain impartial throughout the trial. If any of you has reason to believe that another juror has violated these rules, you should report that to me. You are to decide this case solely
Don't be no snitch.
on the evidence offered and received at this trial. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of the party who calls the witness. Second, any exhibits which are received, whether or
Cheers,
not
chat.
they accompany you
1,000
to the
likes.
jury room. Third, any facts which the lawyers have agreed or stipulated, or which I direct you to find. Attorneys for each side have the right and the duty to object to what they feel are improper questions asked of witnesses, and to the receipt of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection is made.
I'm looking at his pencil
allowing,
holder now. What is this like
Testimony or
red
other evidence to be received
devil
over
thing he's
objection.
got on a
I am
pen or
not
something?
indicating any opinion about the value of that evidence.
No idea.
You jurors are the sole judges of the believability of the witnesses and of the weight of the evidence. You are not required to take notes during the giving of evidence in this case, but you are welcome to do so if you wish. If you do decide to take notes, please take care that it does not distract you from carefully listening to and observing the witnesses. You may use your notes during your deliberations to refresh your recollections. Otherwise, you should keep them confidential. The bailiffs will supply you with the materials. You may
Another judge
rely
lets you take
upon-
notes. That's cool.
Excuse me. After the trial, your notes
Yeah,
will
in
be
a
does seem to
collected.
be a
case
bit
like
of a
this,
trend.
you gotta
Yeah.
take notes.
You will not have a copy of the written transcript of the trial testimony
I
available
wouldn't.
for use during your
But they do.
deliberations. You should therefore pay careful attention to all of the testimony because you must rely primarily upon your memory of the
I'm
evidence
curious.
and the
Just
testimony introduced
on
in the trial.
a policy level, why they don't
Your duty
provide
is
a
to
transcript
scrutinize and to weigh the
to
testimony
the jury.
of the witnesses.
I mean, wouldn't that be
and
helpful?
determine the effect of the evidence as a
Yeah.
whole. You are the sole judges of the credibility, that is, the believability of the witnesses,
It's like, why go off our recollection when we can just literally read the words on the page?
in determining the credibility of each witness.
I
and
don't
the
know.
weight
Maybe
you
they
give
don't
the
want to taint the
testimony of each. You
impression
should
with an
consider these
objective,
factors.
cold read later.
Whether the witness has
Maybe.
interest or is disinterested in the outcome of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had to observe and to know the matters and things about which testimony is given, the reasonableness of the testimony, the witness's apparent intelligence, bias or prejudice, if any is shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the witness's testimony, and then give the testimony of each witness the weight you believe it is entitled to receive. There is no magical
I
way
give it
for
the
you to
weight
evaluate
of
the
that
testimony.
prosecutor.
Instead, you should use your common sense and your experiences in life. In your everyday lives, you determine for yourselves the reliability of statements which are made to you by others, and you should do the same thing here. The first count of the information in this case charges that on
Okay.
the
On to the count. Look at this stack of papers the judge is sifting through.
25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of Joseph D. Rosenbaum under circumstances which show utter disregard for human life.
That's going to be a hard
First-degree
one.
reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of this crime, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death.
Substantial factor,
Second,
back
that
to like the
defendant
Floyd
caused the
discussion,
death
right?
by criminally reckless conduct. Criminally reckless conduct means that the conduct created a risk of death or great bodily harm, which was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances of the defendant.
Third element, buddy.
You lose your place on the page.
The third element is that the third circumstances of the defendant's conduct show utter disregard for human life. In determining whether the defendant's
now
conduct
literally
showed
marking
utter
it when he reads
disregard
it.
for human
I mean,
life,
that could work.
consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. The second and third counts of the information, respectively, charge that at the same time and place, the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. And the third count charges an identical crime involving an unknown male. And to each of these charges as well.
How is he still unknown at this point,
Guilty.
right?
Reckless endangerment of the first degree as charged in these counts is committed by
That's
one who
like just
recklessly
conceptually a little bit
endangers the
weird. It's like
safety
we
of
can't even
another
identify
being
who
under
the purported
circumstances which show
person who was
utter
acted against
disregard
is, for
human life.
sure.
Before you may find the defendant guilty
Criminal
of
violation against John
endangerment of the
Doe.
first degree as to either of these counts, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being. Second, that he endangered the safety of another by criminally reckless conduct. Again, criminally reckless conduct means that the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm.
That's a weird one because
And great bodily harm means injury which creates a substantial
not
risk of
privileged
death.
to self-defense
which
there, but that
causes
guy just kicked him in the
permanent
face.
serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily injury. And the third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct show utter disregard for human life, you should consider what he was doing, why he was engaged in that conduct, the danger of the conduct, how obvious was the danger, whether the conduct showed any regard for life, and all other circumstances relating to the conduct. The fourth count of the information charges that at the same time and place, the defendant intentionally caused the death of Anthony M. Huber with intent to kill him. First-degree reckless homicide, as defined in the criminal code, is committed by one who causes the death of another human being with intent to kill that person or another. Before the defendant may be found guilty of intentional homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements of this crime were present. First, that the defendant caused the death of another, and cause means that the defendant's act was a substantial factor in producing the death. And second, that the defendant acted with intent to kill another human being. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the act is committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may have been formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the act. You cannot look into a person's mind to determine intent, which must be found, if it is to be found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be Intent should not be confused with motive. While proof of motive is necessary to a conviction, while proof of intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The fifth count of the information charges at the same time and place at the city of Kenosha in this county. The defendant attempted to cause the death of Gage P. Grosskreutz with intent to kill that person. This is a charge of attempted intentional homicide of the first degree. The crime of attempted intentional homicide of the first degree, as defined in the criminal code, is committed by one who, with the intent to commit first degree intentional homicide, does acts towards the commission of that crime which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have committed that crime except for the intervention of some other person or some other extraneous factor. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements of this crime were present. First, that the defendant intended to kill another human being. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another. Second, that the defendant did acts towards the commission of the crime of intentional homicide of the first degree, which demonstrate unequivocally, under all of the circumstances, that he intended to kill and would have killed another, except for the intervention of another person or some other extraneous factor. Unequivocally means that
he missed.
Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone other than the defendant and may include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the act is committed. The act need not have been brooded over, considered, or reflected upon for a week, and a day, an hour, or even for a minute. There need not have been any appreciable time between the
Schrader's
formation
gonna
of the
get
intent
COVID.
and
Doc, get a
intent
cough
to-
drop or
may
something,
have been
man.
formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the act. Again, you cannot look into a person's mind to determine intent, which must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case, which bear upon intent. Intent should not be confused with motive. While proof of intent is necessary to conviction, proof of motive is not.
Intent
Motive
versus
refers to
motive
person,
will trip some lawyers
reason
up,
for
man.
doing something, and while motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to obtain a conviction. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The sixth count
I like
charges
what
that
Nate
at
the
the
lawyer
same
said
time and
about
place, the
Gage
defendant
Graskowitz. He's a
was a
UNICEF
person
now.
under the age of 18 years
No more biceps for him.
and was armed with a dangerous weapon. The seventh count charges that
I didn't think he was going to read that.
at the same time and place, the defendant intentionally failed to comply with an order issued by an agent of the state or of a local government unit which was engaged in emergency management activities under Chapter 323 of the statutes. The defendant has also pleaded not guilty with respect to each of those charges. I'm going to give you a more complete instruction about those offenses which are alleged at the close of the trial. Basically, the sixth count deals with the circumstances under which it is lawful for a person who is under the age of 18 to have a firearm in his possession. And the seventh count deals with special circumstances in which emergency management edicts are issued and the requirements which are imposed for obedience to those edicts.
The denialist says step 1, buy a howitzer. 2, name it perfect
The first
self-defense.
5
3,
counts of the
fire in random
information allege not
directions.
only that
4,
the defendant committed the crimes
profit?
which are charged in those counts, but also that he did so while using a dangerous weapon. If you find the defendant guilty on any of those counts, then you must answer the following question. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder. Before you can answer the question yes, if you are called
So,
upon to ask it, answer it,
air-based guns
then
are
you
not
must be
firearms, I
satisfied
guess.
beyond a
So,
reasonable
yeah.
doubt that the defendant committed the crime while using a
or
dangerous
rail
weapon.
guns.
Self-defense is an issue in this case, and the law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with his own person, and that he believed that the amount of force that the defendant and that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm, only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the standpoint, and not from the viewpoint of the jury now. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. That is with respect to counts 1, 3, 4, and 5. So those are the charges of reckless endangerment, reckless homicide, and intentional homicide, and attempted intentional homicide. A separate instruction applies to, I'm sorry, I misstated that. The reckless, the instruction I just gave you on self-defense applies to the first count of reckless homicide involving Joseph Rosenbaum, the third count involving the unknown male, the fourth count involving Anthony Huber, which is a charge of intentional homicide, and the fifth count, which is attempt to commit intentional homicide involving Gage Grosskreutz. There is a different rule applicable to the charge involving Richard McGinnis, the second count. And that is that there may be evidence in the case that the defendant was acting in self-defense as to Joseph Rosenbaum. The fact that the law may allow the defendant to have used force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in determining whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life. But the defendant does not enjoy the privilege of self-defense as to Richard McGinnis, because Richard McGinnis was not any way
such a confusing jury instruction. Terribly,
the law of
terribly
self-defense
conceived.
allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with his own person, and that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. A defendant may intentionally use force which is likely intended or likely to kill or cause great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. So that self-defense would be applicable to the defendant with respect to Mr. Rosenbaum, if you find that it's sustained by the evidence. But that doesn't follow through with respect to Mr. McGinnis, who is in the area of the gunfire.
Doesn't automatically follow through. Come on. Oh, my God.
So you have to analyze that separately and determine, well, I'll get further into it. Keep in mind that a belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances then existing. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. You should consider the evidence relating to self-defense along with all of the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm as to Richard McGinnis.
Christ.
If the defendant was acting lawfully in self-defense with respect to Mr. Rosenbaum, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the risk was unreasonable. You should consider the evidence relating to self-defense as to Mr. Rosenbaum in deciding whether the circumstances of the defendant's conduct with regard to Mr. McGinnis showed utter disregard for human life.
Guarantee no juror has
on the
followed
state
this.
to prove beyond a reasonable doubt that the defendant
I'm not sure I'm following it.
in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this
In
case
fact, I know I'm
The
not.
circumstances of the defendant's conduct showed utter disregard for human life. In reaching your verdict, examine the evidence with the utmost care and caution.
Everybody blaming
Act
the
with
judge for
judgment,
this.
reason, and
Chill out a
prudence.
minute.
The
Like,
defendant is
these
not
are
required
the
to
jury
prove his
instructions from
innocence.
Wisconsin.
The law
The
presumes every
instruction
person
itself
charged
is
with the
bad.
commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving
It's
the
one of the
defendant
better definitions of reasonable doubt I've heard.
every
So
reasonable doubt. We're going to hear the opening statements of the lawyers now. And we follow the procedure where the state speaks first. You know, sometimes you see these actress judges on TV, and they just destroy my enjoyment of the program when they tell the lawyers we're going to have the opening argument now. And I think, well, the only argument you're going to have is with me, because there's no such thing as an opening argument. It's opening statement.
this is technically
The
correct.
argument is for the end, and that's when they're going to make their pleas to you to return
And
verdicts
opening
in
statements
accordance
are
with
mildly
their beliefs.
argumentative.
At this
Persuasive,
point, they're
maybe
going
we
to
should
briefly
say.
acquaint you with what they think the evidence is going to show, give you an overview, alert you to the things they especially want you to watch for in the evidence. And they can be very useful to you for those purposes. And they're brief. Then we can write into the evidence right after that. Mr. Binger, I think, is going to address you first on behalf of the state. And then Mr. Richards will
Can
have
I ask you a question?
to make an opening statement now. Or
So-
first, he is entitled
So given that jury instruction with respect to count 2 for this reckless endangerment,
and
so you and I both know that we have to
with
apply
that,
the law as it's been
again,
given to
no,
us,
well, you haven't-
regardless of what we think about the law personally. So
because this is,
given the law as it was just described to us in count 2, and given the evidence we currently understand,
Binger, you may
guilty or not guilty, because I don't know anymore.
Good morning, ladies and gentlemen.
Depends on the juror's feelings, apparently.
I was asking
The
you,
evidence
what do
in
you
this case
think?
will show
I think
You-
not.
I mean-
Still.
August 25th,
Okay.
2020,
I want to hear this guy. I
here
want to
in
hear
our
this dummy.
community of
Fair enough.
commission. The defendant, Kyle Rittenhouse, who was 17 years old at the time, had armed himself with an AR-15 style semi-automatic rifle loaded with 30 rounds in the magazine.
Magazine clip.
And using that rifle, he shot and killed Joseph Rosenbaum, an unarmed man. The shot that killed Mr. Rosenbaum was a shot to the back. This occurred after the defendant chased down Mr. Rosenbaum and confronted him while wielding that AR-15.
Did it?
The evidence will
Chased
show that the
down and
defendant
confronted
fled
him.
the scene
How did he chase him
of the
down?
dead body of Joseph Rosenbaum,
Rosenbaum
without
chased
stopping to
Rittenhouse
offer
down.
any aid whatsoever. And as he's running, word spreads from the crowd on the street that there is an active shooter running through the area. And the citizens there attempt to stop him. They approach the defendant. One person hits him in the back of the head. One person takes a swing at him with a skateboard. That individual is Anthony Huber.
He hit him with a skateboard.
Eventually, the defendant
Didn't just
loses
take a
his
swing.
balance and falls to the ground. An individual who is the subject of count number 2, the unknown individual, runs in at that point and attempts to kick the defendant in the face.
No,
The
count
defendant's
number
on the ground.
3. You got
This
this
unknown
wrong.
individual is unarmed. The defendant, in response, points his AR-15 directly at this individual as this individual is literally flying over his body and discharges that gun twice. Luckily, that individual was not hit. But clearly, if he had been hit, the wound would have been severe and perhaps even fatal.
Flying over his body, he's kicking him in the
Immediately
face.
after that, Anthony Huber,
Defense will get to say all this.
who is holding a skateboard, comes in and reaches for the defendant's gun. He grabs hold of the gun and tries to pull it away from the defendant.
Well, thanks.
The
for
defendant
that.
is wearing his AR-15 strapped to his body. There is a nylon strap around his entire body, and the gun is slung from that. So it is essentially attached to him. Mr. Huber's efforts are unsuccessful because of that strap. And in that struggle, the gun winds up pointed directly at Mr. Huber's chest. The defendant pulls the trigger one time and discharges a round into Mr. Huber's chest, killing him instantly. A final individual by the name of Gage Grosskreutz has followed this chase on foot and has approached the defendant at this time. Mr. Grosskreutz is holding his cell phone that he'd been using to record the night's events for a live stream on Facebook in one hand, and a Glock semi-automatic pistol in the other hand. He runs up to the defendant. The defendant turns towards him with the AR-15. Mr. Grosskreutz raises his hand. The defendant then turns his rifle over, begins to examine it for a second. Mr. Grosskreutz takes this opportunity, and you will see in the
Was
photo
it for even a second?
Wait.
that he blades his body with his left hand, reaching towards the defendant. His right arm is pulled back. This is the one with the gun in his hand.
Well,
And as he's reaching for the defendant turns the AR-15 and discharges the 8th and final round into Mr. Grosskreutz's right arm. The arm
just
with the
made
gun.
2 self-defense cases right
Mr.
there.
Grosskreutz runs off, screaming for a medic. The
I
defendant
don't mind it though, because he's admitting to bad facts, so he's taking the
that
sting
night,
out, which is
He
good
killed
strategy.
2 unarmed people, shot at a third at very close range, and wounded Mr. Grosskreutz in the arm, who was armed with a gun.
And is now
It is the
disarmed.
state's position that this evidence demonstrates the criminal charges against the defendant is intentional homicide of Anthony Huber and his reckless conduct towards the other defendants. Now, what I've just given you is the snapshot, but there's a wider context here. As we all discussed yesterday, this occurs during the context of the events following the shooting of Jacob Blake, which occurred on Sunday night, August 23rd, 2020. And we all know that within a short period of time after that, the community erupted in protests, looting, rioting, arson, and violence. Sunday night and Monday night were 2 of the roughest nights that our community has ever seen. We are well aware of the damage that the uptown area along 22nd Avenue suffered. The probation and parole office on 60th Street, the furniture business there, Car Source, one of their locations on Sheridan, and other properties around town that were damaged.
I love it.
Fortunately, in the entire sequence of events, this was all property damage. And one of the things we all agreed on yesterday is life is more important than property.
Fair.
Up until Tuesday night,
Not always.
despite all of the things that the community had experienced, no one had been killed. But what happened as the time went on was that the people of Kenosha, who felt a sense of outrage, began to protest. But like moths to a flame, tourists from outside of our community were drawn to the chaos.
Oh, they're going
here
to
in
pull this
Kenosha.
one, huh?
I like it.
People from outside of Kenosha came in and contributed to that chaos. And it caused many of our citizens to fear for their safety, fear for their homes and their families, fear for their businesses, and take steps to protect themselves. whether it is to arm themselves, board up their windows, move, or take time away from the community. All of those reactions were entirely understandable and reasonable. And no one here is going to tell you otherwise. As long as those are what you're left doing, there's no issue. But out of the hundreds of people that came to Kenosha during that week, the hundreds of people that were out on the streets that week, the evidence will show that the only person who killed anyone was the defendant, Kyle Rittenhouse. The evidence will show that hundreds of people were out on the street experiencing chaos and violence, and the only person who killed anyone was the defendant, Kyle Rittenhouse. We will show you videos of some of the events that night, of police, tear gas, rubber bullets, and yet the only person who killed anyone was the defendant. There are fireworks going off, which is a loud noise, sounds like gunfire. There are guns being discharged, the sound of gunfire throughout our community that night. Hundreds of people are there experiencing this, and yet the only one who kills anyone is the defendant. We will show you video of hostile confrontation between literally hundreds of people on one side of the issue and on the other side of the issue. People getting up in each other's faces. And yet the only person who killed anyone.
Love it. I love the repetition.
He's making a
Hundreds
good
of people
opening statement.
No, I think
those
this
nights.
opening is
Experience the night of August
wonderful.
25th. Experience that chaos. Hundreds of people. And yet the only one who killed anyone is the defendant, Kyle Rittenhouse. Recently, I heard someone sort of tongue-in-cheek joke that jury service is bringing in folks from our community and paying them $8 a day to help solve a murder. We're not asking you to solve a mystery in this case. In most homicide cases, the elements that I need to prove might be a little challenging, but here, there's no doubt, there will be no dispute in this record that the defendant had that gun that night, shot 8 bullets, 4 of them hit Joseph Rosenbaum, 2 of them at an unknown individual, 1 into Anthony Huber's chest, and 1 into Gage Grosskreuz's arm.
Love it.
That will not be in dispute. The central issue in this case is going to be self-defense. And the judge has given you an instruction, which I want to highlight here, because there are some factors that I'd like you to keep in mind when you hear the evidence in this case. The defendant used deadly force. There is a privilege under our laws to use deadly force, but it's a very limited privilege. That privilege, according to the law, indicates that the defendant can only use deadly force if he reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself. In determining whether or not those beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not with the benefit of hindsight. You are essentially the people of ordinary intelligence and prudence who will apply that standard of reasonableness to the defendant's behavior and make a determination as to whether or not his use of deadly force was reasonable. Was it reasonable for the defendant to believe that the force was necessary to prevent imminent death or great bodily harm to himself? So let's talk about the context of that evening. And I'm going to try and go in a little bit of chronological order to set things up for you so you understand the evidence as it comes into this trial. The first witness you're going to hear from in this trial is a man by the name of Dominic Black. Dominic Black was, at the time of this incident, dating Mackenzie Rittenhouse, who is the defendant's sister. And through Mackenzie, Dominic Black got to know the defendant. And they spent a lot of time together in the months leading up to August 25th, 2020. In fact, On May 1st of 2020, Dominic Black bought the AR-15 for the defendant. That occurred up in Ladysmith, Wisconsin. Dominic Black used money that was given to him by the defendant to go to an Ace Hardware up in Ladysmith and buy the gun in Dominic Black's name. Now you might ask, why was it necessary for Dominic Black to do that? Why couldn't the defendant do that? Because the defendant was 17. And Dominic Black and the defendant knew that because the defendant is 17, he cannot purchase a gun. He cannot legally own a gun.
That's not true.
And
No,
so
no,
this
but
was
the
in
owning
fact
part,
a
that's,
straw
you know.
purchase on behalf of Dominic Black, on behalf of the defendant. After the gun is purchased in Ladysmith, Dominic Black and the defendant spent a little time up there at Dominic Black's family's hunting property. And they fired both that AR-15 and one that Dominic Black already had. And the two of them are practicing using their AR-15s at a shooting range that they have on that property. And Mr. Black will tell you some more about that. Then they agreed that that gun would not go home with the defendant to his home in Antioch, Illinois. It would stay here in Kenosha at the residence of Dominic Black's stepfather in a locked gun case. And in fact,
Seems
after
safe.
the two of them returned from Ladysmith in early May of 2020, the gun stayed at that residence here in Kenosha until the day of August 25th, 2020.
Cathurga says, listening to this POS
On
prosecutor's
the
sophistry
night
is
leading up to
pissing
August
me off.
25th, that Monday night, the defendant stayed over at Mr. Black's residence here in Kenosha. And the two of them decided on that next day, Tuesday, August 25th, that they would do something about what was going on in Kenosha. So at one point earlier in the day, they come down here. They work on cleaning up some graffiti on some buildings here downtown. Then they decide they want to come back later that night and protect the local business, a business called Car Source, which is located at 59th and Sheridan. Now, as I talked to you a little bit about yesterday, Car Source actually has three
Nice.
locations very close in this downtown area. One of them was on the east side of Sheridan Road at 58th and Sheridan.
East side.
And either on Sunday or Monday night, I think it was on Monday night, August 24th, that entire property was pretty much destroyed. There were multiple cars in the parking lot that were set fire and completely burned out. The building itself was damaged as well. Right across the street from there is another Car
magically
Source
happened.
location that also sold used cars. And some of those cars had been damaged on the night of Monday, August.
No, I like it though because
So,
he's getting in
on Tuesday, when
front
the defendant and Mr. Black are
of
out,
bad facts.
they encounter one of the owners of Car Source. And they talk to him about protecting their 59th Street location that night. And there's some discussion about that. In the afternoon, Mr. Black and the defendant go out to Jelinski's on Highway 31, Green Bay Road. And they acquire straps so that they can sling those guns around themselves when they come back to the downtown area that night. And
Don't wanna carry a gun
eventually
all
later
day.
that evening, they return. They meet up with some other folks that are interested in protecting Car Source. Originally, they start out at 63rd Street Car Source, which is the third and final Car Source location. But then they agree, we're going to go to the 59th Street, 59th and Sheridan location and protect that location to make sure no one damages the cars, no one damages the property. And I want to be clear, there's nothing wrong with that. Protecting that property is entirely lawful, totally understandable. And it's something that many people here in Kenosha did. And there's a group of people, including the defendant and Dominic Black, that take up positions at 59th Street. Some of them, like the defendant, are on the ground in the parking lot, where as people are walking by in the street, they're having interactions with
Can I
these
make a
people.
joke about roof Koreans?
Dominic Black will testify.
Sure.
He took up a position on the roof. He did that because he didn't want to be on the ground, close to where other folks were, close to where potential
Oh, they're gonna
issues might
suggest
arise.
it.
He wanted
Well,
to stay
Kyle
a little
should
bit
have
removed
chosen to
from
be
all
up on
that.
the roof.
Didn't want to
What,
get directly involved. in
Fired
it.
down into the crowd. I guess that would be good.
You will hear and see videos of sequence of events going on around Kenosha that night. The evening begins with large-scale protests, large-scale, no other way to put it, rioting that's occurring
Good for him.
right outside these windows, right in front of the courthouse here at Civic Center Park. There is a crowd of police that have lined up to protect this building, to protect the public safety building, which is right next door. And there
You
are
may
a
not like
large
what he's
number of
saying, but
protesters
he's
that
doing
are
a very good
agitating.
job.
They are
in
screaming at
opening
the
here.
police. They are throwing projectiles. Police are shooting rubber bullets, tear gas, etc. It is a very volatile situation at Civic Center Park. Now, that's at 56th and Sheridan, about 3 blocks north of the car source where the defendant was. But as the evening goes on, the police decide to move the line of protesters south on Sheridan. And eventually, they pass the car source at 59th and Sheridan. The police establish a line at 60th and Sheridan, 1 block south. Now, as that process is going on, many of these protesters pass by the defendant and the people that he's with at 59th Street. Words are exchanged. There is confrontation. There is a little bit of hostility. No one is hurt. No one fires a gun. No one is injured. But clearly there's antagonism. It is clear that this is a crowd that is not on the same side as the defendant, that does not see him as an ally, does not see him and his group as someone that they identify with. And as I said, there is a hostile exchange there for a while. In fact, at one point, members of the crowd pull one of the dumpsters from the property out into the street and attempt to start it on fire. And some of the other folks that are there with the defendant go out and put the fire out and have some very harsh interactions with those people in the street. I believe the evidence will show that it is this process that demonstrated for the defendant that this is a crowd that is not a safe crowd to be in. This is a crowd that does not view him as an ally. This is a crowd that if he ventures out into it, there could be problems.
That seems a little defense friendly,
Now,
unless he's going to
once
convert
the
it.
police pass by and the protesters are pushed down south of 60th, I believe the evidence will show that the car source that the defendant is stationed at is no longer in danger. There's no one there who's attempting to damage the property. There's no one there who's going to do anything to harm anyone there. The situation has moved on. Does the defendant stay there? Does he decide that he's done what he set out to do and it's time to go home? No. The evidence will show that the defendant, another individual in the group by the name of Ryan Balch, who you will hear from, decide to venture out into the crowd. They cross the police line at 60th and Sheridan, and they walk amongst this group of hostile protesters. At some point, they both wind up at a
Managed
gas
to
station
not shoot
on
anybody.
the southeast corner of 60th and Sheridan called Ultimate Gas. And you'll see some video of the scene there. It is a scene, again, of groups of people that are clashing with one another verbally. There's some shoving going on. And in the midst of this is Joseph Rosenbaum. And you will hear some testimony about Mr. Rosenbaum and his activities that night. Mr. Rosenbaum had been discharged from the hospital that very day and had come back to his home of Kenosha, had met up with his girlfriend, Carrie Ann Swart. He couldn't stay with her, so he left her and came downtown and got caught up in the midst of these protests.
Got caught
You will
up
see him
in the
on
midst.
videos. You will see photographs of him as he's walking around. He is carrying a plastic bag. Part of that plastic bag is clear and see-through. It has a string, white string, drawstring to it. It is the type of bag, I believe the evidence will show, that you get at the hospital when you're asked to put all of your personal possessions in a bag. Your shoes, your watch, your phone, your jewelry, etc. That's the type of bag it is. And I believe the evidence will show that he was carrying it around most of that evening. And at various points, the evidence will show that Mr. Rosenbaum is agitating. He is getting in people's faces. He is using obscenities. He is essentially daring people to respond. In fact, at Ultimate Gas, I believe the evidence will show that he actually gets right up in the face of armed people who are similarly armed as the defendant, who have similar AR-15 type rifles on. And he is literally confronting them in their faces.
Mm-hmm.
None of those folks shoot him. They push him away. He's 5'3", by the way, 150 pounds. They push him away.
He just made the manlet argument.
No one appears to take him is a serious danger. The defendant is at the ultimate gas station during part of this, so is Ryan Balch. I believe Mr. Balch will testify that there was an understanding that when we cross south of 60th, we stay together. We try not to intervene in anything. But if we get separated, head back to 59th Street, where our original group is. Mr. Balch does. The defendant attempts to. He comes up to the police line. They won't let him pass. He says, I work at that business, and points to 59th Street. And again, they won't let him directly through the line. Now, I believe the evidence will show that he could have easily gone a block in either direction if he really wanted to go back, but he turns away from the police line, returns to the ultimate gas station. And a few minutes later, we see him on the video of a man by the name of Corey Elijah, who will testify very shortly here in this trial. Mr. Corey Elijah was one of these people out on the streets who was Facebook live streaming the events of that night. And he catches the defendant passing right in front of him with a fire extinguisher. The gun still slung around his body, strapped to his body. And Corey Elijah will testify, this caught his attention. Where's he going with this fire extinguisher? And so Corey Elijah decides to follow with his video, recording the entire way. And we will show you that video. You will see that as Corey Elijah leaves the ultimate gas station at 60th and Sheridan and heads south, he passes by the defendant, who by this point is walking, holding a fire extinguisher in his hand, all by himself. Corey Elijah, I don't think, registers that that's the person I originally saw, and he keeps on passing him. And as he continues, he passes by Joseph Rosenbaum, who at this point has taken his shirt off. He's got shorts on, and he's taken his shirt and kind of wrapped it around his head. And Mr. Rosenbaum is still carrying that plastic hospital bag and walking down Sheridan towards the 63rd Street car source. The defendant is behind him at some distance. As they get down to the 6200 into the 6300 block of Sheridan Road, that block on the west side of Sheridan has a house right at the corner of 62nd and Sheridan. And then on the south end of that block, the south half, is the car source lot. You will hear testimony from someone from the FBI who was up in a plane that night taking video, and we will show you the video. It is an infrared video, which means it picks up heat. This is at nighttime, so regular cameras, especially from an airplane, aren't going to be able to see everything. So the infrared helps us to see in the dark. The video picks up Mr. Rosenbaum. It is quite clear to see him because he is a white blob. Infrared picks up heat. He doesn't have his shirt on. So the cloth of a shirt would help conceal some of that heat, but when you don't have your shirt on, that heat radiates, and the infrared picks it up more clearly. So he's very easy to see in the video as a white dot. You see him running towards the 63rd car source. And behind him, running in the same direction, following him, is the defendant. As they get to the 63rd Street car source, there are some cars on the north side of that lot. Mr. Rosenbaum peels off behind those cars, and the defendant stops on the other side of those cars and turns towards Mr. Rosenbaum. Now, obviously, in an infrared video from a plane overhead, we don't know exactly what was going on at that very moment. We don't know what words were said. But what's clear is whatever that confrontation that was initiated by the defendant started, it caused Mr. Rosenbaum to come around the cars and start running after the defendant. The defendant drops the fire extinguisher right there and runs, carrying his AR-15. At some point during that foot pursuit, the defendant turns around, points the gun at Mr. Rosenbaum, who puts his hands up in the air. Now remember, he has got no shirt on. He's got his hands up in the air, almost like, what are you going to do? The defendant stops, pointing at Mr. Rosenbaum, continues to run. And right around this time, there is a gunshot from someone else, who we have identified by the name of Joshua Zeminski. This is an individual who's walking on the sidewalk, probably 30 feet away from where the defendant and Mr. Rosenbaum are running. Mr. Zeminski, for reasons only he can explain, decided to take his handgun and fire it one time in the air. As I said, this is in a different direction and many feet away from where the defendant was. Mr. Rosenbaum continues to pursue the defendant.
Why?
And we will have Detective Martin Howard testify that he's timed the gap between Mr. Zeminski's shot and the eventual gunshots is about 2.5 or 2.6 seconds. Mr. Rosenbaum closes on the defendant. The defendant turns and fires 4 shots at Mr. Rosenbaum. You will hear the testimony from the Milwaukee County Medical Examiner, Dr. Douglas Kelly, that Mr. Rosenbaum suffered 5 wounds total from 4 bullets. Dr. Kelly will testify that the first 2 wounds that were inflicted upon Mr. Rosenbaum were to his lower extremities. We're not sure which order they were in, but one was to his right pelvis, fracturing his pelvis, and one was to his left lower thigh. Dr. Kelly will testify that these wounds caused Mr. Rosenbaum to start falling face forward. And you will see video of his body where it is found. He lands on his face down on the ground. As he is falling, the defendant fires 2 more shots. One of them hits the defendant in the back, or I'm sorry, Mr. Rosenbaum in the back. And that is the shot that kills Mr. Rosenbaum, according to Dr. Kelly. You will hear testimony from someone by the name of Richie McGinnis. Richie McGinnis is a reporter who came to Kenosha to cover the events of that night. And at some point shortly before these shootings, he encounters the defendant at 59th Street and interviews him. He talks to the defendant and then follows the defendant down Sheridan Road and is right behind the defendant as these shootings are occurring. In fact, he is in the car source lot. He is behind Mr. Rosenbaum when Mr. Rosenbaum is shot. And Mr. McGinnis will testify that one of those rounds came close to him, which is the basis for the count that we've alleged that Mr. McGinnis was recklessly harmed or placed in danger by the defendant. Mr. McGinnis will testify that when he saw Joseph Rosenbaum shot and fall to the ground, he immediately ran up and attempted to treat Mr. Rosenbaum. He took off his shirt. He used it to try and stem some bleeding. He rolled Mr. Rosenbaum over onto his back, and he's attempting to administer first aid. Many other people respond at that very moment to that location and attempt to help Mr. Rosenbaum. They eventually lift him up. They carry him across the street to Frederick South, formerly known as Kenosha Memorial Hospital, KMH, which happens to be right across the street. These folks load him into a hospital SUV that's there in the back of it, and it races off towards the emergency room to try and save Mr. Rosenbaum's life. That's what Mr. McGinnis does. The defendant, after shooting Mr. Rosenbaum, gets on his phone, calls Dominic Black and says, "I just shot somebody," and starts running away. Now, one of the things that you will see and hear in this case is that the defendant throughout this entire evening held himself out as an EMT, as a medic, that he's carrying a medical bag with him, strapped to his body. And yet in this time of Mr. Rosenbaum there on the ground, injured, potentially dying, the defendant offers no aid, but instead runs. He runs up Sheridan Road. He encounters another member of their group from 59th Street, who you will hear testify, by the name of Jason Lakowski. Jason Lakowski is similarly armed. He's a former Marine. He had been with the defendant at 59th Street and had come down in response to the gunshots. Mr. Lakowski will testify that he met Mr. Rittenhouse as the defendant was fleeing the scene. And Mr. Rittenhouse said to him, "I didn't shoot anybody, but I need help." And Mr. Lakowski says, "Head up towards the police." So the defendant starts running north on Sheridan. The crowd starts yelling, "That guy, the defendant, just shot somebody," because that's all the knowledge they have at that point. And it's true. So they begin to chase after him. They clearly believe he's an active shooter, and they try and stop him. And I've already described to you the events that follow. Mr. Huber, the unknown individual, and Mr. Grosskreutz. So when we talk in this trial about the nights of August 25th, we need to keep in mind the context of that night. We need to keep in mind the fact that there were hundreds of people on the street that night, experiencing the same chaos, the same loud noises, the same gunfire, the same arson, the same tear gas, the same hostile confrontations with people who believe the opposite of them. And yet out of these hundreds of people, only one person killed anyone that night. Only one person shot anyone that night. When we consider the reasonableness of the defendant's actions, I ask you to keep that in mind. Now, in this trial, you're going to hear from a number of witnesses from the state. I've already told you about a few of them. We are going to begin the testimony with Dominic Black, and he will tell you a little bit about the acquisition of those guns. You will hear from Corey Elijah,
Shouldn't Dominic
who was
Black
live
just plead
streaming
the fifth on
events
that?
night. You will hear from Detective Martin Howard, who worked diligently to gather evidence, including many different videos, many different photos of the scene that night. We are going to use that television to show you these things so that you can see them yourself. I know many of you alluded to the fact yesterday that you've watched or read things about this. You will get the full story here in the courtroom, and you will see some things that have not been made public yet. We intend to do that by moving the TV as central as we can so that you can see it as up close and as well as possible. And we will show you as much as we can about the events of that night. You will hear from the FBI individual who was in the plane taking that infrared video that shows the defendant chasing Mr. Rosenbaum and initiating that confrontation.
Fair.
You will hear from other individuals who took video that night. You will hear more about Joseph Rosenbaum from his girlfriend, Carrie Ann Swart. She will tell you about his hospital stay. She will tell you about that bag. She will tell you about what was in that bag. You will hear about Anthony Huber. You will hear that he was a skateboarder, that he lived for skateboarding, that he was at the skate park at Penoyer Park all the time, that he actually knew Jacob Blake personally, that he came out that night because he wanted to show support for his friend, Jacob Blake. You will hear what sort of person Anthony Huber was. You will hear from other witnesses who've been affected by that night.
Except that he
You will
was a
hear from
domestic
law
violence.
enforcement
You won't hear that
witnesses
one.
who did a lot of investigative work to assemble all of the evidence against the defendant in this case. And you will hear from Dr. Douglas Kelly, who will testify regarding the cause of death of Anthony Huber, the gunshot wound to the chest. And you will hear that the shot that killed Joseph Rosenbaum was a shot to the back. And based on all of that evidence, I think you will agree with me that the defendant is guilty of all of these charges. Thank you.
Go ahead.
Let's take about a 10-minute break. Please don't talk about the case during the break.
Wait. All right. Yeah. So for my money, and I sense the chat will disagree with this, but so be it. I thought the opening was about as good as you would expect. This is top notch. It's not 10 out of 10. It's not like, creating new levels of brilliance but it's at the highest level of like a normal professional. So
Yeah.
I'd say this is 9 out of 10 in terms of an opening. Some minor points of criticism for me. It was a little long for my taste. I think some of the points could have been shortened or perhaps omitted. That being said, I did like the overall idea of presenting the full timeline and full story. So I like the concept, but perhaps it could have been shortened a little bit. I liked his pacing. I liked his timing. I liked how he didn't step over some major points. Like when he made like a really emphatic point, he would stop for, 3 or 4 seconds to let the point sit. And so that was really good. I just think overall it was well presented, well argued. His tonality, his pacing, his word choice was overall extremely, extremely good. I found it very persuasive. That doesn't, of course, mean that I'm saying that I think that ultimately Kyle Rittenhouse is guilty. So please don't misunderstand me. But I think he did a exceptional job for a prosecutor. I thought it was very, very good. What do you think, Nick?
I basically fully agree. I mean, as far as the prosecution in this case has a really rough set of facts to make this conviction. They know they do. They have the context of a riot. They have a context of chaos. He he knows that he has the context of these guys pursuing Kyle, reaching for guns. I mean, he's not trying to mitigate that, and it's pretty interesting. Or he's not trying to ignore that. He's putting it in there. He's trying to mitigate it by getting out ahead of it. The fact that he has to stand there with a straight face and convincingly does so.
Oh yeah, I found him believable. I found him like he to me at least, he seemed like he believed everything he was saying.
Right. The fact that he has to, with a straight face, argue that Joseph Rosenbaum pursued Kyle Rittenhouse. Kyle turned and did not shoot him. Rosenbaum puts his hands up. He's like, oh, okay. And he backs up. And then a couple of seconds later has to admit that. And then some other guy shot into the air. And then that guy, and then Rosenbaum resumed pursuit of Kyle Rittenhouse. Like, he has to deal with that fact. And he does it really, really well at opening. Now, this stuff is going to, of course, keep coming through trial as the timeline is established, and particularly by the testimony of Dr. Black, because he's going to be the guy laying out the video timeline. One of the facts that he seems to be hinging this entire argument on is the predicate act of shooting Joseph Rosenbaum in the back. If, and I argued yesterday, I think convincingly so, that if whoever wins on Rosenbaum is going to win this case. Rosenbaum,
I think it's very likely.
Yeah, Rosenbaum is the hinge. And so
except for the confusing jury instruction on reckless endangerment, which God knows at this point, but carry on.
Right. But on the main murder charges and the Huber or the Grosskreutz assault charge, if you win on Rosenbaum, you're going to probably end up winning on the other two, because it goes right to his state of mind, what he reasonably believes. The interesting thing is, it doesn't matter what Rosenbaum, Huber, or Grosskreutz believe. The reasonableness of their actions are not on trial. He wants to maybe put that reasonableness in there to try and confuse the jury. I assume the defense is going to focus heavily on the fact that it's about what Kyle perceived, not what anybody else perceived.
This is part of this issue is exactly what you were experiencing in the chat yesterday, with the confusion from the chat from Kyle Rittenhouse's side. People were confused about this aspect, that we kept saying, oh, Rosenbaum, I mean, some of these people might be valid in self-defense. They might have a valid self-defense claim.
Right.
And some people on our side, or Kyle Rittenhouse's side, were confused by this. It's like they seem to be under the impression that if these people have a valid self-defense claim, it must necessarily mean Rittenhouse doesn't, which isn't true. They can both.
Yep.
So people who support Kyle Rittenhouse are confused by this aspect. So sure, why not confuse the jury? Because some of them probably believe that too. If he can demonstrate that these people were reasonable in their actions, he can try to infer that's necessarily true. Rittenhouse isn't reasonable.
Right.
So that would allow the jury to get to a guilty verdict if they have that same issue. Smart.
The trick for the defense will be reiterating and explaining and emphasizing on the jury instructions that it's Kyle's state of mind that matters in all of this, that the other people's actions, their perceptions are not relevant to this.
How well do you think that's going? We couldn't convince our own chat, yesterday, Nick. How do you think that's going to go?
We'll see. I don't know. Maybe Richards is a really good lawyer. We'll have to see what. Or do you? I'm curious to see if Richards or Sharifsi is going to take the opening statement.
I'll obviously rate it for itself. The only part. Okay, so I want to say a couple other things. I thought it was very good tactically for the prosecutor to admit to bad facts.
Yep.
It's called drawing the sting, is a phrase you often hear in law. When you have bad facts, it's very helpful to you to get them out in front, because the other side's going to bring them up. So you basically have two choices. Do I let the other side bring it up, or do I try to bring it up and try to create the initial impression that those facts, those are bad facts, but they don't really matter? I'm so confident in my case, I can admit to the bad facts and I still win. So it's generally true, and I think true here, that he is incredibly smart for making the defense's case for them, because many things he said will be things the defense will say. And that's kind of the point.
Yep.
He's trying to preempt that by I already said the same thing. I went first and it must be guilty. So, it's not like it's the first time you've heard this, not a surprise. So I thought that was very, very good. So For people who don't understand why they're doing that, there's a very strong tactical consideration, and I think it's the right call. The only part of the argument that I thought overall was weak was the self-defense argument, because he correctly states the law of imminent danger to himself and others. Now, he tries to answer that by saying no one else shot anyone else that night. Therefore, Rittenhouse no one else, despite all the arson and rioting and blah, 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 no one else apparently feared for their life. Therefore, it must be true. Rittenhouse didn't fear for his life. I didn't really feel like he didn't really feel like he satisfactorily closed the self-defense. He mentioned it, but I didn't really feel like he fully converted it to the end. It's a bit of a weak argument for my point. He's trying to argue from implication that because everyone else didn't shoot anyone else and because everyone else was in roughly the same position, that Rittenhouse in his specific situation is not reasonable. And it's a little weak, but I don't know he could have done any better. So I'm still sticking with 9 out of 10.
Yeah, no, again, it doesn't mean that that they're going to win the case. It doesn't mean that it's the most convincing thing ever. It just means he did the job that he should do. And as a defense attorney, you would not want that guy. You don't want that guy giving opening arguments. You want pretty much any other prosecutor.
Fat ass would be good.
Yeah, because that guy seems just inherently unlikable. Right? Like, just from his posture and overall demeanor, he's less charismatic, he's less likable, and he seems offensive and affrontive even. But no, Binger did a very good job. And you have to give credit where it's due, because it's a consideration that the jury is going to take in. Now we'll see how the defense does, and
see if they can meet the challenge.
Hopefully they're going to make some very compelling arguments. I mean, he talked a lot about shooting in the back, which was a tactical choice. The context of that shooting in the back is what the defense has to show, and what Dr. Black's testimony, why it's so important. The space between the shots that Kyle fires, it's bam, bam, bam. That's it.
Yeah.
Bam, bam, bam. No,
Close enough.
Bam, 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 bam. It's so fast. It's like a quarter second or less between each shot. So Rosenbaum is falling forward, and the shot that hits him in the back comes in at a downward angle. I mean, it's not like Rosenbaum was turning around to flee and he shoots him.
Fair enough. But, then, of course, you can properly say he was shot in the back. Now, why that's true, I'm not going to necessarily mention right now, but it is technically true. And here's why, from a ballistic standpoint.
He kind of does. He kind of did. Very. I mean, he was falling, so I mean that's why it went in his back. But he was shot in the back, and we don't.
Yeah,
I mean, that's a coward's shot right there. Is shooting a man in the back.
I think the chat is going to is calling him a liar and all the rest of it. And again, the chat's going to disagree with it. But I, for my money, didn't see anything he said was a lie. Everything he said, to my money, was a. Go ahead.
No, there was something early on. I commented on it. He lied about something. I don't remember what it was. It was very early in the argument, though.
Okay, yeah. Well, maybe with the one exception, if we ever get back to it, we can discuss that specific thing. But everything he said is a colorable interpretation of the facts. So, I thought it was about as good as can be done. And you would do well to study this as an advocate.
Absolutely. And to be clear to the chat, in case some people are confused, you typically don't object during opening arguments. It's very bad form.
It's very bad. And same thing for closing arguments. Objection is like,
unless the act is extremely egregious, like they make a highly prejudicial statement that has no foundation, will not be shown, or was specifically excluded in a prior motion. That's the only time you're going to get to object during opening arguments. The defense's objections, so to speak, will come when they lay out their narrative next. And so I just want, because I know some people are like, why isn't the defense doing something? That's why, because if you did, objecting during opening arguments can be a very negative thing from the judge and from the jury.
Chad is suggesting that calling it a straw purchase might be a lie. In terms of
Leon's law
in terms of like its more legal sense, probably, but in terms of a more colloquial sense, that might be something that is a little bit touching the line. But
the lie was him saying Kyle could not own the gun, which is not true.
That I did know. That it's like he can't.
Yeah.
Well, I'm not sure about that one. So that might have been he misspoke or maybe something, but it's like that one does seem to be a bit of a problem. But I'm not gonna harangue the man for one sentence.
No.
In an otherwise brilliant opening, because I'm pretty sure the defense is going to make some mistake somewhere. It's probably not going to be perfect. So
we'll see. Maybe it will be. The judge will just go, "Oh my goodness, that was so good," and it's dismissed. No, I'm just kidding.
Sure.
Let me read a couple of these chats. Stephen Cooper says, first night they cleaned graffiti. Second night, he cleaned the neighborhood. Billy Witch Doctor 99 says, thanks for covering this, Nick and Uncivil. Hey, my pleasure. I assume it's your pleasure too. Maybe not, though. Dennis Heaton sent a message, but it got deleted, I think, by YouTube. So thank you, Dennis Heaton, for the donation. Sorry that YouTube is racist against you. Nick Ricada says, and I saw this one. I want to address it. He says, doesn't matter. Kyle let off that alleged shot to someone's back because he fell. Know why? Because that's a negligent discharge. Rittenhouse is culpable if true. That is not at all a sound legal analysis or logical analysis. It's not automatically a negligent discharge because he shot a guy in the back as he was falling to the ground.
Yeah.
That is completely incorrect. And I don't know how to say it other than that's just wrong. Tommy TK says, Nick, I've agreed that the whole case hinges on Rosenbaum's death. It will imply if Kyle's an active shooter defending himself. Can't wait to see. Well, I mean, it also, the active shooter thing is a misnomer. That's a red herring. Kyle doesn't think he's an active shooter. Unless Kyle intentionally killed Rosenbaum.
The question was the perception of other people. And I think it would be reasonable for a person to think that he might be an active shooter, which goes to the self-defense claims of people trying to stop Rittenhouse.
Right.
So, yeah.
But those people aren't on trial. So it's a good distraction technique. It's why it's good for Binger to have put it in there. That's why he's mentioning these things. He wants to get the jury outside of the mind of Kyle Rittenhouse and into the mind of other people. But the state of mind of Kyle Rittenhouse is what matters. If Kyle Rittenhouse shoots Joseph Rosenbaum in cold blood, then with intent to murder, right, rather than intent to defend, then it changes Kyle Rittenhouse's state of mind for everybody else. Now he's not defending himself from harm. He's defending himself from being a murderer by murdering more. He's continuing his string of illegal activity, and he would know that. That would be part of the issue there. But if Kyle's defending himself from Joseph Rosenbaum, then he subjectively is carrying that fear into his going towards the police. And by the way, that was a really brilliant moment by Binger, if I must say so. He mentions an absolutely irrelevant fib that Rittenhouse allegedly says to the other guy. I don't know if he actually says this, but apparently the guy's going to testify that Kyle Rittenhouse says, I didn't shoot anybody. I just need help. And the guy says, run to the police. Right.
That was, the prosecutor said the opposite of that.
No,
the prosecutor said, I just shot somebody is what the prosecutor said.
No, that's what he calls his friend and says, I just shot somebody.
Right.
And then he encounters the former Marine guy who he was with at the car source. He encounters that guy and says, allegedly, I didn't shoot anybody, but I just need help. And so he says, yeah, head to the police, is what he said. Kyle said. Now, maybe he mistook that. Maybe I misheard it, but I'm 99% sure that's what he said.
Well, if that's what a witness is going to testify to, then so be it. I mean, if that's what he's going to say, then okay, the prosecutor can rely on that.
But the brilliant part of that to me is he mitigates the fact that he's telling the jury that Kyle Rittenhouse is headed towards the police with a lie that Kyle Rittenhouse told about just shooting someone. It's because
Yeah. So
I
it
think-
goes to his credibility, which, yeah, he told a lie to this Marine. So it questions maybe everything. So fair, reasonable.
Yeah, and we'll see if that if that bears out with the testimony. I'm not sure. And it's possible Binger misspoke too, but I don't know. Let's see. Someone says you're going to mention the manlet argument the prosecutor is making for Rosenbaum.
There is a point to be made, because when you're looking at self-defense, the relative threat profile of the people is relevant. So if you have a 5'3", 130-pound person, the amount of force that would be required is different than 6'10", 400 pounds or whatever.
He said 5'3", 150, which is actually pretty big for that height. 150 is and Rosenbaum is not like, he's beefy, he's burly, his broad shoulders, so yeah, it's an interesting question, but it was just funny the way it's like, oh no, everybody shorter than 5'3" just realized they're no longer threatening. Let's
Short
see.
kings, right?
Yeah, short kings rise up. Oh, but except you can't.
Ooh.
That was rude.
Apparently,
that was rude.
Did take a couple steps like 2 or 3 months ago. So, yeah.
Yeah. Let's see. President-elect Austin M says dismissing the possession charge mid-trial kneecaps prosecutor. I would agree. Oh wait, I read that one too. Not applicable says, could you imagine having to baby a 30-plus-year-old judge or 30-plus-year judge on how self-defense works? I'm glad people get paid to do this so I don't have to. Freaking crazy. Look, arguing over jury instructions and arguing over the law happens with a lot of judges in a lot of instances. No, judge, this is what this means. Yes, judge, this is well established here, here, and here. It's just how it goes. President-elect Austin M says arguing the endangerment might be good. It forces the state to call McInnes, saying he was in danger. If not, it may collapse the whole prosecution. McInnes is the state's witness, which I think is a misstep by the state, personally. I think that was a bad play. I think bringing the charge against McInnes and making him the state's witness is a bad play, because McInnes is typically favorable to Kyle. And the other interesting thing about that, that I hope the defense puts together at some point, is the fact that Kyle fired 4 bullets, hits Rosenbaum 5 times because one bullet leaves Rosenbaum and re-enters at a different point in his body. Again, he's falling forward. Mm-hmm. So you can imagine it going through like a shoulder or an arm, and then into a thigh or something like that. I don't know. They don't know the order of the shots. But
yeah, there was a point in chat that I missed earlier in the analysis that I wanted to mention, if you don't mind. It is true in self-defense law that if you're like purposefully inducing someone to act in a violent way towards you, it can nullify the self-defense case. So I saw that in a case where there was a guy who shot someone outside a convenience store, I think, as they're going in or out. And on the video, it looked like self-defense. And I said so at the time. But as it developed, apparently this guy was coming like on a routine basis. And the assertion was that he was, through his actions, trying to provoke the action so that he could use self-defense. So that was one of the things the prosecutor is trying to get to, that Kyle was that he was in this hostile crowd. He knew it was hostile. He knew it was hostile to them. Therefore, he was trying to provoke an attack against him. Therefore, he loses his self-defense claim. So that's a colorable argument.
I think it's pretty thin to say that someone was present, therefore they were provoking.
Yeah, I wasn't. Yeah, colorable and thin. Yeah, it's just worthy of note. I try to give, and the chat, I just try to look from both sides of this analysis and just like, well, this is what the prosecutor. What's the best possible case? What's the best possible case for the prosecutor given what they just said? It's like, okay, here's how to make that work.
You have to understand there is a complete moron in the chat who has been running this theory for the past 6 months, desperate for attention, and he doesn't get that provocation tends to involve an overt act. Carrying a gun is not provocation. Being present in a crowd is not provocation. There has to be something more. The closest Binger can get to this is this alleged FLIR video that literally no one has seen outside of the two parties, apparently. This FBI FLIR video that shows, even though there's no audio and no resolution.
I'm curious what this could possibly show, because I'm just trying to imagine it in my head.
There
that
is
it's going to be able to show
video.
something.
There is video of Kyle following Joseph Rosenbaum, incidentally, not specifically, towards the place where the shooting would take place. There's also, on that video, Joseph Rosenbaum meets up with the guy who would actually fire the first shot into the air. Joseph Rosenbaum meets up with him and is walking with him. So the judge, the prosecutor said, we have no idea why this guy fired the shot. Was he being called as a witness? I'm really curious if that guy is a witness, and we'll get to ask why he fired a shot into the air randomly that night. But there is video of Joseph Rosenbaum just before the incident meeting up with that guy and his significant other as they're walking to the same place. Kyle is about 20 or 30 yards behind them. They're not running. Kyle does not appear to be in any sort of pursuit. I don't know if that's what the FLIR video is covering specifically, but that is on non-FLIR video. I've watched it myself, so I know that's true. So I'm curious if that's the issue. If that's the issue, it will not show Rosenbaum. It'll show him jog up to the other people. It does not show Kyle running in any way that I've seen. So it'll be. I'm really curious to see that FLIR video. He's got a big hurdle that since there's no audio, it's going to be really hard for him to show that Kyle was definitely provoking Rosenbaum and not the other way around. There's a significant amount of doubt there, but without seeing the video, we don't know.
Right.
So that'll be interesting. Rick Nikita says, "Where's the whistle pig at? Hopefully you didn't drop another $400 bottle of whiskey." As I told you in chat, I drank all of that on stream. It was delicious. Thank you very much. Peter Bemis says, so Kyle's going to prison for 12 years for not shooting someone because of a bad read from the judge. McInnes was behind Rosenbaum. Oh, wait, I wanted to get back to this point. Kyle fired 4 shots. All of them went into Rosenbaum. The interesting thing is the shot that apparently recklessly endangered McInnes would have necessarily come out of Rosenbaum, right?
Yeah.
So it's a weird thing to say that someone could be recklessly endangered when the bullet traveled through the intended target into someone else or near someone else. Like, it's not like he indiscriminately fired, missed 5 shots and hit 1, and the 5 shots errantly went off into the crowd. He shot the target. The bullet just traversed through the target.
It's but the question, I guess the question would have to be at the moment you pulled the trigger, whether it was reckless, because you don't know, probably can't determine where the bullet's necessarily going to go because people might move and such and so forth. So is it reckless even though you hit what you're aiming at? That's a tough squeeze.
We also don't even know if it was if the bullet traveled in a straight line. I mean, AR-15 bullets tumble.
This is very true.
And if it's the one that hit the pelvis, there's no way to
proceed to the defense opening. It's my understanding that counsel is going to be showing videos to the jury.
Okay.
These aren't evidence yet. I don't know what's going to be shown. And I think it's unusual procedure. I've often considered using exhibits in my opening statement, and I think it's generally.
How has this issue not already been resolved?
So we can't be showing them to the jury unless they're in evidence, and we don't have any of this in evidence yet. So I would object to that.
Well, he does need to tell you what he intends to shoot. I got to turn things on here. He does need to tell you what he proposes to show, and me too. But the rule does not preclude their use during opening statement at all. What's up, Mr.
Your Honor? The first slide is a jury instruction, part of self-defense. The second slide is a picture of Joseph Rosenbaum wearing the maroon shirt. for identification purposes. The third is a video at the Ultimate Gas of Mr. Rosenbaum
Looks
having
like Rich
to be
got a haircut for
restrained.
this.
The fourth is a still photograph of Mr. Rosenbaum walking down the street after arming himself with the chain. The fifth is a picture of Joseph Rosenbaum taken from the video at the Ultimate Gas Station of him and Mr. Zeminski.
This should be done at the judge's
The
bench, in my
sixth
opinion.
photograph,
Well, the jury's not
once
there,
again,
so.
a picture
Oh, jury's not in yet. Okay.
taken by Nathan DeBrune of Joshua Zeminski and Joseph Rosenbaum starting a fire at the trailer. And in that one, Mr. Rosenbaum is wearing a blue mask. Number 7 is a picture from the Ultimate Gas Station taken from a video of somebody who's commonly been referred to in this as Yellow Pants Man, Kelly and Joshua Zeminski, showing Joshua Zeminski armed with the weapon that was the first weapon fired at car source number 3. Number 8 is a picture for identification of Richie McGinnis. Number 8 is a picture of how Richie McGinnis was dressed that evening so he can be identified in the videos. Number 9 is Gage Groskwitz and his backpack taken from a video that has been agreed to be introduced into evidence. Number 10 is a still photograph of Gage Groskwitz running down Sheridan Road towards my client, arming himself. You can see him pulling the gun out of his back waistband. Number 11 is a still photograph of Anthony Huber holding his skateboard. And then number 12 is a picture of Anthony Huber holding his skateboard, so you can see the whole skateboard, but dressed the same way as it is in number 11. Number 13 is Anthony Huber holding Mr. Rosenbaum back at the confrontation at Ultimate. Number 14 is the photograph of Jump Kick Man, the non-complaining witness, kicking my client in the head. 15 are 2 close-up photographs taken from that of the shoes of Jump Kick Man. 16 is a photograph
What are those?
of 11:40 p.m. when Kyle Rittenhouse is going out with Mr. Balch, and he's confronted by Yellow Pants Man and 3 other armed individuals that evening. And those photographs are blown up in 17, showing one individual with a noose, the other individual with rocks in each hand, and the other one a picture of the individual in the blue shirt armed. 18 is a video where Mr. Rittenhouse tried to return to the 59th Street car source and was stopped by law enforcement and the Bearcats. Number 19 is a still photograph taken from Mr. Rittenhouse at Ultimate as he's leaving with the fire extinguisher, his medical pack, and his gun heading towards car source 3. 20 is the video, what's called the infrared video with Kelly Zeminski, Joshua Zeminski, Rosenbaum, my client, and Richie McGinnis circled and identified. 11:48 is a still photograph of Mr. Zeminski's arm in the air firing the first weapon, the first shot. 22 is those individuals, that same photograph from the video, same video, a photo just a couple of seconds later with 2 circles, one identifying Mr. Rosenbaum in yellow and another one showing Mr. Zeminski with his arm raised firing. 23 is a video taken from, and I always forget this gentleman's name, Lucas Zanin from 63rd Street, right west of Sheridan, which forms the south edge of Car Source, and that's what Kyle was running to. There's approximately 100 people there bashing all the car windows, in there with pipes, bats, things like that, jumping on the cars. And you hear the first shot, which is Zeminski's, and people kind of stop a little bit. And then you see Kyle, you hear the next shot, and all of those people
You
start
see
taking
Kyle?
off from
Oh
Car
my
Source.
God.
24 is the
happens?
video where Kyle begins leaving Car Source 3 after the shooting. And on that video, you hear
How long is this
somebody
opening going to be?
who's
I
been
mean, he's not
identified
opening
as
now. I'm just
Tony
wondering when he
Zeminski
actually gets to the opening. How
yelling,
long is that actually going to be?
kill him,
Sound
things
like
like
30
that.
minutes
You shot
at
him.
least.
25 is Gage Grosswitz's video where he runs up to Kyle. It's about 7 seconds. Runs up to him as he's running down Sheridan. At that point, Mr. Grosswitz is unarmed. He asked Kyle what he did. Kyle said, "I'm going to turn myself into the police. I had to." Photograph 26 is from BG on the screen. Photograph of an unidentified individual in a white sleeveless, or what's kind of referred to as a white beater shirt, hitting Mr. Rittenhouse in the head, knocking his cap off. And then right after that, you see the next photograph from that video of circled Mr. Huber picking up after a skateboard, which he had used to strike my client in the head. The next photograph is a still photograph of an individual running up to Kyle as he's on the ground. There are several individuals in that photograph. One of those individuals being Jump Kick Man, approaching from Kyle's right.
Jump kick.
And the next photograph is
great
him
term.
kicking Kyle in the head. 30 is the picture of the close-up of that and the shoes. 31 is a photograph of Mr. Huber striking Kyle Rittenhouse in the head with his skateboard, held by the trucks in his right hand.
Held what?
The trucks of the skateboard.
You know, do I look like I skateboard?
They're called trucks.
Okay, wheels.
Do I look like
These are
I
wheels.
The wheels. Yeah.
Wheels with his right hand while he's grabbing Kyle's gun, his bare hand, touching Kyle's gun with his left hand. The next photograph is depicting Jump Kick Man getting up from the ground, Mr. Huber with his hand once again on the gun going forward.
I already am liking
and still
Richard's
having a
strategy
skateboard.
here.
33 is
Because
a
Kyle's
close-up
case
of
is
that
highly
photo.
visual. And so he's going to make it
34
visual from the start.
Is you can see the strap
We'll
on
see how he
Mr.
pulls it
Rittenhouse's
off.
gun being pulled
But-
taut. Mr.
I'm not
Gross
sold on it yet. We'll
running
see how it
into
actually
the frame
manifests.
From the right of the frame. Next is Gage Grosswitz standing in front of Kyle Rittenhouse with his hands up. Kyle does not shoot. Next, Gage Grosswitz lunges forward with his right hand pointing directly, and that is when the shot is fired. And then there's a picture of Kyle Rittenhouse on the ground, individuals approaching him, one with a pipe, one with his hands up. He backs them off, does not fire. 11:51, him video trying to turn himself into the Kenosha Police Department and turned away. And the final is a photograph from the Antioch Police Department surveillance cam at 1:20 a.m. of Mr. Rittenhouse and his mother turning himself into the Antioch Police Department.
This is the most Wisconsin accent that has ever Wisconsin.
Witnesses, we've got the whole trial there. I thought the opening statement was supposed to be a summary of the evidence.
Yeah,
not
this
the
is
evidence itself. This is I think we're up to 41 videos and photos that are going to be seemingly introduced through the testimony of Attorney Mark Richards. This is a highly unusual procedure, Judge. Both sides will have the opportunity to call witnesses to talk about these things. We will have an opportunity in closing arguments to characterize these things, but to give the jury what the defense considers, and I'm not conceding that these things are all the evidence, or even that a lot of these things are relevant, but for the opening statement to essentially be the entire defense case and all the evidence, showing it to them is highly unusual. I took the approach in my opening statement, and I guess I was not pushing the envelope as far as I should have, but it's always been my approach that I will describe what I believe the evidence is going to be, but I'm not the witness. I'm not giving them the evidence. That's what the testimony is for. We've had a stipulation as to the authenticity of a lot of the things that counsel has talked about. That does not mean that they're admissible into evidence. It does not mean we're conceding relevance to those things. And I anticipate that there will be some arguments as to the relevance of a lot of these things. We've already had some arguments about some of these things. So, you stressed to the jury that the opening statements would be brief. It took 5 minutes for him to list all of those things, let alone what it's going to take to actually show them and play them for the jury. So I think as a general policy, Your Honor, and I understand it's not necessarily the law, but witnesses should be presenting evidence, not the attorneys in their opening statement. So I object to this procedure. I think it's
interesting.
It's overly long. It's duplicative of what the evidence is going to be. There'll be an opportunity through witnesses to present all of that. I think counsel should be describing what he thinks the evidence is going to show. That's appropriate. But showing them all the evidence.
This objection, you think
this
he's
way,
going to ask for
why do
another
we even need
recess
witnesses?
to reframe
At this
his
point, let's just,
opening?
I'll get up and I'll play all the videos I want to
Maybe.
play. They'll play all the videos they want to play, and then we'll just be done without any testimony. That's not the way this trial should work. So I don't think this is a proper procedure, Your Honor, and I do object to it.
Okay. Well, first of all, are you going to be able to authenticate each and every one of these?
All of these come from exhibits that have been agreed or stipulated to their authenticity.
And they're all going to be relevant?
They all are relevant. They've all been.
It sounded like what I've already heard about, by and large. The standard is not what you did or what you can do or could do. The standard is what the law allows. And I can remember studying this 50 years ago, that this was an acceptable way with judicial permission to make an opening statement. We see it more in civil cases than in criminal. It's not customary in criminal cases, but I've seen it done by your office.
Damn.
Ooh, by your office is a nice little burn.
In terms of the numbers. But on the other hand, there's a large number of crimes being charged and separate acts that are being asserted with respect to both the acts that the state alleges were unlawful and the defendant's claim of self-defense. So given that they do appear all to be relevant and they've been agreed as authentic, then I don't see any reason that I should interfere with his right to make an opening statement. Mr. Binger makes a good point in reinforcing my comment that this is supposed to be brief and informative. So
I
keep
don't
it.
think I'll be any longer than him, Your Honor.
10 minutes?
No, then
All
he
right.
Always
was.
just said?
No?
Yes,
He said him.
One of the
Any longer than
motions
him.
in limine I filed,
okay. I was
not
about to
objected
say.
to by the defense, is that there be no reference to any pending or prior criminal cases or convictions with regard to Joseph Rosenbaum.
Fair enough.
The parties are aware, the jury is not, that there was at the time of his death a pending criminal case between Joseph Rosenbaum and his girlfriend, Carrie Ann Swart.
Really,
And there was a bond condition
I
that
thought the judge was
prohibited
going to uphold that
Mr.
objection.
Rosenbaum from having contact.
Yeah.
The purpose of my motion in limine, which, as I said earlier, was not objected to by the defense, was we're not going to talk about that. Now, I made a reference in my opening statement to the fact that
What are you thinking about this
Rosenbaum
bird American
saw
flag
Miss Swart
pin?
that night and was basically
That's a
was not
weird
allowed
thing.
to stay with her was not able to stay with her that night, so he left her residence. And I purposely worded it that way, Your Honor, because there are many reasons why someone may not be able to stay at someone's residence. It could be because of a bond condition. It could be for a myriad of other reasons. It's my understanding from an off-the-record discussion with counsel that he intends to go into this. He believes I've opened the door to it. I wanted a pretrial ruling from the court on this issue. We got one. And I'm now raising it because if it's going to be mentioned in the opening statement, I think this is the time to address this issue rather
Fair
than
enough.
in the middle of an opening
So you
statement.
can
I'm
anticipate
bringing
the
it back
objection.
again. I do not believe
Fair.
that my statement opened the door to it. And
I don't
frankly,
think so
my
either.
statement is not evidence. So I don't know that it can really open the door anyway. But by and large, I was very careful in the way I worded that. And I don't think it opened the door. I don't think, regardless, this is a relevant issue for this trial. Mr. Rosenbaum's conduct with regard to Ms. Swart has nothing to do with what was going on the street that night. So it is
no, he
completely
may have
irrelevant.
opened the door
And I would
to
ask
it.
that the court reaffirm its prior ruling on my motion in limine.
Why couldn't he stay with her?
Ways. He can't go and say he was at the house and he couldn't stay there and not. Why can't we tell the jury why? Because there was a no contact order. It's not appropriate. He thinks he didn't open the door, but he danced through the door. And he also talked about the hospital, got out of the hospital. He was in a mental hospital. And he's going to put her on the witness stand and we're not going to get to ask that? That's insane.
It's a tough call.
Word hospital, Your Honor. I believe it was actually St. Luke's in Racine, which is a medical facility. It is not a mental institution. This wasn't Mendota or Winnebago or something along those lines. And frankly, I'm not even 100% certain why he chose to check himself in. But again, whether or not Mr. Rosenbaum needed a new kidney or needed medications for mental illness or was going in to have his blood pressure checked has nothing to do with the events of this night. And frankly, it's just a backdoor way of attacking his character and suggesting to this jury
that's the ultimate problem.
Because
it is. That's the ultimate issue.
going to be an allegation
Is it a character
some
issue?
sort of mental illness that had something to do with his behavior that night. I'd love to hear an expert on that, I guess, if they want to try and present that, and we can go down that line and we can talk about whether mental illness contributed to his behavior. What was his diagnosis? What medications were he on? We could open that door and go all the way through it, but that's a mini trial on an irrelevant issue. And if it's going to come in, there's a way to get it in through an other acts motion, which was never filed by the defense. And I certainly have not opened the door when I talk about the word hospital. This could be COVID treatment. It could be a kidney transfer. It could be anything. It does not open the door. And again, I was very careful in the way I worded that, Your Honor. You know, if I start talking about his medications,
question why he's carrying a bag of his belongings from a hospital
or something like that. That's
you
different.
brought up.
Hospital is
I think the
very
prosecution might have the better end of this one.
nebulous
Might
term
be.
that could mean
I just think
a
it's
myriad of
interesting.
things.
Help me out here. I thought when I read the pre-trial motions, and I know there were a series of them on which there was agreement, so I probably may not have the best recall of those because I didn't have to put too much thought into it. But I thought that the references or the statements which were attributed to Mr. Rosenbaum were, "I just got out of jail today." You're telling me that there was also a discussion about hospital? No? Or
there's no video or statements or audio of Mr. Rosenbaum talking about the hospital. The only relevance it has, Your Honor.
Well, wait a minute. I mean,
You brought the
so
bag up,
Sure.
dude.
is there testimonial? Are we going to hear testimony that he made statements that he had just gotten out of jail that day?
There's going to be statements to that effect.
Okay, my
And in
understanding.
fact, your statement on your opening statement was, and I will tell you this, I'm going to ask you to try to reconstruct from you, if necessary. I'll have the reporter read it, but I don't recall the exact statement. I do know that I thought at the time, I'm surprised he's going into this because it may trigger a response. So what exactly did you tell the jury?
What I said, Your Honor, is that Mr. Rosenbaum had gotten out of the hospital that day
Right.
and was carrying around a plastic bag,
Right.
which is the kind of bag that hospitals give you to carry around your personal
Okay.
belongings. The only relevance that it has to this case
Well, I
is
don't know.
that's
I
the
just
bag.
wanted to get
Sure.
the statement.
Yeah. And I
Now,
was doing that because
okay.
the bag comes in. And
Okay.
that's the only
I understand.
relevance.
Okay, now, and you also made a statement about his being with the person by whom he was allegedly bound not to have contact.
That's true.
And do we know the exact scope of that order?
I believe it was a straight, typical,
Don't
no
tell me
contract.
typical. No.
We can look it up, Your Honor.
Well,
It was
What
a
did you
bond
say
issue.
about it? What did you say about it?
What I said is that he had seen her after he got out of the hospital,
Right.
that he couldn't stay with her, and so then he left and essentially came downtown.
That's
and
right.
Ms.
That's
Swart
what
will
he said.
testify,
Why
and
did
she
you
will
say that
talk.
he couldn't stay with her?
I'm sorry.
Why did you say that he couldn't stay with her?
Good
I
question.
said that because it explains why he left and came downtown. He's got a hospital bag, Your Honor. It's a little unusual, I think, for someone to be released from a hospital, have a bag of their personal belongings, go to their girlfriend's place, and then continue to walk around with it.
unusual. Maybe
a
the
little
jury wants to know
We
about
know what was really going on.
And by the way, how do we know that he had been there and had left? Is she going to testify?
Yes.
Okay.
Yeah. And so she's going to talk about seeing him. She's going to talk about that bag, and she's going to say she saw what was in that bag. And this comes into play, Your Honor, because this is the bag that was.
But you're not going to be able to ask her,
There's some
do you know
allegations
why
out
he
there
left
that
your
it's
house?
a cocktail, or it's got chemicals.
As a
in it or
cross
something. It's got
examination
something
question?
that
Burying
caused the
himself
defendant harm.
on this.
It had toothpaste,
Okay.
mouthwash, a water bottle in it. That's the narrow.
Had a water
relevance
bottle
of
in
this
it? Water
bag.
bottles
That's
are
why the
dangerous,
hospital-
dangerous
concerned.
weapons.
The
if thrown.
relevance is not something I want to talk about now. I want to talk about what you said and
Sure.
why he thinks it is worthy of response.
He's misrepresenting the facts of the case to the jury by saying hospital when it was a mental hospital. Mr. Binger knows full well
Why isn't that a hospital?
he had gotten out for a suicide attempt,
So,
and
it's a hospital.
and let the jury know what type of hospital it was, why he was acting the way he was. He was not acting appropriately. That's part of the defense. And,
Boy,
and then he goes and says, can't stay there. Why can't he stay there? Because there's a court order that says he can't. He wasn't supposed to go there in the first part.
True.
If he was on
True.
trial for violating his bond, then we'd have that trial. But he hasn't been
True.
tried or convicted
You
of that.
brought it
because
up,
he's
though, Binger.
deceased.
He went there.
Your Honor, and by the way, we have the bond.
This is a tough call.
No contact, including the residence, electronic or third party, with Carrie Ann Swart and the Park Ridge Inn, which she stays there, and they had been staying there together until that criminal case started. So, if we want to charge Mr. Rosenbaum with violating his bond, what good would it do? He's deceased. But yes, that is true. But again, it doesn't make him a criminal on this evening. It doesn't make his behavior.
He literally
help
does if he
explain
violated the
any
no
of that stuff.
contact order.
I don't think, as far as your opening statement, you need to respond to his statement about the hospital. I'll have to separately decide
Understood.
at a later point as to whether he had been hospitalized and for what. I don't know if that's admissible or not. I suspect that it is not, but I'll keep an open mind. As far as his not being there or not supposed to be there, again, I'm not sure that I want to hear about that in your opening statement. Again, I'll hear you later as to why you think
That's
that
going to
would be
come up on
relevant.
cross, though.
Yeah, you would think it would be a proper question for Cross for the girlfriend.
And he's trying to say, oh, he had a good excuse for not being at home. He couldn't stay there that night. Well, the jury should know why he couldn't stay there.
Well, I don't know. If he can't stay there, he can't stay there. She could have kicked him out because she didn't like his having a hospital bag. I don't know.
But that's not what happened.
I'm not sure it's necessarily relevant. He was where he, like the defendant, was not supposed to be, allegedly, and we'll let it play out.
This
But
is really
how
a
about
close
those
call.
things in your opening
Because
statement.
this
Anything
is
else?
all character evidence
Okay.
that's not normally admissible.
Yeah.
Thought
But as
Binger
I said,
may-
I thought the prosecutor had the better end, so I think the judge's decision is correct.
Would you come down, please?
thought for a minute Judge
Okay.
might let it in the way he was like, well, it was like, ooh.
Yeah.
I think that stuff's open to
That it doesn't come
later
in
on.
now makes sense, but how you're going to keep that out of Cross with the girlfriend on the stand seems, yeah.
Yeah, there's
Because
no
like
way.
you can ask her, did he come to your house? And it's like, do you know why? Or it's like, did he leave? Do you know why? And it's hard to imagine that the restraining order doesn't come into a cross-examination question.
She's going to testify to what's in the bag. Where
Do you know why he was in the hospital?
Yeah, where'd he get the bag?
If
it's
she
from the
knows,
hospital.
if she knows, she's just a girlfriend, so privilege isn't an issue. If she knows independently, privilege isn't an issue for medical privacy. So isn't that a proper question for cross-examination?
Yeah,
But it
think
is a
so.
character. It makes sense to exclude it now. I'm not 100% sure on the issue of when she's on the stand is where the more interesting fight is going to happen.
The reason it makes sense to exclude it now is because they could decide to not call her.
That too.
That's the big
That
one.
too.
Or they could decide to avoid the line of questioning entirely and have her testify to something else. I think part of the prosecution's issue is that they here's the crazy thing. I think he may have opened the door on Huber in his opening argument, now that I think about it. He loves skateboarding. He just loved to skateboard. He knew Jacob Blake. He was there to show support. Now do you get to impeach his character? Did you raise character as to why he was at this protest in the first place? Like, he's just helping out a friend. He just loves to skateboard. Now do you get to start saying, well, you know, this guy who loved to skateboard and just helping a friend has a criminal history and is engaged in further criminal acts? I don't know.
I did love his ruling on the video, though. He's like, well, you've agreed it's authentic and it's relevant. So basically, I'm making that determination now. So he can bring it in. Like, the law allows it. Why should I stop him?
All
right.
Dealing with, what do we got?
The big problem with prosecution's
Six lawyers
case,
in the room? What do you expect?
the big hurdle, I should
All
say,
right,
is the
let's,
prosecution
go
has to manage not raising the character of these people because their histories are problematic for the jury. Okay.
Good morning still for the next 10 minutes. This is my opportunity to tell you and show you what I believe the evidence will show. You've heard the state's opening statement, and now I will give mine. We have two very different outlooks on the events of August 25th of 2020. Kyle Rittenhouse was present in Kenosha, Wisconsin on the evening of August 24th. He stayed at his friend's residence, Dominic Black. He saw on the live streams and things like that the events of the 24th. He saw Car Source number one, as I refer to it, the one that's on the east side of Sheridan Road, burn. All of the automobiles burned, destroyed. He saw the looting going on. He saw the other businesses burnt down. And the next morning, he went down to downtown Kenosha to look at the damage. He stopped and he helped clean up at the old Ruther High School. I think it's called something else now. But when I was around here, it was called Ruther, and before that, Bradford. And he saw that. He met one of the owners from Car Source, and they talked. And they decided that they would offer their services, him and Dominic Black and Nick Smith, to help protect the property of Car Source. Ladies and gentlemen, the evidence will show, in spite of what the media and public statements and things like that have been, the evidence will show that Kyle Rittenhouse had strong ties to Kenosha. His father lived in Kenosha. His mother lived in Antioch, Illinois. Kyle worked here in Kenosha County at the Recplex in Pleasant Prairie as a lifeguard. He went downtown to clean up the graffiti. Him and Nick left there, and they decided to come back that evening and help Car Source Lot 2, which is at 59th and Sheridan, and initially Car Source 3 at 60th and Sheridan. And when they were doing that, they met other individuals who had come to town at the urging of websites and things like that, and then just a general, I would say, distaste for the destruction. And those guys from the West Bend area, Ryan Balch, Lukowski, Joanne Fiedler, agreed that they would all help protect the Car Source lots. And initially, they went to the lot.
Please stop starting your sentences
early in
with
the
"and."
evening. And what will end up
He does it
being,
immediately.
you will see the events of that night unfold in video and still photographs. But ultimately, what this case will come down to It isn't a whodunit, when did it happen, or anything like that. It was Kyle Rittenhouse's actions privileged under the law of self-defense? That is, that the defendant believed that there was an actual or imminent unlawful interference with his person. The defendant believed that the amount of force which he used or threatened to use.
What happened to the other guy we saw yesterday? He's still at the council table. He was better.
The interference, and that his belief was reasonable. You as jurors will end up looking at it from the standpoint of a 17-year-old under the circumstances as they existed on August 25th of 2020. And Mr. Binger makes a big thing out of Kyle Rittenhouse was the only person who shot somebody that evening. True. Mr. Rittenhouse was the only person who was chased by Joseph Rosenbaum that evening. This is Joseph Rosenbaum. And what's important in this photograph,
as unbearable
is,
as this
one,
guy sounds, you got to remember he sounds like a Wisconsin.
Throughout the course of trial,
and these people
notice
all
the
live
belt,
in Wisconsin.
The baggy, lengthy jeans, and there will be a fair amount of testimony, I'm sure, regarding the maroon shirt. He's obviously currently wearing it. Mr. Rosenbaum was at a location, and Mr. Rosenbaum had, along with other individuals, started a dumpster on fire. And when somebody put that dumpster that was very close to a gas station out, Mr. Rosenbaum became enraged.
I wish we could see the video. Was that Colin Kaepernick in the video?
Does it sound on?
I just saw a giant afro.
That's just a brief snippet of that.
They got the shoot me
interaction.
N-words in there.
And he was upset, and he's yelling that he wants to be shot. And you'll see individuals in the full video, which you'll see in the course of the trial.
I'm going to start making a note every time he starts
holding him back, trying to stop him from getting at an individual who is dressed with a baseball cap, an AR rifle, and long pants. Excuse me, short pants, who looks very much like Kyle Rittenhouse. Here's Mr. Rosenbaum during the evening. Him and his friend or associate, Joshua Zeminski, had just come from starting a trailer on fire. He arms himself with a chain and goes up and down Sheridan Road, carrying this rather heavy chain used to tie down equipment.
There's 4 minutes left to be at 10
Next is a
minutes.
still photograph taken from the ultimate gas station where he was shouting, "Shoot me, nigger, shoot me, nigger," at a Black Lives rally. Who is that behind him? Joshua Zeminski. The evidence will show that Mr. Zeminski, also named as Alec Blaine, and Mr. Rosenbaum are together.
He dropped the hard R.
Joshua Zeminski plays a central role in this scenario on August 25th. One, creating chaos and havoc with Mr. Rosenbaum. And two, more importantly, when we finally get to car source number 3, Mr. Zeminski is the individual who fires the first shot that evening behind Kyle Rittenhouse as he's being chased by Mr. Rosenbaum. Here's a picture with 2 circles. Mr. Rosenbaum and Mr. Zeminski starting the trailer on fire on Sheridan Road along with a dumpster. You see the photograph, the second one circled. The testimony will show that that is in fact Mr. Rosenbaum wearing a blue mask, not his shirt over his head, and carrying a bag, which I'm sure there will be much testimony about. Other individuals.
Sorry, he's salty as hell.
Once again, Mr. Zeminski. In the photograph taken at the Ultimate, this is a still from one of the videos you'll get to see, is Mr. Zeminski armed with the weapon that he ultimately fires at the car source 3. The individual with the red hair is Kelly Zeminski. She has a backpack and there's a circle on her hand with a big, heavy flashlight. As you can see, there was no need that evening for a flashlight other than it being a weapon. Count 2 is an individual by the name of Richard McGinnis. He was a
There's
reporter
no need for a flashlight at night?
covering the riots in Kenosha. He had covered the
Well, it's all the
riots in
arson.
Portland, Minneapolis. And he will tell you what he's called to the witness stand by either the state or myself, that he was dressed like this that night. The black t-shirt with the white back, the helmet on his head. And he had interviewed Kyle Rittenhouse and talked to him. And Mr. Balch and Rittenhouse were going to go out and see if anybody needed medical attention that evening. And Richie McGinnis was going to follow along. He will testify that he goes out with them and eventually they have an interaction with the individual who we refer to as Yellow Pants Man. This is Gage Grosskreutz, the individual who is the victim, or excuse me, the complaining witness in count 5. I apologize. And in that photograph, you see that he's wearing a backpack and he has his cell phone in his hand as he does throughout the evening filming. Photograph 10, excuse me, the next photograph, is the evidence will show Gage Grosskreutz running down Sheridan Road, and you see his hand going into the back of his waistband, pulling out a firearm to arm himself. The evidence will show through testimony of an individual by the name of Nathan DeBrune that that yellow dot right up there is where Kyle Rittenhouse
You mentioned the word
is.
victim, which I
They
missed,
chased him
but
down
apparently.
Sheridan Road. Mr. Grosskreutz is not in any danger. Kyle Rittenhouse has already told him that he's going to turn himself into the police, yet he arms and continues with the mob to attack. This is a picture of Anthony Huber, the individual who attacks my client as he's laying on the ground after being kicked in the head by Jump Kick Man with his skateboard. He's hit him with the skateboard as he was running down Sheridan Road, and then as he's laying prone on the ground, he comes in for another hit on his head and then grabs Kyle Rittenhouse's firearm to try and take it away from him.
I think Jump Camp Man is one of the
The
most
next
brilliant
photograph
things the
is a
defense has
picture
done so far.
To look at the whole skateboard, the size of that skateboard, the trucks of that skateboard. Ladies and gentlemen, I would love to be able to hold up that skateboard in front of you as evidence today, because then you could see it. You could see the weight and the heft of what a skateboard is. And what that skateboard would do is somebody takes it in their hand and swings down on somebody's shoulder, head, and neck, trying to separate the head from the body, as Mr. Huber did.
He's trying to decapitate.
Here, Your Honor, this is straying beyond a characterization of the evidence, and it's Mr. Richards' interpretation as an argument.
You'll see the
What a
photographs.
fucking dick.
You'll see the videos, and ultimately, you'll.
Why doesn't he have the skateboard? He said, "I'd love to show it to you." Why don't they have it?
Trying to do. The skateboard doesn't exist because Ms. Giddings, his girlfriend, in spite of repeated requests by Detective Howard, refused to produce it. That's what the evidence will show.
Warrants, my
Mr.
friend?
Huber at the Ultimate Gas holding back Mr.
Yeah, that objection was
Rosenbaum,
overruled, but
who is ultimately
objecting it all was
the
bullshit to
individual
me.
who lit the fuse that night. Man I refer to as Jump Kick Man or the non-complaining witness. Kyle is laying on the ground after being knocked to the ground by an individual hitting him in the head with a rock, Anthony Huber hitting him with the skateboard, and Jump Kick Man comes in, kicks him square in the face with his black boot. Close-ups of that. And as he's kicking him in the face, Kyle fires 2 shots at that individual. He's not hit. He gets up and he runs away into the night, never to be seen again, never coming forward to identify himself as a victim, complaining witness or otherwise to law enforcement. We looked for him, the evidence will show. The state looked for him, the evidence will show. Those are the big players in this case. But ultimately, what you'll end up having to decide, looking at all the circumstances of that evening, are the events that occurred over really a brief 15-minute period, but more importantly, 3 minutes. The police spread or push people south to approximately 60th. That's something we can agree. There's no line set up to stop Kyle or anybody else going in a southerly direction down Sheridan Road. There's no statement that if you go in that direction, you can't come back if you have business in that direction. Kyle,
Bring it to the podium.
an individual by the name of Ryan Balch, followed by Richard McGinnis,
Or maybe you can't.
go down there, Sheridan Road. And at 11:40, they have a conversation yelling medic. And you'll see the videotape of this event. Kyle's got his medical bag, his gun, and he comes upon these 3 individuals. And the individual in the yellow pants accuses Kyle Rittenhouse of pointing a laser sight from a gun at him. Kyle shrugs it off, does not want confrontation with these individuals, does not point his firearm at them, and he leaves. Why does he leave? Because he doesn't want trouble. These are the 3 individuals who are with Yellow Pants. One individual is carrying a noose. I don't know what that's for. The other individual, the testimony will be from Kyle Rittenhouse and Richie McGinnis.
Wait,
rocks in
Kyle's
his
going to
hand.
testify?
And then the blue-shirted individual was carrying a 9mm firearm.
Is that what he said?
Richard McGinnis will tell you about
Yeah. I'm
the
concerned.
marauding nature of these individuals. He was so intimidated by them after Kyle walked away that he had to give up 2 White Claws to him to settle him down and some cigarettes so that he would be
What
able
the fuck are we talking about?
Kyle, from there, realizes he's been separated from Mr.
Calm down,
Balch.
have some White Claws.
He goes over to the Ultimate gas station looking for Mr. Balch and is unable to find him. What happens next is he attempts to get back to Car Source at 59th and Sheridan Road.
We're 4 minutes
Kyle
from
on the
20
right
minutes.
coming into the frame.
But Bingers is about 15 minutes, I think.
It was a very different experience living those 2 speeches.
I work in that business. I am at that business.
They don't let him pass. He goes back to the Ultimate gas station, and a few minutes later, at approximately 11:45, he receives a phone call from Dominic Black. Dominic Black informs him, the evidence will show, that they're breaking windows and starting fires down at Car Source 3. Go and stop them. He asks an individual for a fire extinguisher and asks the individual to go down to Car Source 3 with him. The individual gives him the fire extinguisher, but does not go with him. And Kyle heads down to Car Source 3.
So
He
he was
doesn't
requested
know
to go. That's
that Mr. Rosenbaum is down there. He's been asked to go down there by Nick Smith. He heads down Sheridan from 60th, walking to Sheridan and 63rd, where the Car Source is. That's a picture of him from a video leaving the car source at 11:46 p.m. approximately. He has his firearm, and he has, as you can see in his other hand, a fire extinguisher to put out the picture, the fires and that are being started down there. This is an aerial photograph that the state had referred to in its opening, and it's actually started to roll, and you'll see circles in here. There's Kelly Zeminski in the green lettering, and that's a thermal image, excuse me. I don't think I can start. It starts very slowly.
This is the problem with tech.
You can see people are labeled Richie McGinnis, and they head down.
Oh, this is the thermal imaging from the FBI.
Which we can't see, which is lame.
You see Mr. Rosenbaum come around. I'm hiding in the cars, beginning to chase my client. You'll see the flash of the firearm from Mr. Zabitsky.
Oh, thank God.
Oh, thank you.
See the flashes of his first shots.
Not focused at all.
I am not responsible for cutting this video. I don't know how it got the way it did chopped up. That's the FBI up in the plane that took this video. But it's very telling.
The
because
FBI
you'll see
delivered
this
an edited
100
video?
times. I'm not going to go through it again for you in opening. But you'll see it that the individuals are heading down Sheridan Road, and you'll see this.
They should have just
Mr.
objected to this
McGinnis
video.
is now over here. Go
Sure
and
they
hide
did.
right in this location. You'll see Kyle come into this area and pause where Mr. and Mrs. Zeminski are, and you'll see in this car is a fire that started. See
Move your head.
Move, Binger.
Kyle runs in this direction, trying to get away from Mr.
Oh, I'll look at this one instead.
Ladies and gentlemen, Kyle Rittenhouse is under no obligation whatsoever to retreat from Mr. Rosenbaum. He does. He runs away from him because he doesn't want a confrontation. He doesn't
I can't
want
see
trouble,
shit in this still.
which makes no sense.
Good, because the
What
jury
the
can't
state
either.
says about him hunting
If that's
or
their big
chasing
evidence, that's
him down.
actually probably great.
He's trying to get away from the individual. You'll hear testimony, not just from Kyle Rittenhouse, but Balch, Mr. Balch, about Joseph Rosenbaum
I want to take a bet on the probability the
Kyle?
cameraman shows the jury at some point.
and to Ryan Balch in each other's presence. If I get either of you two alone, I'm going to kill you. Flat out threats to murder. When Mr. Rosenbaum is shot in the car source lot 3, there's been a gunshot behind Kyle. He turns to address Mr. Rosenbaum of his firearm. Mr. Rosenbaum is not deterred. He continues to run. You'll see that on numerous videos, closing the distance. Mr. Rosenbaum could have stopped at any time. Mr. Rosenbaum is wearing that maroon shirt on his face as a mask, covering up his identity because he wants to steal my client's firearm and use it against him to carry out the threat he had made earlier. That isn't just the word of Kyle Rittenhouse made up after the fact. You'll hear the testimony of Richie McGinnis, who was close that evening. He was following behind them. You'll see him on the video. He'll testify to you in court. He did not feel endangered. He was doing his job. He will testify that Joseph Rosenbaum let out, as he put it, one of the scariest screams I ever heard, yelling, "Fuck you," and dove for Kyle Rittenhouse's gun. Kyle Rittenhouse fires. He fires 4 shots at Joseph Rosenbaum. The state wishes to slow everything down into a microsecond. Those 4
Weird
shots,
phrasing.
the evidence will show, took 0.76 of a second. 76 hundredths of a second from first shot to last shot. Those measurements will be put forth by Dr. John Black, who's a certified video examiner. He breaks every frame down. He knows how much each frame takes.
Mm-hmm.
He counts the frames and he comes up with that time.
I think that was a
That's
little
photograph
unnecessary. Just could have stopped at
11:48.
0.76 seconds.
That's car source 3. You see an individual right here with his hand in the air. The evidence will show that's Mr. Zeminski. This is Mr. Rosenbaum in full stride running after Kyle Rittenhouse. This is a still from a video. And you'll see a lot of videos leading up to this. You'll see a video, I believe it's from Corey Elijah, where he's confronted by Mr. Rosenbaum. And he doesn't want a confrontation. And he goes, you'll hear it on the video. The video is not showing that confrontation, but you hear Kyle's voice. And he goes, friendly, friendly, friendly. He thinks because he's giving medical attention and helping people out, that people don't have an animosity against him. He's wrong, but that's the belief in his head, and Mr. Rosenbaum chases after him. And I believe
Sounds like
that
Kyle's going
the
to be
state will
testifying
want
directly to
say,
his state of
why
mind. I don't
did
know
he
if
go
I agree
down
with
there?
that.
He went down there because Nick Smith asked him to. Why didn't he keep running? One, you don't have to run. But two, I'll show you a video from 63rd looking back onto the car source lot, taken by an individual who will testify and his daughter. Next
How do you
photograph,
make showing the video
circled
boring?
again.
That's what I want to know.
Zeminski with the arm up, Rosenbaum in full stride chasing and an arrow pointing to Kyle. This is the video from 63rd and Sheridan Road.
Oh shit. They shooting. Oh shit. Oh my god. I am.
Why
You'll
did you
see
say
that whole video during the trial.
What
That
does
was
that video
pointless.
show?
Individuals
What does that video
driving
show?
cars, of course, the
The video
rider
shows nothing.
destroying all of those vehicles. And as Kyle was running from Mr. Rosenbaum, he did not want to run
Maybe we
into
weren't
those
paying attention to
rioters
them
who were
bashing windows or something.
destroying all of that property that did not belong.
Should have highlighted
But
that
even if
before
people in the
showing
crowd
video.
And the
were-
first gunshot, the evidence will show Mr. Zeminski. You hear 4 shots in quick succession. The evidence will show that is Kyle firing at Mr. Rosenbaum as he's trying to take Kyle's weapon from him to use against him. You hear 3 more shots in quick succession. I don't think the government will have any dispute. I don't think the evidence will dispute. Those 3 shots are from another person who's in the car source lot firing for some reason. He was never identified, never arrested. This will show Kyle running back to the scene of the shooting. It will show, I think the evidence will show, why Kyle Rittenhouse didn't stay and render aid for Mr. Rosenbaum. Not that he's under any obligation to do that, but sometimes discretion is the better part of valor.
He fucking shot him! Get him there! He fucking shot him! He fucking shot him! He fucking shot him! Take screenshots.
How is that helpful to the defense?
That dude shot him.
Showing why
That nigga just shot that dude!
he's running.
Cranium that
Okay.
boy!
Cranium that dude. He
Individuals
just shot
were
him.
yelling, he just shot him, shoot him, and you can see one of them with a gun. Mr. and Mrs. Zeminski. He begins running down Sheridan Road. He's not taking his gun. He's not threatening anyone as he's running down Sheridan Road. He's running in a southerly, I always get my directions confused, a northerly direction from 63rd towards 60th. What is at 60th? The evidence will show that is where law enforcement is, and that's where somebody would run to be protected from a mob that wants to kill him. The evidence will show this next video taken from Gage Groskowitz.
I think we're coming up on
He
40
runs
minutes
up
here.
to Kyle. At this point, he is unarmed. Kyle does not point a firearm at him, does not do anything to dissuade him from approaching him. You'll hear on the video the exchange, and you'll see it.
Hey, what are you doing? You shot somebody? Who shot? Who shot? Hey, stop him!
You see him running with the gun at the ground away from Mr. Groskowitz. Mr. Groskowitz came up on Kyle, got very close. Did Kyle point a firearm at him? Did Kyle shoot at him? No. All he wanted to do was get to the police. But the mob is closing in, of which Mr. Groskowitz is a member. The first individual runs up behind Kyle and hits him in the head with his hand or a hand with a rock in it. The yellow circle shows Kyle being knocked a bit askew. More importantly, his hat being knocked off. He's run all this distance. His hat stayed on his head. The government doesn't want anyone to think that he's being attacked or hit. This still photograph shows that his hat is being knocked off. That's the first blow to Mr. Rittenhouse. He continues to run. The testimony will show that these individuals are running up on him. What's important in this photograph, the evidence will show, is on the left, the testimony will be Mr. Huber is picking up his skateboard. Why is his skateboard on the ground? Because he has taken his skateboard and swung it at Kyle Rittenhouse's head for the first time, hitting him in the head. And you can see in the blue circle, Kyle Rittenhouse beginning to fall down. The two red marks are one, the individual who struck him first, and Jump Kick Man closing in. Kyle goes to the ground. This is a still photo from a video you'll see. What's important here, the evidence will show, is an individual. Kyle's on the ground within 2 feet. Kyle points the firearm at him, does not fire. The individual backs up. He's no longer a threat. Kyle does not discharge his firearm. The next picture. The unidentified complaining witness, Jump Kick Man, kicking Kyle in the face. Behind Jump Kick Man is
Who jump
Huber.
kicks with their hands in their
Now he's
crotch
picked
like
up
that?
his
It's very
skateboard.
weird.
This is a photograph from a different angle, a different individual. And you see him running in Kyle's direction. There's the boot right before contact. Those are the boots that struck Kyle Rittenhouse in the face. Here is the photograph. Mr. Huber's bare hand on the skateboard, holding the trucks, bringing it into contact with the back of Kyle Rittenhouse's
Don't
head.
call them trucks.
Jump Kick Man still has not even gotten completely on the ground. And where is Mr. Huber's hand? And it's important here, ladies and gentlemen, it's a bare hand grabbing his gun. The state will produce evidence, I believe, that there's no DNA on the gun. He must not have touched it. Ladies and gentlemen, there's video photographic evidence of him touching the gun. Next, the bare hand pulling the gun towards him.
Oh,
Jump
damn,
Kick
that's
Man
a good
getting up
angle.
to run away. You can see a close-up, the bare hand on the gun. Kyle Rittenhouse flat on his back, in the most vulnerable position one can be in.
That's,
There, the strap is pulled tight.
that's about as
Mr.
self-defensey
Huber's
as you
trying to
can
pull
get,
the
in all
gun away
honesty.
from Kyle Rittenhouse as he's laying flat on his back. Kyle's afraid he's going to be disarmed and shot with his own weapon. The evidence will show he fires one shot, striking Mr. Huber. In this photograph, just entering from the right, the evidence will show is Gage Grosskreutz. One hand, a phone, one hand, a firearm. Here's Gage Grosskreutz with his hands up. Kyle Rittenhouse does not fire. Look at the distance between them. Huber's skateboard has not even hit the ground yet. That's how fast all these things occur. Mr. Grosskreutz does not stay in that position or back up. He moves in on Kyle, getting closer, pointing the gun almost directly at his head. As the state said, he's like this, but look at where the gun is going. The gun is in the circle. It hasn't got directly to pointing at Kyle's head, but it's going there. Kyle fires once, hitting him. Another individual approaches after Gage Grosskreutz has been shot, puts his hands up. Kyle Rittenhouse does nothing. In that events, in event number 2, the whole event from first shot with Mr. Grosskreutz, jump kick man coming in and getting the 2 shots to the time Gage Grosskreutz is shot in the arm is about 5 seconds. You'll have exact times of those shots, how fast it occurs. And after the shooting that evening, Mr. Grosskreutz was interviewed.
Ooh.
He told law enforcement his story of that evening.
Is he going to say what he said?
One interesting detail he forgot to mention was that he was armed when he got shot. He told the police that he had lost his gun as he was running down Sheridan Avenue. He didn't know that there were people out there like him videotaping and photographing everything. He had a gun in his hand, and that's why he shot. His statement says that the reason he went into the fray was because he had to stop Anthony Huber from beating Kyle with the skateboard. At 11:51,
Really?
Kyle has gotten up. There are individuals around
Why is that defense?
in that area who've come at him. He's pointed his firearm, backed them off, and he continues in a northerly direction down Sheridan Road to 60th.
Hey, he just shot them! Hey, dude right here just shot them! Dude right here just shot all of them down there! That dude just shot them right there! That dude right here! Yeah!
You see Kyle with his hands up approach the police car to turn himself in. The evidence will show that the police told him to get away from the car and go home. The police say that they pepper sprayed Kyle. Kyle didn't get hit with the pepper spray. He's not disputing that they might have shot pepper spray at him. That's why he backed up so quickly. He finally makes his way to car source 2 back at 59th, meets up with Dominic Black,
Finger's
the
gotta be
individual who sent
seething
him
at how
down to
long
car
this
source
is right
3,
now.
tells him about what had happened. Dominic Black, I believe, will testify that he saw him. He was white as a ghost, sweating like a pig, and he was explaining what happened, saying he had to do it. It was self-defense. They talk about going home to Antioch. Dominic Black takes them home. They leave about 10 to 12. And at 1:20, Kyle Rittenhouse and his mother are walking into the Antioch Police Department, turning themselves in to the police, which is what he wanted to do here in Kenosha. But the way Kenosha was that night, with the police department surrounded by fence and things like that, he couldn't. He turned himself into law enforcement. He said from that day what he did. He's made no bones about that. He acted in self-defense, ladies and gentlemen. The evidence will show that his actions on August 25th of 2020 were reasonable under the circumstances as they existed that night, being attacked by Mr. Rosenbaum. The evidence will show, and the law is clear, he didn't endanger those other individuals. The government can refer to him all they wish as an active shooter. The only person he had shot was Joseph Rosenbaum, who had made threats to kill, had made numerous statements about ripping people's hearts out. He wasn't afraid to go back to jail. And Nathan DeBroom will testify to some of the actions of Mr. Rosenbaum that night. And he'll testify, and it was one of the more telling statements, I thought, in a statement.
He just got the back to
If there was
jail in
trouble that night, Joseph Rosenbaum was there. And that's ultimately who visited himself upon Kyle Rittenhouse. The evidence will show he thought probably that he could get that gun from Kyle Rittenhouse. He was wrong. Kyle Rittenhouse protected himself, protected his firearm so it couldn't be taken, used against him or other people from Mr. Rosenbaum who'd made threats to kill. And the other individuals who didn't see that shooting attacked him in the street like an animal. Ladies and gentlemen, that's what the evidence will show. Thank you.
Whew, 40 minutes.
Thank you, Mr.
Good prediction,
Richards.
man.
Let's break for lunch, folks. I'm going to take a vote now, and I don't want to influence by phrasing it one way or another. Are you comfortable with the temperature here? I'm going to ask how many think it's too warm, just right, or too cool. So, how many think it is too warm in here? How many think it is just right in here? 2, 4, 6. How many think it's cold in here? All right. Well, the majority is going to rule, unfortunately. But okay, thank you. We have this blower up here, which on occasion I used to, and it's gotten progressively worse over the years in terms of its enormity and intensity, but it controls the entire building. So I can't shut it. I can't ask them to shut it down because it has control over the water, the air throughout the entire building, and it's tied into what they did to the ceiling here in 1965 or so. All right. With that,
so
please
hot
don't
here.
talk about the case during the break. And is it unrealistic to set a tentative start time of about 1:15? But if you
It's
folks
45
want
minutes.
more,
That's a short lunch.
that's okay. Just let me know if you want more time, and then we'll use this as a trial for the future. If you decide you wanted to go less time too, we could do that. But right now we'll aim for 1:15. And any questions? Okay, thank you very much.
Okay. So since I went first last time, why don't you go first this time?
Way too long. Way too long. It took him almost 20 minutes to get to the meat of his opening statement. What he should do is he should go back and reconsider and edit out that first 20 minutes, because his last 20 minutes was pretty good because of some of the photos and the video and his statements. I think this is the risk with using tech in making these opening statements. It becomes a crutch, and you can use it way too long, way too much. You can include stuff that isn't really useful. One of the videos is supposed to show us that these people are breaking windows. You can't tell it. And he says afterwards, oh, that's what it showed. These are breaking windows. It's like, well, but I didn't see that when I watched the video. You told me after that's what I was supposed to see. That stuff was a mess. So the 41 exhibits or pictures, they weren't exhibits yet. The 41 pictures and videos, too much. But some of his stuff about Rosenbaum was great. So his stuff about Huber and Gage Grosquit's statement that he was there to stop Huber from hurting Kyle Rittenhouse, fantastic. Be very interesting to see how that pans out as it's introduced. He managed to get the Rosenbaum not wanting to go back to jail, or being okay with going back to jail, getting in there. Like, he got that in, which will be an interesting perhaps segue into getting ultimately the reasons that Rosenbaum would have been at jail or at the mental hospital into the case in general. So the thing I said on Twitter was this: the prosecution had a better opening statement. I don't know how you could watch those two and say that the prosecution didn't. He just did a better job. It was more concise. It was easier to follow. But the defense has a better case, and they laid that case out really well in this opening statement, even if it took forever to do. So we'll see how that goes. But I think on opening statement judgment alone, prosecution's was better by far. What did you think?
Yeah, so I'll just preface this by saying because there was some speculation in the chat about my personal knowledge of the case. I'm fairly familiar with the case. I've covered it on my channel, and I've been on the view that Kyle Rittenhouse has a valid self-defense claim. I've said it many times that I think it's a valid self-defense claim. So I have to, but what I have to do when I'm analyzing this is I have to put myself in the position of the jury, because the jury is supposed to look at the evidence only from what's in court. So to the extent they know anything, they're supposed to disregard that and not only look at what's being presented before them. So I have to put myself in that position when I'm analyzing this. For me, I thought this opening was like a 3 out of 10, possibly 2 out of 10, where the prosecution was 9. There were just a multitude of problems that I wrote down. The biggest overall problem, there are two big overall problems. One was the run-on sentences. There's just sentences that went on forever, and beginning new sentences with "and." The other big problem was he had no storytelling. He had no narrative architecture. This is what the prosecution did so well. They had a story, and they went through the story in a time sequence and with plot points and things that showed a direction and a narrative architecture. For me, the defense lawyer was presenting information, but there was no coherent or cohesive theme that was driving what he was saying. And also, unlike the prosecution statement felt like it was planned and rehearsed, and it didn't come off as rehearsed. What I mean by that is it seemed like something he had worked on and really gotten the wording down and gotten the timing down. It seemed like he could do it basically from memory. He had that statement down. The defense seemed like they were making it up on the fly. I don't know if that's true or not, but that's just the way it came off, or that he's just making things up. It didn't seem planned out. There is also this point from a technical aspect of the law where the chat has pointed out that he used the word victim, apparently more than once. So this is what shifted from a 3 out of 10 opening to a 2 out of 10 opening, because I didn't catch it anytime he said it. So I'll take the chat's word for it. But if he used the word victim in relation to these people, then the state has the argument of reopening that door. And so if they're now able to refer to these people as victims going forward, he sabotaged what was a major win for him. As a comment I made earlier, it's like, how do you make the videos and photographs of the thing boring? Because it was boring. It was, and he did get better at the end. I'll give him credit for that. He got better at the end, finished okay. But the first 20, first 30 minutes really were not good. So that's what I think. If you had to base it right now, you'd say that Kyle's going down in flames, which is not my preferred conclusion, but that's where I think, yeah, I thought it was pretty bad.
I disagree with the assessment that basing it on the opening statements would say Kyle's going down in flames. I think that the prosecution delivered a better opening statement, but I don't think it was a case-winning opening statement versus the defense's opening statement, personally. I think the defense, again, had a bloated opening statement, way too much extraneous stuff.
As long as shit. I forgot to mention that too. Oh God. Yeah, it was long as hell.
Getting to the worst part for me was getting to it. That's what took so long. It's like, just get to the opening statement, please. Can we get to where your thing is? But he had too much of a lead up. But he did have some really good stuff in there, and some of those photos are fantastic. Photos from angles that I hadn't seen before, which is nice. I've watched a lot of the video, but they grabbed some really good still frames of the hand on the gun. They've got, I don't think his showing of Groskritz advancing was a very good still frame.
Yeah.
It's weird because he's like, look at how he's closer. It's like, well, you picked a completely different angled image. So I don't know that that's super helpful, but yeah, and pointing out that Gage lied about having his firearm is an interesting sort of addition there as well. So it's, and I think that's kind of important because Gage is going to be the one testifying, right? Like the other two are dead, as the prosecution is very happy to say. They're dead, so they won't be testifying. Gage will, and he's already brought up credibility issues with Gage, and I think he's on the road. Although I think it's mostly Binger's fault to bring in Rosenbaum's criminal history. And someone pointed out to me, this is something I missed in the prosecution's opening statement, which I wish I would have caught it. The prosecution said that Huber was a good guy, which is quintessential character statement that can open you up to introducing.
If he said that, yeah, that would be, yeah.
And see, that's the hard thing. The stream is being wonky.
We can go back to full screen because there's nothing to watch for a while.
Yeah. I'm actually going to switch to, whoops, wrecked. No, I'm actually going to switch to the Court TV feed.
Okay.
Instead, I've heard the Court TV has better.
And I'm not, please understand, when I'm giving assessment, I'm basing it off of what has been said in court up to this point, because that's what the jury has to do. Where are we right now? So am I saying that Kyle is toast? When I said that, did I mean based on everything that will be admitted? No, I thought I was fairly clear, but I'll say it again. I was basing it based on what we know up to this point, because the jury at least is supposed to conceptually block everything out of their mind except what's been offered in court. So all the jury knows is the opening statements up to this point. So based on that, how would you rate it? And I was like, well, based on that, Kyle's toast, which was my assessment, although Nick disagrees. He thought it was stronger, which is a valid disagreement of opinion.
No, I didn't think the opening statement was stronger. I just think the case overall is stronger. That the
yeah. So I wasn't speaking to the case overall. I was speaking to what we know so far.
Right.
So yeah, when the witnesses testify, and maybe if this guy's going to be doing the case principally, maybe he's a lot better at questioning than he is at opening statements. I mean, different lawyers have different strengths. So as the evidence gets revealed and as the witnesses testify, the case hopefully for Rittenhouse will be a lot stronger, because I continue to think, based on all the knowledge we have, that Rittenhouse is not guilty. So hopefully that will become manifest throughout the trial. And hopefully someone else closes, would be my thought. But the opening alone is not working great.
So it turns out the state's opening video on Court TV is 34 minutes, 22 seconds. So if that's the case...
How long did they say?
I clocked it at 40 minutes, almost to the minute on the defenses. So if 34 minutes to 40 minutes is I didn't realize the states was that long.
It didn't feel that long if it was that long. It felt shorter.
Yeah. So I'm checking the two ends of the video here, and yeah, it's the entire 34 minutes for the state. So the defense's was only 6 minutes longer. It felt a lot longer to me. Of course, that was my I guess I'll have to see when they release the actual time-stamped video of it. But Court TV doesn't actually have a live stream up right now, so we'll have to wait and see. Someone on Twitter mentioned that they have better view of the exhibits. And after opening statements, I guess the state's going to start its case in chief, right?
Presumably. That'd be the
should
next
be-
logical thing to do. Call your first witness.
Yeah, we'll hear our first witness and see how that goes.
And people might disagree on the assessment, and perhaps the jury disagrees. I mean, we don't know what's in their head. I was just trying to give my best assessment of where we're sitting.
We're giving our opinions, and
maybe a little bit overcompensating because I'm so pro Kyle that maybe I'm a little bit overcompensating in trying to go the other way to be as fair. But
yeah, the other thing. The thing that I brought up in the middle, which I do think is important, in places.
Oh, and Kyle's going to testify. Apparently, we should talk about. Finish your thought.
Yeah, we got to talk about that. One thing to remember: if there's a place with various stereotypical accents, like the movie Fargo, for example, or just Mark Richards talking, it may be annoying or grating to hear a thick Wisconsin accent. To me, who's in Minnesota, thick Minnesota accents are different, but also grating. But I'm from Texas. You're not up in Wisconsin or Minnesota. So it may be annoying to us, but to the people that are sitting there in the jury box, most of them, if they don't talk like that, their dad does, their uncle does, their brother does, their mechanic, their priest, whatever. These people are used to these kinds of accents. So he's got that, it's like a weird mix of Chicago and Wisconsin thrown together. And so it's an annoying thing, and he sounds really weird, and he draws out his words, and he starts every sentence with "and." But I think those affectations are probably pretty normal for the people who are sitting in the jury box.
Maybe that's fair. Maybe they will respond to that more based on their local, dialects and patterns. That's a fair point. But we have to go with the biggest reveal, which is apparently Kyle's going to testify now. Apparently, this is the thing.
Oh, I hope not. I mean, it can be done, but I think it's too risky. I don't see why you would. The only thing I could see that as to the idea of why you would have Kyle testify is to get his state of mind on the record from him. But that opens him up to credibility issues. It potentially opens the door to the other acts evidence that they've already successfully had excluded, rightfully so. But if Kyle makes any sort of statement into well, I've never really been in a fight before, or, I was scared because I'm not used to fighting, then the defense gets to bring in that video of him clocking that chick in the face, right? Like that. Yeah. That's a lot of risk. I don't know. I don't think I would do it. It's so far in what I've seen in this case, there's no reason to get Kyle's state of mind evidence from Kyle because the prosecution doesn't have any good evidence about his state of mind.
The problem also is with this particular prosecutor, because the standard reason that lawyers counsel again is because the prosecutor can usually do something to make you look guilty. And I have more confidence in this prosecutor than your standard prosecutor being able to do that. Because it just seems more with his game to my mind. So the idea that he can extract statements from Kyle that will seem damning, that he can use in his closing, doesn't seem that far-fetched to me. So, and as you point out, there are other things that Kyle could say that he could open doors to things that would allow things that otherwise are not admissible to become admissible.
Right.
So
now,
if he has a real prospect of saying something.
It's important to note that Richards very likely, as he did several times during his opening statement, could have misspoken, and that he doesn't intend
Fair
to
enough.
have Kyle Rittenhouse, because he mentioned it in the context of another person testifying as well. He might have just said, as my client, as this person will testify, as a mistake. So we're going to the conclusion that Kyle will testify based on what he said here. He maybe misspoke or misstated. I hope Kyle does not testify. I don't think it's necessary for him to do so in this case. There's plenty of statements from the deceased. There's statements from Gage Grosskreutz that support Kyle's state of mind, and I think that's important.
Yeah. I know continually that I'm getting a lot of criticism from the chat, so I'm not sure if I'm not explaining myself correctly or
No, it's just
I
a
am
charged
explaining myself
topic,
correctly and they hate me.
It's a charged topic, so people want Kyle to win.
I want Kyle to win.
Yes,
I want Kyle to win.
But it's the same thing someone else was pointing out.
I consider myself, and the chat's going to disagree with this rapidly, I'm sure, but I consider myself right-wing. I consider myself very pro-gun. And I'm just looking at this, and I've always, to this point, been like, I want Kyle to win because it seems clean to me, based on what we knew. And then I'm trying to say, okay, let me put all that aside and try to put myself in the position of a juror who's supposed to be only considering the things that they hear in court, and what do we know thus far from that frame of reference. Now, it might be true, as you've pointed out, that his mannerisms and speaking style will be more amenable to a jury based on what they're used to. I can only speak to what I can only speak to how I would react. But then again, I'm not being called from that community, so maybe there's something there that I'm not factoring into the consideration, but yeah. Neither's Nick, so we're doing our best.
This is the thing. And it's why getting things like why it was good for Richards to get the he wasn't afraid to go back to jail statement in. It's why the prosecution hits on shooting him in the back, right? Because no matter the prosecution has put the narrative in front of the jury that Kyle shot Rosenbaum in the back.
Yeah.
Now, the defense has an uphill fight to counteract that narrative, and they may be able to do so. But the jury is never going to be able to push from their mind that the first thing that they heard about Joseph Rosenbaum being shot was that he was killed from a gunshot to his back. And the jury is also not going to be able to push from their mind the fact that they heard Rosenbaum say something about going to jail. It may not come up. It may come back up. There may be argument about it. There may be an objection about it later. But in the same sense, you and I cannot take out of our minds everything that we've seen about this case up to this point. So you make a really good point about that, and that we're trying to do this, and we have to actively try and mitigate what we've seen, whereas the jury doesn't have the same level of issue. Now, they have some level of issue. We also have to mitigate the fact that we know the law and have seen, we've read statutes about it. We know common law self-defense. We've read cases about self-defense, and we're trying to take that out of our minds as we do it. So we may overcorrect or overcompensate on some of these things, or we may give too much faith to the jury too. It's 12 people that we've never met. So that's what makes juries so interesting. And the one last thing I want to say to anybody who's really dooming out about anything so far today or at any other point in the trial is this. It takes one juror for Kyle to win. It takes 12 jurors for the state to win. And that is a really big thing. If the defense is able to identify a couple jurors who seem to be following along with what they're saying and who seem to be with that, that's all they need to do. They need to feed them all of the red meat, and everybody else gets a salad. Who cares? That's how it goes.
Yeah. Some of the actual videos and photographs that were used in the opening argument, obviously, when there will be admitted as evidence and will be very persuasive ultimately. It's just the presentation framing. It's like what I said from my notes that I took. It's like, how do you make video and photographs of this boring? I wrote that down
Yeah.
with 3 question marks. So the videos and photographs speak for themselves, but the way they were presented, I was like, what now? Huh? Which I think was readily apparent. People saw me half falling asleep, which, yeah.
Well, it felt really long, and
Yeah.
I had to refocus. I mean, I have some level of ADD. I don't know how much, but I had to refocus several times to try and follow because, oh boy, it was long statement. It was jumbled. It felt disorganized, and that presentation factors into
Yeah.
how much attention people were paying. I do think that he got a lot of the garbage out first, and that his ending was stronger. I just wish he would have. I wish he could have made that a little more concise. And I think he should have gotten rid of some of the videos and some of the photos to pick up the speed
Yeah.
on that. But
Yeah.
we'll have to see. I mean, we won't actually ever see the result of how this particular thing played in the mind of the jury, which is an artifact of how this all works. But
Sure.
we'll have to see as the case keeps going. Did you need a
and
break
it might,
or
it
anything?
might-
Oh,
yeah, it
sorry,
might very
go
well
ahead.
get better. One will hope, because the videos and footage, as Nate has said, as I've said, as Nick has said, that all seems to show self-defense to my mind.
Yeah.
So one can only hope that the evidence will be presented when it's actually presented formally in a way that's going to stick with the jury. And please, for the love of God, get someone else to close.
Maybe Sharif C will do the closing. He's got a
He
very
seemed a lot better yesterday. I was like, where was that guy? He seemed pretty odd.
He's got a very good speaking style. He makes good arguments. But who knows what the overall strategy is. Oh, and for everybody out there saying Barnes would have done a better opening statement or whatever, Barnes was never going to give an opening statement in this case. He may not have been ever even appearing before the court, no matter what the circumstances are. So those kind of statements aren't really helpful. And someone asked who hired Richards. Well, Kyle did. Kyle's the client. He's an adult, and he's the one who presumably has control over who his counsel is. So that's one important thing to note on all of this, is that the team that is there because Kyle wants them. Kyle has had the opportunity to change teams. In fact, he did change from John Pierce to Mark Richards and Mr. Sharifsi, and he seems to have confidence in what they're doing. Kyle has resources out there to maybe change that, although I know there's some competing narrative on that, but I can't verify any of it at this time. And so it's whatever you may think about Barnes being on or off the team, and there's some legit controversy and questions about it, that would not change who's giving opening statements and how that statement went. So those types of things are important to remember. People think just because one person is an attorney on the case, that means that they would be doing all these aspects. Kyle has at least 3 attorneys if Barnes is still his civil attorney in some respect, and he may have several more. So that's not how things play out.
And as the chat pointed out, the prosecution objected during the opening, which is a dick move and tends to annoy the jury.
Yeah.
Because the opening and closing is the purpose of it is to frame the argument, right? So the opening is here's what you will hear, here's all the stuff, and put it into a frame so that everything can be understood. Because the facts by themselves, you have to put them into a frame. The prosecution put them into their frame. I thought it was a very good frame. So you put them into a frame. Here's what we'll show. At the ending is here's what was shown. It's dick move to object, and when you do that, it can make the jury hate you a little bit because you're interrupting them listening to, what's happening. So it's ill-advised.
Yeah, especially when the defense did not object to the prosecution's opening, if we're being nitpicky and technical, there were some aspects of the prosecution's case that the defense could have objected to. Would they be successful? Probably not, but they would be grounded in making the objection. It wouldn't be a sanctionable thing to do so. And they did not do that. When you combine that in, and the jury doesn't know this, but we do, which makes it extra dick move, with the fact that he raised substantially the same objection prior to prior to the actual opening statements, and it was resolved and ruled on by the judge. The fact that he would go on and say, Your Honor, I didn't think we were going to make out our whole case again in his objection during the thing. No.
The prosecution's objections at the very start were manifestly true. It's like, I didn't think we were going to argue the entire case, which we just did, basically.
Yeah, and you were overruled, or you were, I guess, overruled on your initial objection. Now you had to be overruled again in front of the jury, and that, to me, that made it extra dickish. The jury doesn't get to consider that because they don't know about those initial arguments, but we do, and we will never forget Binger.
Fair.
Real quick, do we want to address the elephant in the room? The fact that
I thought I had addressed all the elephants in the room, but there are more elephants, sure.
Richards did drop the hard R-N word a couple times. And I
only heard it the once. Was it more than once?
I think it was like twice in quick succession.
Okay.
I think it's actually, like, I laugh. I think it was actually maybe a smart move to do so. The alternative would be him saying the N-word, but I think it might have been okay for him to do it because it's shocking, jarring, and attention grabbing, and the rest of his thing was not. So very, that's my point on that, is that it's drawing extra attention to this thing that is patently offensive, that has just happened on video from one of the deceased. And that's a part of their case, is his general rowdiness and craziness. So I'm going to go with it. I wouldn't have done it. I don't think I would have done it. I think I would have said N-word. I would have played it safe.
Yeah, I think I tend to agree.
That's a tough call. Well, hey, I have to go to the bathroom. Do you need a break at all? Or are you good to hang out for a bit?
I mean, you can go to the bathroom and I can entertain the chat and defend myself more while you're in the bathroom.
Never defend. You're on the show. You don't have to defend.
Yes, but I want the chat to like me.
That's
so
true.
I have to try harder.
That's true. I just realized my headphones are on backwards, I'm pretty sure.
Okay.
Yep, backwards headphones. I'll be right back.
Okay. So it'll be just me for a while. I'm Uncivil Law, in case you haven't checked out my channel. We have over 1,000 videos dealing with legal stuff, mostly courts of appeal, U.S. Supreme Court. Oh, incidentally, while I'm thinking about it, I'm just waiting for the transcript to be synced up with the audio. The U.S. Supreme Court just had oral arguments on whole women's health and U.S. versus Texas yesterday. Those are the abortion cases coming out of Texas relation to SB 8. So I've been covering that on my channel a lot. And we will be doing a Supreme Court React where we'll be going over the oral arguments as we do and constructing them. So I'm just waiting. I have the transcript. I have the audio, but OYEZ, Oyez, it's pronounced Oyez in case you wanted to know. OYEZ.org syncs it up. So I'm just waiting for them to sync it up because it makes it a little bit easier than me trying to do it manually. So that'll be really, really exciting. So I'm looking forward to that. And I've covered the cases on my channel in depth. I basically have said that I thought what Texas was trying to do is extremely clever. And the U.S. Supreme Court seems to agree with that on the whole. So it'll be very interesting to see what happens. So all that good stuff. Also, as I'm sure some of you have noticed on my channel, we're trying a new editing format, which may or may not be a good thing. Also, someone was pointing out, it's like the color of law thing. It's like, we may not stick with it, but we try things and see how it works. And then if it doesn't work, we try different things. So also the music from some of the people I paid on Fiverr leaves a lot to be desired, but we press on. So good times. So let me just read you all the notes I had for this defense lawyer, just in order, with all the issues I had. The run-on sentences. Yeah. Vocal variety, his speech was mostly monotone. And he didn't vary his pitch. He didn't vary the loudness. He didn't vary delivery speed. It seemed to me whereas the prosecution, when he hit a strong point, he stopped. So he changed the pacing or changed things like that. It seemed to my mind the defense lawyer didn't vary his pacing. It was just a consistent throughout. He didn't vary the volume. He didn't vary the emphasis of particular words like the prosecution did. So the vocal variety was lacking. The storytelling aspects I've talked about before. This comes from trial advocacy, by the way, where, to tell a story. I mean, every trial is telling a story. Here's a whole bunch of things. What's the story behind the things? It felt very unrehearsed. It felt very like he was making it up on the fly. He mentioned the word victim, but we've covered that. The narrative is just missing. And on just a purely technical level, yes, I understand that the things on the skateboard are called trucks. I get it. I understand. But the jury doesn't understand, so it's probably ill-advised to use the word trucks. It's correct in a technical sense. It is
say
not
the
helpful
wheels
to the
or
jury.
the axles.
Just call them the wheels or the axle would have been fine. So that stuff. So I've been successfully vamping for a couple minutes now, but I could go more.
I got to get a bunch of super chats that I want to get to that I've been putting off because the court was talking. The one thing on the trucks aspect, I think you say wheels or axles in opening statement. And then I think when you're presenting evidence about the skateboard itself, you talk about the trucks, you get one out there. You bring an example of one to the court and you say, look at this. This is a hunk of metal that's attached to the skateboard. If you're hitting someone with this, it's adding weight. You might strike them with the metal. I mean, these are real dangerous things. And you bring that in. I agree. I think for opening statements, it should have just been a quick thing. I also do love, this is my favorite part of the opening statement, I have decided, was him saying that Huber was trying to literally decapitate Kyle with his skateboard. That was magnificent.
It was
remove his head from his shoulders.
I appreciate that. That was a good flavor text.
I liked it. Okay, let me read some of these chats. American Legend says, good afternoon. Kyle is no monster. He doesn't seem to be a monster. And if they, if they start really getting into it and they really probably don't want to in general. They don't want to defend him being a monster because then they open the door to character evidence that would be contrary. And that's just messy in everyone's lives. But if they need to get into it, they'll play the video of him just weeping at the police station after turning himself in and all of that stuff. There's a lot to suggest he's not a monster. Next, we've got I hate this super chat screen so much.
Is it like doing that thing where you scroll down and it automatically scrolls back up? Because that's my favorite thing.
No, for me, I scroll down and then it jumps all the way down to the bottom, and then I have to get back to it. Tommy TK says, Nick, I have agreed that the whole case hinges on Rosenbaum's death. It will imply if Kyle's an active shooter or defending himself. Can't wait to see. Next, AGK says, according to the prosecution, the Zeminski first shot. Why isn't this a felony murder case against Zeminski instead? Because they don't want to charge. So I guess the idea would be that he had a reckless discharge or a negligent discharge. That would be a felony case in Wisconsin, and then people died as a result of it. I think it's maybe a little attenuated.
The causation is slightly off, but it's a good question, though.
Yeah. Well, and the other question is, why isn't Zeminski being charged at all? And what do you think about the defense raising these issues with who's being charged and not charged as, in exchange for testimony? Like, presumably they would be, Nicholas Black, right? Mm-hmm. His friend is maybe not being charged with a straw purchase. Was he not being charged with a straw purchase in exchange for testimony for the state?
That's always a valid question to ask. Were you offered any kind of incentive to testify?
Yeah.
Not being charged would be an incentive. So, yeah, and that always goes to credibility.
Right.
Sure.
And so
yes, it's a smart thing to bring up.
Yeah, that I think is going to come up on some of these witnesses. Unpleasant Alex, welcome to the channel. Thank you. Zalowarg says, isn't this very irregular? I mean, for the defense to display what can be construed as evidence during the opening statement. Irregular, maybe. I think it's probably getting more and more common as we go. I don't like PowerPoints and tech in opening statements. I don't like that idea at all.
Oh, yeah. Well, I and as a public speaker, I'm just anti-PowerPoint altogether. I hate PowerPoint with a passion.
Yeah. Yeah, it's a weird thing because you're always doing this. You're turning away, you're disengaging, you're pointing up there, pointing over there. A lot of and even when he pulled up the self-defense thing, he then reads it to them. I hate having a PowerPoint slide read to me with a fiery passion like that. That type of stuff is why I don't like it. But I think it's going to be more and more, as courts continue to catch up on technology, I think it's going to be more and more common as we go forward. Bilbonius Bag of Donuts says, it's a bird, it's a plane. No, it's Jump Kick Man. Mithrin Emrys says, were his actions privileged, not was his actions privileged. Richards is killing me with his speaking style here.
That one you give him pass for. Wrong tense.
Yep. Yellow Flash 2 says, Kyle was only taking out the garbage. Mithrin Emrys says, FFS Richards, the term victim should never be anywhere in your mouth when talking about any of these individuals. I agree. Binger threw a hissy fit about not being able to use the term in pretrial, and you drop it like that. And the funny thing is, it might have been all that fuss over the term as to why it slipped in. That might have been the issue. Yellow Flash 2 says, let's go, Brandon. Free Kyle. Pseudo Snark says, does McInnes need to feel victimized? HR behind you. I don't know what HR behind me means, but does McInnes need to feel victimized? Maybe. I mean, it's going to go to the idea is that the state is charging Kyle with recklessly endangering McInnes, and he's going to get on the stand and testify, I didn't feel like I was in any danger. Like that's why are I'm YouTube keeps telling me that there's a live video and it's not live over and over again.
Nice.
So that's just annoying. But that's the idea is that he's going to testify that he didn't ever feel in danger. He was doing his job. That's going to undermine the credibility of that charge in general. And again, that charge is a weird one because if he shot Rosenbaum and the bullet happened to travel through him towards someone else, that's not recklessness, typically speaking. That's not recklessness as most people would think of it.
I agree.
Mithrin Emrys says, how in God's name did you already decide Kyle will testify? Stupid move. And then you are stretching this out. Get to the point. Kyle acted in self-defense. Focus on that. The rest is fluff and filler. Bad opening. Ovid says, can you fire your lawyer halfway through opening arguments? I mean, in theory, yeah, I guess. It wouldn't. I don't know if that's a good idea.
I don't know how that would work, actually.
This guy is a liability. After dropping the N-word, many jurors will be so off-put that Kyle is now kneecapped for the rest of the trial. I don't think that's actually going to be the case, personally, especially if people are right that it's 11 white women. I don't think that's actually going to bother them that much as people think. Not in Wisconsin, guys. You may think white people in the South are racist, but let me introduce you to the North. The Japanese Yakuza 1 says, after a day's work out in the rain, but I was an hour or so late and pride. Welcome back, buddy. Peter Bemis says, honestly, this may seem boring, but a lot of us saw the evidence for this a year ago. But for the jury, the mainstream media has been hiding this. Consider if this is all novel. That's a good point. You know, some of these people have not seen this evidence. We talked about that a little bit earlier. Mithrin Emrys says, took him 30 minutes to get there, but he finally started making some excellent points. Yeah.
Yep.
He's like a Wisconsin tractor. You just got to crank start it or whatever. Scipio says, is the jury live or remote? They're live. I think the opening statement is good, but the camera moves between the attorney and the live video at odds with someone's natural attention. If they're sitting live, I think this may work well. Yeah, they're live. They're there. So all they do is they turn and look at the screen as he's talking. Irby says defense had better opening statement when they went, shoot me N-word, shoot me N-word. Also check Discord DMs when you get the chance. I will. Super Iron Bob says, make Uncivil's point in opening even stronger. The jury is coming not unbiased, but coming in misinformed by mass media, and the defense should know this. That's an interesting counterpoint there. I like that. Tall Skinny Geek says, how pro-gun can Uncivil be if he doesn't have a collection of them on the wall behind him? Called out. You have been called out. Where's your giant rack of guns? Just right behind you in the frame. Like Lauren Boebert or whatever.
No, that's okay.
Have you ever seen when she does the congressional hearings and she's got like the 2 ARs crossed and the 9mm sitting? It's awesome. I love that.
Nice touch.
Ray Fernandez says the opening was so long I was able to make breakfast, vote, and install a shower head, and still had time to watch the end part. It's election day. It's election day here in Minnesota.
Yes, I voted early, so I already took care of that. Yay.
No, I didn't. I don't know if I'll get to it. Probably not. I'll be here all day. Oh, well. Rayona says, not sure if it has been like this or if it is a glitch on my app, but if you type Kyle's name on the Facebook app search button, it says 196,000 are talking about it, but it won't show anything. Seems like they are blocking it. I must correct you on something. It's not Facebook anymore. Thank you. It's Meta.
That's right. Now, did they actually change the name of Facebook, or is Meta a holding company like Alphabet? I was a little confused
I think
on that.
Meta's the holding company currently.
Yeah.
It just seems changing the name of Facebook seems like this is way off topic, but seems like a very, very poor decision to me. But I mean, maybe they're getting out ahead of the MySpace death, right? Pseudo Snark says, I don't think they should have opened stipulating Kyle's testimony. He has to testify now, or they lied to the jury. Bad move. No, that's not true. Personally, they didn't actually stipulate to it, but if they're planning on him testifying, I have a lot of questions. I don't think that's a good idea. 2% right says, Dear Mr. Rackets, before I check out and head to bed, I ask if you haven't yet to watch Pauly Shore's Jury Duty on movie night at some point during this trial.
Good call.
I love that movie. It would be great to watch, but I don't think it's on Prime. And then some Russian letters that I can't read says decap doesn't mean axe, guillotine only. There's a Lanto occipital dislocation thing as well. Yes, you'd have an internal decapitation. That is correct. That is correct. He said, he didn't say decapitation though. He literally said, use a skateboard to remove his head from his shoulders. Hold on.
I doubt they're going to start on time if I'm a betting man.
For the myocarditis after vaccination, I can
fuck.
say that
Hold
most
on.
of the cases.
I gotta mute that real quick.
Why are we talking about the CDC?
What is this doing on court TV? I gotta remove this from the screen. Now they do it. Thank you, you assholes.
How does Yahoo get into this exactly?
Yahoo is using the court TV stream apparently.
Okie doke.
I tried to find the court TV stream and they shut it down.
All right.
They're gonna start a new one. The hell is that? Are they trying to get people? Wouldn't that be a shady move, right? They're trying to get people covering the trial struck.
Because they're talking about, yeah.
Let me just give a countervailing statement. I'm not making any statements about COVID-19 or vaccinations or anything like that. I've never even heard the term myocarditis before. That was entirely Yahoo. Shut Yahoo down, not me. I did nothing wrong. That was Yahoo, and their YouTube channel needs to be shut down, not mine. I didn't do anything. Edward Redbeard says, Miles Mathis says it's all fake. No blood in video of Rosenbaum putting back of unmarked black ambulance. Blood
Oh,
pack
Lord.
on bicep. Arm should have hyperextended. Surname Rittenhouse is Jewish. All to distract from. Oh, this is it. The McMichaels trial. Yes. The Kyle Rittenhouse was a false flag event 2 years ago, or in the middle of last year. Solely
Distract
purpose
from Ahmad
to distract
Arbery?
from Ahmaud Arbery and the McMichaels trial, which they had no way of coordinating those schedules in separate states for incidents that happened completely different times. No. So long story short, let me humbly suggest no. That's funny if it's a joke.
Right,
if
give
it's
me
not a
one
joke,
second, I'll be right back.
no. Yeah, sure. Sounds good. Wow. Yeah, wreck a shoe. You're correct. Imagine from the state of the world that put us here, having to worry about a medical video that might take away your income. Yep. It's that ridiculous. It's that crazy out here right now. With this stuff, let's see. Okay. Let's see. All right. What else do we have here? I do have the stream ready to go. They've kind of fixed it. I underestimate the power to them. What is my prediction in Virginia's election? Are the Reds going to take back the governorship? I have no idea. It looked like it's polling favorably for Republicans in Virginia. You have any opinions on that?
The Virginia race, yeah, it's looking really interesting. I was a resident of Virginia for many, many years until I moved to Texas about a year and a half ago. The fact that the Democrat is on the edge is amazing. It just shows because they won by lots of points in Virginia. So the fact that it's so close,
like 8.
Yeah, I think it was 8. I was about to say 10, but I was like, that can't be that high. So I avoided saying it because I didn't want to make myself out to be a jerk. But yeah, it was the fact that it's so close, I think the Republicans are actually going to pull it out, which is amazing.
Okay, what about this? This is a completely off-topic hypothetical for you.
Okay.
Are you familiar at all with the ADA? The
Sure.
Americans with Disabilities Act?
Yes.
All right. Let's say hypothetically you're a man with a paralyzed face.
Okay.
So you probably qualify. It's something called Mobius syndrome. Probably qualify. Makes communication, eating difficult. So Disability Act qualification probably assumed.
Sure.
Okay. Let's say that you on your insides are a beautiful singer and performer, but on the outside you have trouble doing this, right? So instead you have to hire a band, for example, to perform a song that you created for America's Got Talent.
Okay.
Does America's Got Talent owe you the money that you paid the band as a reasonable accommodation for your disability, since without the band you would not be able to compete?
I think the answer is no, because the thing that's being rated is not only the composition, but the actual performance. So if you can have the same song performed by multiple different singers, that doesn't mean it's going to sound as good coming from every singer. So yeah, it's not a reasonable accommodation. Also, there's a First Amendment implication in there that would also run against the ADA analysis. So there's that.
What about if the reasonable accommodation was not to pay for the band, but to just advance you automatically to the TV judges round in 2022 rather than in 2021?
No, that's definitely not a reasonable accommodation. You're going to have to go through every step of the process that anyone else does. Now, whether or not they need to give you an accommodation as part of those process or processes but the idea that you would skip ahead is a reasonable accommodation. That's not reasonable.
Right. I think I agree with you. I don't know. I'm not an
who am I trying to convince?
No one.
Okay, just curious. Is this a hypothetical? Is this a hypothetical because someone in chat made a stupid?
No. This is a hypothetical because a stupid who's not in chat filed a federal lawsuit against America's Got Talent based on.
Oh, I need a piece of
exactly
this. I need a piece of this. Send me that thing. I want to cover that stuff.
I'll send it to you.
Yeah.
It's my man Russell Greer, the world's greatest pro se litigant, who has sued Taylor Swift, Katy Perry, Selena Gomez, a random stripper. He has done so many great things. He has lobbied actively for legalized prostitution in Utah, followed by forced prostitution and cheaper rates for disabled people to be able to have access to the prostitutes. He is phenomenal. Nothing can stop this man. No amount of discouragement, lost income, or losses in general can stop Russell Greer from going after those rights.
Okay.
He did.
I don't think forcing someone to provide that particular service is going to fly. No.
I think you need to read his pamphlet. Why I want to make it legal for your daughter to sleep with a disabled person for $500. I think you need to read that pamphlet.
Well, why prostitution should be legal is a little bit different than why they should be forced to engage with that with a disabled person. The prostitution should be legal. It's a classical libertarian argument. So that's not that hard if you want to go down that road.
What would you say to filing in small claims court a case against Taylor Swift?
I think I read this one.
Yeah, for not acknowledging your gift, right? Like you sent Taylor Swift a gift. She did not get on Instagram and acknowledge your gift. Therefore, you sued her in small claims court in Utah with the big brain plan that small claims parties are not typically represented. So therefore, Taylor Swift would be forced to come to court in Utah in person, and then you could offer to settle with her for dinner, but it's not a date.
Okay, so let's just go with basic gift theory 101. In order for something to be a gift, it has to be without consideration, which means by legal definition, you're not getting anything in exchange for it. So if you gave someone a gift and you said, I didn't get a thank you, you're not entitled to a thank you because it was a gift. So you're not entitled to anything. So, yeah.
He brought that suit in federal court in Tennessee, I believe, to try and force, through the judge's order, every celebrity to offer a disclaimer anytime they issue a thank you for a gift, that they would not always issue a thank you. And he sued Taylor Swift for this is after the small claims. He brought it to Tennessee and sued her for $100 million.
Once again, the legal definition of a gift precludes any legal expectation to anything in return. It's a gift. It's gratuitous. Yeah.
It's amazing. It's amazing. I'll send you the ADA case. It's his newest case, and it is, it is great.
Like someone said, "Oh yeah, is up on a synced argument." Excellent. I might do that tonight then. Excellent. Very good.
Wait, what?
So apparently the synced up argument. I think I was talking about this when you weren't here. I'm going to cover the U.S. versus Texas and women's health case. And I was just waiting for the OYA to sync up the transcripts, and apparently that actually happened. So I would expect then tonight we're going to do Supreme Court React and listen to the live audio.
Yeah, guys,
you're welcome to come if you just want to make your daily streams even longer.
I think that it's going to be right during my dinner.
Yeah.
But guys, if you want to check that out, that is a really interesting case going on. Kurt's channel is in the description. You just click on that tag of Uncivil Law. It'll take you right there. If you are interested in how the Supreme Court arguments went in regards to the Texas they're calling it a 6-week abortion ban, even though that's not quite accurate. But the fetal heartbeat abortion ban that's going on in Texas. that has been brought now before the Supreme Court. And this is, if I'm not mistaken, the U.S. government's case against Texas, right?
There were two cases argued. They weren't consolidated for argument. They were argued separately. Maybe there will be a consolidated opinion. But yeah, Whole Women's Health, which was the private people suing, and U.S., which is the U.S. government suing, were both heard on the first.
Yeah, that'll be
exciting.
That'll be a very, very interesting case to follow. And last time we talked about this, your prediction was that we'd get a ruling maybe by the end of November or in the middle of December.
Yeah, I still think that's right, because the timeline of the oral argument was so accelerated. What was it, like 6 days or 7 days to go from congratulations, you have a U.S. Supreme Court case to you have to argue this case? And you and I had basically a panic on stream because what?
Yeah, because how are you going to put together?
How are you going to write this? How are you going to prep for oral argument?
Yeah, on novel issues as well. Like this is new stuff, at least in regards to the government and how the government is handling that. Let me see.
So that should be a fun stream tonight, where we go over and try to pick apart those arguments.
What time is that?
Yeah, I have to set a time. Oh Lord!
Roughly, so people know.
Let's say 7 p.m. Central.
7 p.m. Central. Okay, there you go. So that'll be there. No, right after this show is done, I think at 5:30, I have to pop over to Adam Krigler, his show, and summarize what's going on in the case, and then I have to eat dinner and get ready for my 11 p.m. show.
Cool.
So I'm a busy boy today.
You are busy, but that's good. It's good to be busy.
Yeah.
Thank you for sharing the time to spend with me. It's nice. I appreciate it.
Oh, absolutely. That'll be great. Legal Mindset is going to come on for some of tomorrow's show. I don't know how much.
Excellent. That'll be fun too.
I know. I've never had him on. I've only tangentially talked to him on like an Eric Hunley show.
Yeah, I was trying to talk to him before the Eric Hunley show on the camera. It's like, oh, you should come on. And he seemed a little taken aback or something. But I would love to have him on my show too, because he seems like a really cool guy.
Oh, well, let's stop fluffing him up too much. He is still a lawyer, so I mean, come on. Cool guy? I don't know. I don't know about that. Is that even possible?
There are some cool lawyers. There must be, right?
There's got to be some somewhere. No, so this was let's see. So yeah, 40 minutes for the defense's case, 34 for Binger's. Although I do think we got to credit time served on the defense for 30 to 60 seconds for that objection as well.
Well, he did say he didn't think it would be much longer than the prosecution, so I'll give him correctness for honesty.
That's right.
Not much longer. So yeah, but those two speeches felt like very different lengths of time. That did not feel like 30 minutes or 34 minutes. It felt shorter than that.
Yeah.
Although it was still a little too long. The defense's case felt like it went on forever. Yeah.
Let's see. Are you calling it a day soon, or are you going to wait for the stream to start again? No, we're waiting for the stream to start again. We
want to hear some. We want to hear some actual witnesses who might actually be able to testify to some things.
Yeah, the court will go on until I think 4:30 or 5 p.m. Central Time. I will be here the whole time. Kurt will be here as long as he wants to be, and we'll be here for the full analysis. Nate, the lawyer, says, "What about the defense calling the men killed victim? Bad move." A very bad move.
We mentioned that. And some people in the chat were saying that the judge's order relating to victims didn't apply during opening or closing. But I can't speak to that. That doesn't seem right.
No, he said during closing you have some leeway, but I don't think during opening you had the same leeway. You have to have the facts lay it out.
So yeah, but I can tell you for absolute certainty that the prosecution is going to be arguing. They open the door for us to mention the word victim now. So now we have to have that whole argument. That's probably what we're going to do rather than calling back somebody. We're going to have a
the night of August 25th, 2020.
Okay.
We'll use that.
We're just straight into this
reference. How long before that date had you known the defendant?
Roughly 9 months.
Was that the same period of time that you were dating his sister?
Yes.
And how frequently would you see the defendant during those 9 or so months?
I mean, where the
About
hell
every
was the
day.
court feed?
You mentioned there were times when you would go down to his residence in Antioch. Is that right?
Yes.
Were there times when he would come to your stepfather's residence here in Kenosha?
Yes.
How often would that occur?
Weekly.
What sort of things did the two of you like to do together?
Everything as a kid. Hanging out, going to the lake, hunting.
This is Kyle's friend, Nicholas
Going
Black.
up north, just everything you would do growing up.
You mentioned hunting. Is that something that you and your family are interested in?
Dominic Black,
Yes.
sorry.
Tell us more about that.
We own property in Ladysmith. Every year growing up, I would go there with my stepdad and my brother and go hunt. Ever since I was a little kid.
When you say hunt, what sort of things would you hunt?
Deer, turkey, pheasant, rabbit.
Can you describe your family's property in Ladysmith for us?
Yeah, it's about, I want to say 13 acres of land with somewhat we would call a shooting range, which is like a big open gravel pit. And it's pretty secluded and private in the woods.
Now, you mentioned that the defendant was interested in hunting. Did you ever bring him along hunting up in Ladysmith?
I wouldn't say hunting. We did bring him once to go kind of just get a feel for hunting and shoot guns and just kind of get away for the weekend.
Do you remember when that was?
I would like to say a few months before everything happened.
If I said it was in early May, around May 1st of 2020, would that sound right to you?
Yes.
Now, do you remember a time in which you and the defendant were up in Ladysmith and there was some discussion about purchasing a gun?
Yes.
Can you tell us about that?
We were going up and we had stopped at a store that was local to buy like clay pigeons and ammo. Kyle had also wanted a gun similar to the one I had. He did not, or I did not have the money for it, so he said he would pay for it. I told him that wasn't a good idea. He wasn't 18, but we came to an agreement to where he could have it once he is 18. It would be kept at my house until then. So it kind of went on from there.
What kind of gun was this?
An AR-15.
Did you have one of those already?
Yes.
Did the defendant see that gun that you had?
Yes.
How did it come to be that he saw that gun?
Just from when I bought it, he had saw it at my house, or just me opening it from the box.
And he indicated to you that he wanted a similar type gun?
Yes.
Did the defendant say anything to you about why he wanted such a gun?
No.
Now, you just mentioned the fact that the defendant was not 18. How old was he in May to August of 2020?
17.
And you discussed that he couldn't have a gun because he was 18. Is that something that you and the defendant actually talked about?
Yes.
Can you tell us about those discussions?
It was more along the lines of he would be 18 soon. I told him I didn't want to do it because I knew it wasn't, obviously he can't buy it legally. We did agree that it wouldn't be his until he was 18, and he was aware of that.
Then.
And from then on, it did stay at my house.
That's not a straw purchase at all.
So
if
when
that's
you
true.
were up in Ladysmith, I think you said you went to a local store to purchase the gun. Is that correct?
Yes.
In whose name was the gun purchased?
Mine.
So you were the legal registered owner of the gun?
Yes.
Where did the money come from to get that gun?
Kyle.
After the gun was purchased in Ladysmith, did the defendant use it?
Yes.
Tell us about that.
We just target practiced. We bought a pretty good amount of ammo and just shot clay pigeons, and just went into the woods
clay
on our
pigeons with
property.
an AR?
That's weird.
Now, you mentioned earlier there was some sort of, I think you said a shooting range on the property. Is
Yes.
that right? Can you describe that for us, please?
It's about 250 yards long. It's an old gravel pit that they used to use to obviously get gravel. It kind of just turned into the shooting range for us as a big open field.
Did you and the defendant shoot your AR-15s on that shooting range?
Yes.
You mentioned it was about 250 yards long. Did you have targets that far away?
Not entirely. It was, more at the time it was just like iron sights, so that wasn't a realistic range to shoot. We would set up clay pigeons hanging on trees at the end of the range and just kind of walk a certain amount of distance until we felt comfortable it was the right spot.
Oh, okay, that makes
What would
more
you
sense.
say the farthest distance away would be that you shot targets at with your guns?
Say about 75 yards.
Were you successful in hitting what you were shooting at?
Not all the time.
I'm going to ask the detectives here to show you a couple of exhibits that have been marked as
75 yards
exhibits
isn't that far.
27 and 28.
Well,
And I'm
actually,
going
it's not
to
bad.
have them handle them for safety purposes, but I'm going to have them hold them up and show them to you, and I'm going to ask you if you can identify them for us, okay?
Okay.
And I want to represent to everyone that these items are not loaded. There are no bullets or anything like that.
Tell that to Alec Baldwin, Binger.
Please,
I believe
please.
that Detective Antaramian is holding up what is been marked as exhibit number 27. Detective, is that right? That's number 27? Okay. Do you recognize that item, Mr. Black?
Yes.
What is that?
Are you sure?
One of the AR-15s.
Do you know which one that is?
I believe it's Kyle's.
Why?
I'm not too sure.
Okay.
Okay, thank
Would it be
you.
fair to say that yours and the defendant's look very similar to one another?
Yes.
Do you remember if there are any particular markings on one or the other that would help you to identify them?
The only difference
I
was
think he just tried to
sight.
assemble it and failed.
What was the difference in the sights?
One of us had a bigger one. I don't remember which one it was.
Okay. I'll have the detective now show you the next exhibit, which is exhibit number 28.
Yeah, interesting. Well, now that Kyle is 18, one of them may be his.
Detective Antaramian
Holding a
is
gun in
now
trust for a
showing you
minor is not illegal.
Another item, which is exhibit number 28. Do you recognize that?
Not from the last time I've seen both of them, no.
Okay. And I noticed that the gun that he's holding up doesn't appear to have a scope on it. Is that right?
Yeah.
Okay. Are AR-15s the type of weapon where a scope could be added to them if need be?
Yes.
Okay, thank you, Detective. Okay. Could you grab that, please? Detective Antaramian indicates there's a scope in the box, so we're going to show that to you as well.
Got my scope in a box.
Maybe we could show Mr. Black both of the scopes, and you could tell us if you recognize which one might be yours. So, I believe Detective Antaramian is showing you one of the scopes. Are you able to recognize if that's yours or the defendant's?
That is not mine.
Okay. So that scope came
Is it the
you believe,
defendant's?
from the defendant's gun?
Yes.
Okay. And if you recall, thank you, Detective. The other weapon that we had that had a scope on it, now that you've seen this other scope, does that
Cheers,
help you
chat.
remember which gun was which?
Yes.
Okay. The other gun that we showed you, which is exhibit 27 with the scope attached on it, was that your gun?
Yes.
Okay. So these two exhibits, 27 and 28, are 27 is the first one is your AR-15, and the second one is the defendant's. Is that correct?
Yes.
How do you
Your
know
Honor, I
that?
move exhibits
Did you check the
27 and
registration
28 into
numbers?
evidence. No objection, Your Honor. Can you help us understand, Mr. Black, why you were interested in having an AR-15?
I kind of wanted like a personal project. I had mostly only had hunting guns, and I wanted to try something new to target shoot. I have a lot of family with guns like that. They kind of find it a hobby to build them up and put different attachments on them. So I figured I would try and get into it as well.
How long had you owned that AR-15?
I want to say 2-3 months
Before May or before August?
before May.
Okay. And in that time period, had you made any modifications or additions to the gun?
Just the scope.
I assume if life had kept going forward like normal, you would have continued to do so?
Yes.
Okay. We're going to talk a little bit in a few minutes about the night of August 25th. Other than that night, was there ever a time in which you went out in Kenosha holding or carrying that AR-15?
No.
How would you normally store or carry around that weapon if you did?
In my arms. I mean, if I'm driving, it would be, disassembled in the back of the car, unloaded.
maybe I was not clear on my question. I believe you said that up until the night of August 25th, you hadn't went out armed with that AR-15 in Kenosha. Is that fair to say?
Yes.
When you did have it with you in Kenosha, was it disassembled in the trunk of your car?
On the way there, yes, but once we had arrived, no.
Where did you normally keep your gun on a daily basis?
Locked up inside the house,
Whereabouts inside the house?
in the safe,
Where was that safe located?
in my dad's room.
Did you have a key to that safe?
No.
Who did?
My dad.
When you wanted to get your AR-15, did you have to get your dad's permission?
Yes.
And just so we're clear, when you say dad, that's technically your stepdad?
Yes.
Okay.
Guys, this
So,
is
for
all
example,
relevant to
in May,
foundation
when you went up to Ladysmith with the
of
defendant,
how the gun got
who all
to Kyle
came along with
Rittenhouse.
It was me, Kyle, my brother Ray, my friend Cody, and Kyle's sister.
Do you
This is
remember
not
approximately
TV
how
court.
long you
This
spent
takes
up there?
time.
I wanna
TV
say it
court
was the
takes
weekend.
20 minutes.
When you went up there, I assume you brought your AR-15.
Yes.
Did anyone else bring any other guns along with them?
Yes. We also brought like a 12 gauge hunting shotgun, and then I think my friend brought his little 22 pistol.
And I think you said earlier that your dad, your stepdad, and your brother were also interested in hunting?
Yes.
Do you recall approximately how many rounds you and the defendant would have fired off at that firing range up at the property in Ladysmith when you were there that weekend?
A lot, I would say 100, 200.
It's not a lot.
May I approach her?
Real quick, guys. Why they have his gun is because either he or his dad are also charged with the criminal act of either a straw purchase or providing a firearm to a minor. That's probably why his gun was also
Do you recognize the photograph on that document?
Yes.
Who is shown in that photograph?
Kyle.
Was that a photograph that was taken when you and the defendant were up in Ladysmith around May 1st of 2020?
Yes.
Does that photograph show the defendant holding his AR-15?
Yes.
Your Honor, I'd move exhibit number 7 into evidence.
Is there objection?
No.
No,
May I publish that to the jury, Your Honor?
no,
on
Your
screens?
Honor.
You may.
Your Honor, I don't agree with him characterizing it as a photograph. It's clearly a printed picture on paper, Your Honor.
Sometimes these TVs are too smart for us.
I've never met a TV as smart as I am, Your Honor. I'd like to object to the defense to the prosecution's statement that this TV is too smart, Your Honor. Four doors, more horse. Your Honor, I want to object. My client's TikTok name is
that
based
photograph
in
was
Red
taken when
Pill.
you were up there?
I want to say the same day we arrived.
Does that photograph show in the background there the property that your family had up in Ladysmith?
Yes.
And do you remember who it was who actually took that photograph?
Yes.
Who was it?
My friend Cody.
Do you remember if that was before or after you and the defendant went to the firing range and
This is before.
practiced? Okay. All right. Thank you.
They brought that in just to put in the 4 doors more horse
After
thing. That's the reason
you
they
and the
brought that in.
defendant
funny.
returned to Kenosha from Ladysmith, and the defendant
In the line, bruh, I'm just
you-
trying to
you
be
purchased
famous.
this gun for the defendant.
Mission
What
accomplished.
happened to the gun after that?
It was locked up in the safe.
Which safe is that?
The one in the garage. It was the one that required a code to open.
That's the garage at your father's place?
Yes.
Here in Kenosha?
Yes.
Stepfather? I'm going to use that interchangeably, but technically that's your stepfather, correct?
Yes.
Okay, thank you, Judge.
No one's confused.
Did you have a code to open that safe?
No.
Who did?
Only my stepdad.
So the defendant didn't either.
No.
Why didn't the defendant take that AR-15 back to Antioch with him?
Because we had an agreement that he wouldn't do that.
What was the reason why?
He was 17.
Was the defendant
It wasn't his gun.
accepting of that? Did he understand that?
Yes.
You said it wouldn't be
Do
his
you
gun.
recall
till he was
having any
18.
discussions with his mom about that?
Not me personally,
I want to talk about the time period between when you came back from Ladysmith in early May and the night of August 25th, 2020. In that period of time, did the defendant ever possess that AR-15?
No.
On the day of August 25th, 2020, the day when all this stuff happened, did he possess that gun?
Yes.
How did it come to be that he gained possession of that gun on August 25th?
My dad had took a lot of the weapons we had out of the safe due to all the rioting and stashed them inside the house in case somebody were to come break into our house.
What?
And that gun happened to be one of those weapons.
Okay.
Do you know?
Why would you
how
take them out of the safe if you're worried about rioting?
I do not. All I'm aware of is that it was downstairs.
When did you first see the defendant with that weapon that day?
When I was in the kitchen. So about, I want to say a few hours before we left.
And tell us what you saw when you were in the kitchen.
I saw him coming up the stairs with it.
With the AR-15?
Yes.
Did you hear him ask you permission to take that gun?
No.
Did you hear him ask permission from your father?
Fair.
No.
When the defendant came upstairs with that gun,
This is his
what,
defense
if
and his
anything,
other
did he do
crime
with it?
right here.
I believe he set it down on the table and started looking for medical supplies.
What do you mean by medical supplies?
Like bandages, rubbing alcohol, certain things like that.
Do you know why he was doing that?
Yes, in case somebody was hurt downtown.
We've seen some photographs that night of the defendant with a bag that looks like a medic bag. Do you remember him having that night?
Yes.
On that night?
He's not pleading the fifth, guys, because he's likely getting
Do
a
you
deal
know
to
what was
provide
in
this
that bag?
testimony.
All the medical supplies that he was gathering.
Were those medical supplies gathered from your house?
Yes.
Do you know if the defendant got any medical supplies from Walgreens or any other store or anything like that, or was it just all from your house?
I know there wasn't any from any store, but I'm unaware of anything that happened after we had got to the lake.
So I believe you described that the defendant took the gun into the kitchen, put it on the table. He was gathering some medical supplies. Is that fair to say?
Yes.
What happened after that?
We proceeded to get ready and then we went down to the lake.
Say we, who do you mean?
Me and Kyle.
Where did you go when you went down by the lake?
At first we had parked by a friend's house and then we walked to, I want to say, the back parking lot of Ruther.
And what did you do there?
We met up with our friend Nick and then we proceeded to go to the car source locations.
Not me, I don't think.
When you
I
say
wasn't
Nick, do you
there.
mean Nick Smith?
Yes.
Oh, whew.
When you say car source locations, we've heard some testimony about 3 different locations. Can you help us to understand which one you're talking about?
The first one we went to was the one that would be closest to us right now. So further south.
I apologize. I was a little distracted there. Can you tell me again, which was the first one you went to?
The one that was further south.
63rd and Sheridan? Does that
Yes.
sound right? And when you say we went there, was that the defendant, you and Nick Smith?
Yes.
What happened then?
Then we met the owner once again, and he gave us a ride to the north location and dropped us off.
Okay, I'm sorry. You say you met the owner once again. When was the first time that you met him?
Previously in the day, I want to say it was around morning time when we were cleaning up all the graffiti.
So maybe I've jumped around a little bit, so I want to make things clear. If I could have just 1 second.
Real quick, this is all relevant to the Kyle illegal possession charge.
Let's
not
start-
so much the
I
self-defense
apologize.
charges.
It's my fault. I kind of jumped in the middle of the day. So I want to start at the beginning of that day. That was
Oh my
Tuesday,
God.
August 25th, 2020, the day that all these things happened. So let me back up for a little bit so we can kind of go in chronological order. I think it's easier for everybody to follow. The night, Monday night into Tuesday, did you stay at your own home?
Yes.
Did the defendant stay there as well?
I do not recall.
Do you remember when the first time would have been that you would have seen him on Tuesday morning?
I don't know specifically what time, but it was before noon.
When you saw him, was it at your house?
Yes.
What happened when you first saw him? What did the two of you do?
Me, him, and my brother Ray decided to go down to the lake and kind of just look at how things were, and then from there on, we decided to help clean.
When you say you went down to the lake, do you mean the actual beach lakefront, or do you mean downtown?
Downtown.
Where did you go when you went downtown the first time?
We parked right next to the car source location that had already been burnt down, and then we walked across Sheridan to Luther.
I'm gonna, may I approach, Your Honor? I have a map here of the area, and I'm gonna try and prop it in such a way that we can all see it. I wish I had an easel, but I don't right now. Mr. Black, I'll be a human easel for a moment. This shows the area of downtown, beginning on the north at 58th Street and going down to the south at 63rd Street. Sorry, Karen. And the area along Sheridan Road there. Do you see that, Mr. Black?
Yes.
Okay. Now,
No, I'm gonna ask you that, what happened to our easel, do we know?
Well, maybe
Back here?
upstairs.
What happened to the easel?
How do you not have an
Okay,
easel?
And then put it, because right now the defendant can't see it, and I'm required to ensure that he does, and also I can't see it either. Now, and then also, once we get that, then,
Philip Coggin says 75 yards is still blank range for most ARs.
You fair?
Random Blaze says the working girl trade is one of the oldest jobs on the planet next to farmer and cemetery work, so it should be legal. Just woke up.
is that okay?
So how's it going,
so
Rackets?
yeah, you can continue with examination on
It's
something
fine.
else,
It's
or you
right
can
here.
wait. There we are.
Kyle looked a little bit pissed at his friend there, to me.
Put it back so that the defendant can see it.
Or up
Can we
there.
maybe
Or up
angle it
there,
up
that's
there? Would that be
actually what
okay?
we use,
Yeah.
yeah, use that.
So far, the prosecution's competent. Nothing great, but nothing bad.
Yeah, and guys, I know these parts are really boring, but in court you have to lay foundation for everything you're going to get to later. They have to find out how the gun got from point A to point B. They have to find out how he got the gun in the first place. They have to establish that the gun is somehow Kyle's or not Kyle's. That's kind of a weird
Okay, thank you, Judge.
gray area here.
This makes it a lot easier. Mr. Black, I put a little laser pointer right in front of you there. Could you use that and show us on this map? I'm going to focus in on the first time you say you came down with the defendant. And I think you said, was there anyone else with you the first time, or was it just the two of you?
No, it was me, him, and my brother.
Okay.
There's another if you like. No, then you could,
Oh.
if you want.
Yeah.
Or you can use the one Sister Marcia gave me.
I don't want to be accused of using a dangerous weapon, so I'll use it as a laser pointer.
Wow.
Thank you.
Guys, this is why lawyers aren't funny, because they're not. Did you hear these jokes? And they're all
Could you please use that laser pointer and show us on this map? You said you parked near one of the car source locations when you first came down.
Yes.
Can you point out where that was?
About right. Say right here.
And for the record, you are pointing to an area that is, I believe, on 59th Street, just east of Sheridan Road. Is that correct?
Yes.
And on this map,
10
there's a
minutes later,
label
he
there of
pans
one of the
over.
car source locations at that intersection, at that corner. Do you see that?
Yes.
Okay.
Gotta be
You
real
described
careful
one of the
not to
car source
overpan the
locations
jury.
as one that had been affected by the events of the previous night. And I'm not sure what word you exactly used, but can you describe for us when you were at that particular car source location, which is on the northeast corner of 59th and Sheridan, what did you observe?
Every car was burnt to ash. There was a lot of garbage and graffiti everywhere.
Now, there's a structure on that property, an office of some sort. Did you observe that office as well?
Yes, it was burnt down.
Did you look inside?
No.
Is it fair to say that every car in that lot was burned to the chassis almost?
Yes.
Okay. Now, you indicated you parked near there and looked at that location. Is that correct?
Yes.
What did you do next?
From then we walked to, which is now Harborside.
And on that map, can you show us where that would be?
I don't know if it's on the map exactly, but it would be more south up there.
When you say south, you mean actually north?
South up there is
Yeah.
weird.
Okay.
Yeah, I'm sorry.
So you're talking about the area near Ruther High School,
Yes.
which would be right across the square from where we're at right now.
Yes.
And why was it that you walked in that direction?
We noticed there's people cleaning the graffiti, and that was my old school, so we decided to go help.
Did you help?
Yes.
And what did you do to help?
Scrub the walls.
Did the defendant help as well?
Yes.
And how much time did you spend doing that?
I want to say 2 hours, about 2.5 hours.
Did you have any supplies on your own to use to clean, or did people already have some?
They had some. I personally left by myself to go get sandpaper, and then I came back to try it.
I've never tried to clean graffiti off a wall. How does it work?
Not very well.
No, I appreciate your efforts. What happened then after that?
From then, we went back to the house and went home.
So you got back in your car and drove back to your house,
Yes.
and your brother came along?
Yes.
What happened then?
From then, that's when we ended up getting the guns.
Now, we talked earlier about a time in which the defendant came upstairs into the kitchen with his gun. He started to gather some medical supplies. Are we at that point in the chronology?
Yes.
Okay, good. Just want to make sure I've got
So
everything
we went
in
back
order.
to get our guns,
Then
but I don't know how he
let's
got
go
his.
forward from there. What happened after the defendant was gathering medical supplies? He had the gun in the kitchen. What happened then?
As soon as we were ready, we went down to the lake, and that's when we parked at Nick Smith's house.
And I don't know if it is on that map or not. Is his house located somewhere in that area?
Yeah, it's not on the map, but it would be if the map was up more.
Okay. If the map was up
If
more?
the map were up more, yes.
So your friend Nick Smith lives somewhere near this area. Is that fair to say?
Yeah, behind Ruther.
Okay. And you went to his house. Is that right?
Yes.
Who came with you?
Just me and Kyle.
Did you have your guns?
Yes.
Did you have any ammunition for your gun?
Yes.
You personally?
Yes.
Do you know if the defendant did?
Yes.
We've had some discussions at various points already in this case about a strap or some sort of device for retaining the gun. Did you have that type of item with you?
Yes.
And did the defendant?
Yes.
Do you know how those were, how you acquired those?
Yes, from Jelensky's.
When did you do that?
I want to say the middle of that day, in between us getting back from cleaning up graffiti and before we left.
So earlier you described coming down, looking at the burnt out car source location, going over to Harborside or Ruther and cleaning up some graffiti, and then leaving the downtown area. Is
Yes.
that right? Is that when you went to Jelensky's?
We did stop at the house first, and then I believe it was like an hour until we did go to Jelensky's.
When you say we, who all went to Jelensky's?
Just me and Kyle.
What was your purpose in going there?
To get a sling,
Why did you want a sling?
so we didn't have to hold it the entire time we were walking.
Do you recall if you and the defendant both got the same kind of sling?
Yes, we did.
Who actually went in and purchased the sling?
Kyle.
And after that, leaving Jelensky's, did you then go back home again?
Yes.
And that's when you acquired, or the defendant acquired the gun and the medical supplies?
Yes.
Okay. And then after that, you said you came back down to the lakefront. Is that
It's
right?
making this timeline
Yes.
real confusing.
Where did you go when you came
I
back?
swear Kyle's gotten the gun
We
like 4
went to
times
Nick
now.
Smith's, and then we met him at the Ruther parking lot. And from then on, we walked to the car's first location.
Now, I want to stop you for a second because you made a mention earlier of the owner of Car Source. Do you know that person's name?
I believe his name was Sam.
When, if at all, did you encounter him on that particular day?
We encountered him twice that day. The first time when we were cleaning graffiti on our way back to the car, when we were leaving, we stopped and talked to him. And then after we had met with Nick later that day, he had brought us to Car Source to meet with him again.
So let's talk about the first time. You described cleaning graffiti at Ruther, which is kind of at the north end of this map. Is that fair to say?
Yes.
And then you encountered the Sam on your way back to your car, which I believe you said was parked at 58th and Sheridan by that first Car Source location.
Yes.
Where in that process did you physically meet Sam?
On the corner next to Car Source, not the one that had originally got burnt down, but the next one over across the street.
Can you please use your pointer to show us where that was?
Don't bother panning, cameraman. You're not going to make it.
Corner right there.
You're pointing to the southwest corner of the intersection of 59th and Sheridan. Is that right?
Yes.
Now, did you, at this particular moment when you were meeting with Sam that day, did you observe the condition of that particular car source location?
Yes.
How did it appear to you?
It wasn't entirely destroyed, but there were some cars that were damaged.
When you say damaged, what did the damage look like?
Like kicked in doors and hoods and shattered windshields.
Did there appear to be any fire damage?
No.
What about the building? Did you make any observations of that?
It was just boarded up.
And when you talked to Sam that first time, this first conversation, what did you talk about?
We basically just talked about the defamation that he had in his the one that had actually burned down, and how much money he lost, and how deeply he would be in case all his other buildings did burn down.
And was there anything more that you talked about with him?
We did exchange phone numbers in case he needed any help.
Did you feel at that point like you wanted to help him?
I mean, my help was definitely there, but I didn't offer any help at that point.
Do you know if the defendant did?
I'm unaware.
And when you say exchange phone numbers with Sam, did you personally give him your number?
Yes.
Do you know if the defendant did?
Yes.
And then you said, we're going to fast forward a little bit because we covered some of the intervening time period. You said at some point you came back down later, you parked at Nick Smith's house, and I think you said you went to the Ruther parking lot.
Yes.
And then at some point you said you went down to Car Source. Is that right?
Yes.
Which Car Source did you go to after you left the Ruther parking lot?
The one that would be closest to Ruther, on the same side of Sheridan.
Is it that same one we were just talking about on the southwest corner of 59th and
Yes.
Sheridan? Now, do you recall approximately what time of day it was that you came back downtown?
I'd say around 5 p.m.
And you and the defendant both had your guns with you?
Yes.
And those straps?
Yes.
And I believe you said you had ammo too?
Yes.
When you met with Nick Smith in the Ruther parking lot, was there anyone else there besides the three of you?
There was some other people that we didn't know that had also showed up.
And from there, you said you walked to the Car Source at 59th and Sheridan?
Yes.
Why did you go there?
We were kind of just following Nick. About halfway there, we found out that we were meeting the owner Sam again.
Did you actually meet the owner Sam again?
We met his brother, so the other owner.
Where physically on that map can you use the pointer to show us where you actually met with the brother?
Right there.
So you're pointing again to that same Car Source at 59th and Sheridan
Yes.
on the southwest corner?
Yes.
Was when you met with him, do you remember, were you in the building? Were you outside?
We were outside.
Do you remember what you talked about?
We just talked about pretty much how to get in if we needed to, and then Nick had brought up if there was any way to get on the roof, and if there was any keys we needed to get inside.
Why were you having this discussion with the brother at that time?
Pretty much just to know where to stand, to make sure that a lot of us were safe and what we were allowed to do, and if we were allowed to go inside the building in case something happened.
So it sounds like there was some discussion of physically staying at that location.
Yes.
Why?
That's one of the locations we didn't want to end up burning down.
Was it your intention then to stay and protect that Car Source location?
Yes.
Was that something that the defendant was also planning to do, as far as you know?
Yes.
What about Nick Smith? Him too?
Yes.
Now, when the three of you, the defendant, and Nick Smith meet with this brother at that Car Source at that time, was there anyone else involved in protecting that location at that time?
Just the people we had previously met with at Ruther. They weren't exactly in the conversation with who was going where at the time.
What happened after you met with the brother at that Car Source?
Me, Kyle, and Nick had got a ride from the brother to the, I want to say,
the Wisconsin
south
grammar there
location, and then he had dropped us off there.
Could you please use your laser pointer to show us on the map where the south location is that you're talking about? And you're pointing to the Car Source location that is at the northwest corner of 63rd and Sheridan, is that right?
Yes.
And you said the brother gave you a ride in his car down there?
Yes.
When you got down there, did the brother stick around or did he leave?
He stayed for about 30 minutes and then he left.
Did you meet with anyone else down there?
Yeah, that's when a lot of people that we didn't really know had came from out of town and other cities to come help.
Do you, as you sit here today, do you remember the names of any of those people?
Very few.
What was going to be the plan for that night?
The plan was to have a decent amount of us split up between the two locations and then kind of stay there to make sure nothing bad happened.
Which location were you going to go to?
The one closest to Ruther.
The one up at 59th?
Yes.
What about the defendant?
He was going with me.
So the two of you were going to be assigned to protect the 59th Street car source.
Yes.
Was there another group that was going to be assigned to guard the 63rd Street car source?
Yes.
Do you know who any of those people were?
No.
Were those people there in person when you guys were making these plans?
Yes.
So as far as you could tell, everybody understood who was going to be at one location and who was going to be at the other?
Yes.
What did you do next?
Then we walked to the car source location closest to Ruther.
Once you got there, is that where you personally stayed for the rest of the night?
Yes.
And again, you had your gun,
Yes.
and the defendant had his as well.
Yes.
Tell us about what you did when you were at 59th Street car source.
I had climbed the ladder and got on the roof of the building to kind of just watch out for people, and that's kind of where I stayed all night.
Why did you decide to go up on the roof?
I kind of didn't want to be in the mix of a lot of problems. I didn't want to, I didn't want to get hurt. I didn't want to cause any problems. Figured it would be a lot safer up on top.
So what were you going to do?
Why did you bring your gun?
In case something bad did happen and I needed to protect myself.
When you say something bad happened, what were you worried about happening?
Anything, being shot at, somebody coming up on the roof. I mean, there's a ladder in the back, so anybody could get up. Anything.
So if someone climbed up on the roof, were you going to use that gun?
Not really. I mean, it depends what they were doing.
You talked about not wanting to be on the ground because of your concern about things happening on the ground. Did you feel that if you stayed on the ground, you would be in greater danger?
Yes.
Why was that?
People could easily get access to hurting me or coming up closer to me.
When you say people, what are you worried about?
Anyone riding, anybody that was there for the wrong intentions.
So what got it in your mind that night that you felt there would be people out on the street that would want to hurt you if you were down on the ground?
I had heard about the previous night and how it was, and I knew that there was a lot of people fighting each other and a lot of violence. So I felt it would be best that I went there if I was going to go there, making sure that I could protect myself if I needed to.
But you were also there to protect the car source location.
Yes.
How were you going to do that from up on the roof?
I'm helping anybody else that was there. I'm spotting people that were throwing things.
And then what? If you see somebody throwing something, you had a gun, were you planning on shooting them?
No. I mean, when somebody sees a weapon, they're not going to want to start any problems, obviously. If I see somebody with a weapon, I'm not going to want to initiate a problem.
Was it part of your thought process that night that by having the type of weapon you did, that it would deter others from attacking you?
That's fair to say.
Were there others in your group at 59th Street car source besides the defendant who were similarly armed?
Yes.
How many?
Everybody except for one person.
And when you say everybody, how many people are we talking about?
6 or 7.
So it's fair to say that there were, other than you and the defendant, there were another 6 or 7 people that were all carrying AR-15 type weapons.
Yes.
When you were up on the roof that night, what observations, if any, did you make about the crowd and what was going on the ground?
There's a lot of violence, a lot of screaming, a lot of people throwing things. You could definitely tell that people weren't just there for the reason they were. It wasn't a safe place to be.
For the reason they were.
Yeah, that makes sense.
I'm going to ask you a little bit about the
Really
timing
anxious
of
for
that
Cross on this kid.
And I'll represent to you that at some point in the evening there were crowds right out front of this courthouse and then there were crowds that were pushed south on Sheridan. Do you remember anything like that?
Yes.
Can you tell us in your own words, when you first got to Car Source at 59th Street, was there a lot of people out in front of the building on the street?
No.
Did that change?
Yes.
Tell us about that.
Later through on the night, the crowd got pushed back closer and closer to us.
And we say pushed back. Who was pushing them back?
The police.
And how were they doing that?
With the big trucks and a lot of rubber bullets and.
The crowd that was being pushed back, what was their behavior like when they passed in front of your location?
Very violent. Very upset.
When you say violent, can you give us examples of the type of violence you saw?
Saying a lot of threats, throwing a lot of things, a lot of things along the lines of that.
And when you say they would say a lot of threats, who were those threats directed at?
Us, the police, sometimes even people in the crowd.
Do you have any idea why the people out on the street would make any threats to your group?
I have no idea.
Did you ever see
Wants them to say 'cause they had
anyone
guns.
actually injured as a result of any of this violence that you've talked about?
No.
Did you see anyone shoot at anyone else?
No.
Did you ever consider using your gun to shoot at anyone?
No.
Was there a time in
Were you
which
chased by a
you
pedophile?
and the other members of your group observed people on the lot to the north of that location, which is marked on that map as St. James Church? Was there a time when you saw that?
Yes.
Okay. And could you just use your laser pointer and point at that St. James Church for us, please? Okay, and that's on the north side of 59th, on the northwest corner of 59th and Sheridan. Is that right?
Yes.
Yes, 59th. Now, on this map, which is a printout from a satellite, there's a structure there next to St. James Church. Was that structure standing on the night of August 25th, 2020?
No.
What was the condition of that lot?
A bunch of rubble and concrete blocks.
Now, I asked you about whether you saw folks on that lot, and I believe you said you did. Is that right?
Yes.
What did you observe about those people?
They were obviously hiding. It was pitch black outside. We couldn't see anything besides a lot of shadows hiding behind the rocks.
What action, if any, did you and the other members of your group take as a result of seeing those people hiding?
We all started yelling, telling them to stop hiding and to go away.
Did you take any physical action with your gun towards them?
We were ready in case they did have guns.
And when you say you were ready, what exactly did you do with your gun?
We had to aim them
You would point your gun at those people?
in the direction.
Did the defendant do that?
Oh,
I am unaware.
so other people
didn't
felt
see the
threatened enough to
defendant point his
raise a
gun at
gun
those
and aim
people?
it.
No, I was looking at the construction site.
And you said you saw people hiding and you didn't know whether they had guns or not?
Not until the very end.
What did you see in the very end?
As soon as they did come from hiding, they started running, and I noticed one of the people did have a gun.
What type of gun?
It looks like a similar weapon to the one me and Kyle had.
When you say you saw them running, where were they running?
They were running, I want to say west towards the lake across Sheridan.
And you said it was dark. You said you eventually saw them with a gun. When they were in that lot north of you, did you see anyone point a gun at you?
No.
Did you see anyone with a gun at that particular moment?
No.
Did anyone fire any shots?
No.
And I believe you said earlier, during this entire evening, you stayed up on the roof the whole time.
Yes.
Did you ever get down and wander off that 59th Street lot to go anywhere else?
No.
We have heard in this case, after the fact, that there were some individuals out on the street that night whose names are Anthony Huber, Joseph Rosenbaum, Gage Grosskreutz. I assume as you sit here today, you're familiar with those names.
Yes.
On that particular night, had you ever met any of those people before?
No.
Did you know any of their names?
No.
Have you since seen photographs of those people so you know what they look like?
Yes.
Thinking back to that night, Did you see any of them?
No.
Do you have any memory of seeing Joseph Rosenbaum that night?
No.
Do you have any memory of seeing Anthony Huber that night?
No.
Do you have any memory of seeing Gage Grosskreutz that night?
No.
Now,
Kyle
I
would have
asked
stayed
you a
with
little
him.
bit
He wouldn't
about
have
what
shot
you
these
observed
people.
of the crowd on the street in front of this location.
I'll just say it rather than type
Where
it.
was the
For
defendant?
those asking why the prosecutor is
crowd was
asking these questions, it appears to be
Um,
because everyone in the
Brown
crowd
vote,
felt
like, honestly.
threatened, but only Kyle shot.
Was
Therefore,
there a
Kyle is
time in which
unreasonable.
the
That seems to be
defendant
where he's
was
going.
at 59th Street when there were protesters?
It's not the
out
best
in front of that
argument, but
location?
59.
bad facts.
Your car source location.
I want to say previously right before
Right before what?
right before they had got to us.
Okay. What, if anything, did you observe the defendant doing during that time?
I noticed that as soon as they did get to us, there was somebody that was hurt, and he went and helped them and brought them back into the building. And then as soon as they were all like bandaged up, he brought them out.
Do you know what sort of injury they had suffered?
I do not.
He
And
just
when you
say
say
Kyle
you saw
rendered
them,
first aid to
go into
someone?
the building, did you actually see with your own eyes them enter the building?
Yes.
And the supplies that the defendant had in his medic bag or something, did those all come from your residence?
Yes.
Now, there came a time in which the defendant was involved in some shootings that night, and we know that. What I want to ask is, what do you remember about that time period that we now know was the time of the shootings?
I remember that one of us had received information that one of the car source dealerships was being vandalized or people were trying to burn it down. Kyle was not able to make it back to us, our location. So either me or Nick called him and told him about what was happening. And then the last I saw of him was him running towards that direction. And then from then on, I just heard gunshots.
You don't remember if you
Now,
called him?
You said you heard some information about the 63rd Street car source. Where did that information come from?
I'm unaware of that.
And you said somebody received that information. Do you recall if that was you personally who received that information?
I don't exactly know if it was me or Nick.
And you said somebody contacted the defendant. Was that over the phone?
Yes.
Do you recall who that was?
I do not.
You've given a statement about this night already to the police. Is that right?
Yes.
And you and I have talked previously with your attorney, Mr. Cotton, who's in the second row with the purple tie, about this situation, right?
Yes.
At no point did you mention to the police that you were the one who called the defendant. Is that correct?
Yes.
And at no point have you mentioned in our meetings that you were the one who called the defendant. Is that correct?
Yes.
You said you saw the defendant heading down and then you heard some gunshots. What is the next thing you remember about the defendant after that?
I didn't believe the gunshots were actually his until I got a phone call. And I answered it, and he just said, I shot somebody, and then hung up right away.
When did you see him next after that?
I want to say just a few minutes right after that.
Was that back at 59th Street?
Yeah, that was at the original location.
What observations, if any, did you make about the defendant when you saw him?
He was freaking out. He was really scared. He was pale, sweating a lot. You could tell he was just scared.
Did he say anything?
He wasn't really talking. He just said he had to do it. It was self-defense. People were trying to hurt him.
Did he ever say to you that someone was trying to attack him with a gun?
No.
Did he ever say to you that someone was trying to attack him with a knife?
No.
Did he ever say to you that anyone was trying to attack him with any sort of weapon?
No.
What happened after that?
After that, we kind of all tried to calm him down. There was some people yelling, but we kind of made the idea that he should turn himself in, but we couldn't do it in the one in Kenosha because there's people rioting at the front doors. So I took him home, and then we decided he should go turn himself in at the nearest police department.
When you say you took him home, did that mean you drove back down to Antioch?
Yes.
When you got down there, was anyone else at the defendant's residence?
No.
How long was it before anyone came back?
I want to say 5 to 10 minutes.
And who all came back at that point?
The rest of his family.
And that would be his mother and his two sisters?
Yes.
Was there any discussion at that time about what the defendant should do?
Leave, get out of town.
To where?
One of their family's properties in either Michigan or West Virginia.
What was your reaction to that?
Said no, he should turn himself in.
Were you urging the defendant to not flee, but instead to go turn himself in?
Yes.
Did he follow your advice?
Yes.
He shook his head no and said yes. That's interesting. Or maybe I missed it.
A couple more things, Mr. Black. Do you know what the defendant's occupation was around the time of August of 2020?
A lifeguard at the Rexplex.
We've seen some videos. I'll represent to you that at various points on that evening, the defendant tells people that he is an EM.
Can you flee if you're not charged
Do you know
yet?
anything about that?
I know he has some training in that type of thing.
Yes, it just might evince consciousness
that's
of guilt,
kind of
but
most of my knowledge.
Do you know whether he had ever worked as a paramedic?
No.
Do you know whether he'd ever worked as an
No, you
EMT?
don't know?
No.
No, he didn't, or no, you don't know?
Now,
yeah, the question's a little
you
bit
have talked
ambiguous.
about the fact that there was an understanding between you and the defendant that because he was 17 years old, he could not legally possess a firearm. Is that correct?
Yes.
The jury has been told, I'll represent to you, that there is a charge against the defendant in this case for possession of a weapon by someone under the age of 18. Has the person who provided the gun to the defendant, which was used to kill other people, are you facing criminal charges?
Yes.
In fact, have I not personally drafted a criminal complaint against you, charging you with 2 felony counts of providing that gun to the defendant, which were used to kill 2 separate people? Is that correct?
Yes.
And that is a case, a criminal case that I'm prosecuting that is still pending. Is that right?
Yes.
As a criminal defendant in that case, are you aware of the fact that you have a Fifth Amendment right to remain silent and not answer any questions about any of that?
Yes.
Have you decided
asked him this
today
earlier?
to come in front of this jury and tell us the truth about everything,
Yes.
despite your Fifth Amendment right?
Yes.
Have I made any promises to you about what might happen in your criminal case in exchange for your testimony today?
No.
You have an attorney here, Mr. Cotton, who is your attorney in that case. Is that right?
Yes.
You hadn't made any promises. Have you made any offers? If you're giving this kind of testimony without a promise, you're an idiot.
Yeah, since you just basically, yeah.
I mean, he's admitted to at least 1 felony so far.
Yeah.
Confer, see if there's anything else I wanted to cover. Just a couple more things, Mr. Black, that I've neglected to mention. You mentioned that you observed that the defendant was pale and sweaty. I think you said freaking out.
Palm
when he
sweaty,
came
mom
back
spaghetti.
from the shootings that night. Is that correct?
Yes.
Did you see any injuries on him?
There was some red marks on his head, but besides that, no.
Did he say anything to you about any injuries that he suffered?
Just that his head hurt.
Finally, at one point in the evening, there's some indication on some videos that there might have been some folks behind the 59th Street car source, maybe throwing some rocks or something like that. Do you remember anything about that?
Yes.
What do you remember about that?
Out of nowhere, there was like people behind us in the neighborhood throwing rocks at us on top of the roof.
What, if anything, did you do about that?
I tried to dodge them.
You had a gun, correct?
Yes.
Did you think about using that to defend yourself?
No.
Why not?
So they were just rocks. I mean, they were throwing them from a distance, so I didn't really feel like I was in like great bodily harm or being hurt.
Do you remember if the defendant
Sounded kind of
said or
coached at
did
this
anything
point.
in reaction to those folks?
No.
I have nothing further.
No,
Thank you.
he didn't, or no, I don't remember.
No, he didn't.
I have nothing further. Thank you.
Cross-examine?
Okay, prosecution was fine. Let's see what we got for a cross.
This kid's testimony in general is baffling to me without a deal.
Yes, that too.
We need a bigger podium.
Gonna need a bigger podium. We're gonna need a bigger boat. Sorry.
Dominic, excuse me, Mr. Black, I apologize. You knew Kyle Rittenhouse through his sister, Mackenzie.
Yes.
And when you were 18, 19, you were dating Mackenzie.
Yes.
And you and Kyle were good friends.
Yes.
And you referred to each other as brothers.
Yes.
And you talked about Kyle taking the gun out of your father's basement without permission. Do you remember that?
Yes.
And so up until that point, according to your testimony, you knew nothing about Kyle taking the gun down to car source that night.
No, I was definitely aware of it. I kind of never really
Good way to
went
ask that.
into the inside my mind. I never really clicked that, like, hey, he shouldn't have that.
No, what I'm getting at is whether it clicked at that point or not, it's your testimony to these 20 people from Kenosha County that you didn't know about it until he brought it up from the basement on August 25th.
Oh, yes.
You agree with that statement?
Yes.
Okay. Then can you tell me why earlier in the date you guys did go to Jelensky's, correct?
Yes.
You drove to Jelensky's.
Bought 2 slings.
Well, this was after he had brought the gun up.
That's not what your testimony was on direct examination.
I don't think there was.
That's how it went.
Okay, so he brings the gun up, you go to Jelensky's, and then go right downtown. That's what your testimony is on cross-examination.
Yes.
Okay. Whose idea was it to go to Jelensky's?
I don't recall.
But you said Kyle went into Jelensky's alone.
Yes.
And you don't know why he was going into Jelensky's?
I knew why he was going in there.
Okay, why?
To get a sling.
Okay. And then out of the goodness of his heart, he bought you one?
The plan was for both of us to get one.
Okay. So you knew he was going there to get slings, correct?
Yes.
You didn't tell him not to bring the gun, correct?
No.
Now, Kyle Rittenhouse's gun,
Does he get to touch it?
That's funny, yeah. Look at this guy cannot wear suits.
is your gun, correct?
Legally, yes.
And this is an optic on the top of that gun, correct?
Yes.
This optic, does it shoot a laser beam out of it?
Not out of it. I mean, it projects one inside of it, yes.
Right. But if I were to point this gun, and obviously I can't do it here in a courtroom, but if I were to point this gun at you from here, there would be no red or green dot on your chest.
No.
This is the optic from Kyle Rittenhouse's gun. Do you need to see it?
No.
You agree that this is?
Yes.
This does not project a laser dot on you either, correct?
No.
These
So if someone said Kyle Rittenhouse
no, it does not,
put a
or
laser from his
correct.
weapon on their chest, that's impossible, correct?
Correct.
Now,
That must be something from a
Mr.
later
Binger asked
testimony
you
he's
about
trying to
the
head off.
charges that you currently have pending against you, correct?
Yes.
And those charges are a result of you providing the gun to my client.
Yes.
And each of those is punishable by 6 years in the Wisconsin State Prison, correct?
Yes.
And you're testifying here today, hoping that Mr. Binger will give you consideration on those charges and not send you to prison, correct?
Yes.
And you
Well,
just,
well, to be precise, Mr. Binger can't send him to prison. Mr. Binger can prosecute him, and a judge could send him to prison if he's found guilty.
Mr. Binger can make a recommendation of prison.
True. And yes,
Mr. Binger can make a recommendation of prison, correct?
Yes.
And you're hoping that by you testifying, he doesn't make a recommendation of prison, correct?
Yes.
Probation.
There's no really assuming what I get out of this.
There's haven't been any promises made. I'm asking you what you're hoping.
I'm hoping for whatever the best is I get. I don't know what it is.
Okay. Your attorney, Mr. Cotton, he's met with you and Mr. Binger and the detectives?
Yes.
These are good questions.
When's the last time you guys met?
I want to say a few days before this date.
You didn't meet today?
Well, I mean, yeah, we did meet today.
When's the last time before today? Last week sometime?
Yeah.
Okay. You're aware that I asked your attorney if you'd be willing to meet with me, correct?
No.
No?
Oh.
He's looking for some sort of contradictory statement, I think.
On August 26th of 2020, you were...
It's mouthing an exhibit or something.
You were at the Antioch Police Department when Kyle turned himself in, correct?
Yes.
And you were interviewed in the early morning hours of August 26th by, I'm fine, Detective Antaranian.
Yes.
And he's the individual who's the second from closest to the jury, correct?
Yes.
You met with him for a little over an hour?
Yeah, it was well over an hour.
And that was when everything was fresh in your memory, correct?
Somewhat. I was very tired.
But it's
Yeah, it was
much nearer in time than it is today, correct?
Yes.
And you told him on that date, it was audio and videotape, what you remember, correct?
Yes.
We're going to get some of that playback coming.
Get a little impeachment going on.
Do you remember talking to Detective Antaranian and telling him whose idea it was to go to Car Source to protect the property?
Yes.
Was it, I'm going to give you three choices, yours, Kyle's, or Nick Smith's?
Nick Smith's.
Uh-oh. Is he going to just...
When you got to Car Source,
Does he not have it?
after you had stopped at Jelinski's, you meet with Nick Smith?
Yes.
And you knew that Nick had worked at Car Source?
Yeah.
And he introduced you guys to Sam and to his brother.
I wouldn't say introduced. We had met Sam previously that day, but his brother we had not met.
A lot of buildup in these questions. I'm waiting for a payoff.
Getting something marked as an exhibit.
Despite all the room that he has, it looks like he is just trying to weave his way through a crowded area.
Defendants 30. Can you tell me what that is?
This is the second location we went to when Sam, I don't remember if it was Sam or his brother, had given us a ride, me, Kyle, and Nick, to the location that would be more north. And that's where we met up with a lot of people that we really didn't know.
Okay, that would be Car Source at 63rd and Sheridan.
The one right down here.
Right here.
Yes.
Sheridan and 63rd.
Okay.
Right? The far right of that photograph, who is that depicted in the photo?
The far right?
Far left, where I'm pointing. I'm sorry.
The co-owner of Car Source?
So is that Sam or is that his brother?
I believe that's his brother.
Okay. Where are you in this picture?
The far right.
The far right?
Yes.
Who's standing next to you?
Kyle.
And what's in front of Kyle's feet?
First aid box?
Okay. that's a first aid box that is different from his first aid pack that he wears on his side, correct?
Yes.
Where is Nick Smith in this photograph?
He is 2 people to the left of Kyle wearing the white hat.
Okay, so he's got a white hat with a cross on it? Yes?
Yes.
Now, you know the owner, you know Nick, and you know Kyle. Everybody else in that photograph, had you ever seen them before that day?
No.
Did you have any plan of ever meeting up with those individuals to help protect CarSource?
No.
They just came along when you were at CarSource and offered their services to help, correct?
Yes.
Does the name Ryan Balch mean anything to you?
Yes, it's somewhat clear.
Okay. And who is Ryan Balch today to you?
I never really got to meet him a whole lot. He is one of the people that showed up randomly or unexpectedly.
And you talk about you wanting to be on the roof, correct?
Yes.
You told Nick Smith you wanted Kyle to be on the roof, correct?
Yes.
And Nick Smith said, no, we wanted Kyle on the ground
Yes.
because he's a medic and he can provide services, correct?
Yes.
You saw Kyle fix somebody's hand who had a big gash in it.
Yes.
You saw him give aid to a woman who had been shot by a gas ball.
I'm unaware of that.
Okay. You saw Kyle going out with other individuals in that picture, Exhibit 30, and put out some fires, correct?
Yes.
And did you see anybody that evening starting any fires?
Plenty of people.
Plenty of people starting fires?
Yes.
Did you see the individuals who took the trailer from the lot of rubble, put it out in the street, and started on fire?
I did not see that.
You didn't watch that?
No.
Weren't paying attention?
I don't know if I don't remember or if I missed it.
Okay. What about the porta potty?
Yes, I saw that.
Okay. Describe that.
People were tipping over a porta potty and lighting it on fire.
Okay.
Gross.
And
Ugh.
you can't, as you sit here today, say who did that, but you know what happened.
Yes.
Okay. And you don't know what Mr. Rosenbaum did or didn't do because you weren't paying attention to him.
Yes.
You don't know whether Mr. Rosenbaum, let me ask it this way, simpler. You know of nothing that happened down at the 63rd Street and Sheridan Road CarSource.
No.
Couldn't see it.
No.
Even though you're on the roof.
Yep.
Now, I'll answer it this way. Kyle's phone records have you calling him and sending him down to CarSource 3. You don't dispute that, do you?
I don't remember it.
I'm not, if his phone records say he got a phone call from Nick Smith, you don't dispute that.
Wait, what?
Not exactly, no.
Okay. And the whole idea was to send Kyle down to CarSource 3, the 63rd Street CarSource, because you guys had received a report that the people who were supposed to be protecting it had left, correct?
Yes.
And the property was being destroyed.
Yes.
You didn't know that Kyle had been separated from Mr. Balch at that point.
I did not.
So you tell him to go down there and protect that property because the cars are being bashed in, correct?
Yes.
It was either you or Nick Smith.
Yes.
And from where you were, you could see Kyle going down in that direction.
Yes.
And it wasn't the second he goes down there, you hear shots. He goes out of your view. There's a fairly lengthy period of time. You hear a gunshot, and then you hear a series of more gunshots, correct?
Yes.
And you, from where you were, could not see what happened to Kyle at the second incident, correct?
Yes.
Did not see.
I did not see.
And eventually, Kyle comes back in to your vision, correct?
Yes.
What did you observe Kyle doing as he approached? Well, let me ask you this. Where was he first?
Where I first saw him was kind of against a tree line. It was more in front of the Ultimate gas station. And I saw him walking with his gun hanging down and he had his hands up. And then I watched him walk up to a police car and then step away.
Okay.
And then
Describe what he's doing as he's going up to that police car.
I can't hear anything, but I could tell he was yelling.
Okay.
I don't know what he was yelling.
Where
But,
were his hands?
In the air.
Okay. And you saw him walk up to the police car.
Yes.
You don't hear anything, but does Kyle stay and go up to the car? What's his next movement?
He walks up to the car and very quickly he like jumps back.
Okay, like somebody told him to get back?
Yeah.
Because he walked up there voluntarily, correct?
Yes.
And then he quickly steps back.
Yes.
And he then makes his way back to car source number 2, correct?
Yes.
And he goes to that location. You guys meet up outside. You come down the ladder.
Yes, I come down the ladder. By the time I had got inside the building, he was already sitting in there.
Okay.
So they had to open the doors for him and let him in.
Okay. And you described him on August 25th, the morning of the 26th, I apologize, to Detective Antaramian as sweating like a pig. Do you remember using those words?
Yes.
White as a ghost?
Yes.
And hysterical.
Yes.
He told you he shot somebody?
Yes.
Told you he had to shoot somebody?
Yes.
With self-defense?
Yes.
Hadn't met with a lawyer, correct?
Correct.
Hadn't talked with anybody about his story. He's telling you right that day what happened.
Yes.
And you don't want to take him to the Kenosha Police Department, correct?
Yes.
Why not?
It's impossible.
You can't get to it,
Yeah,
correct?
you can't.
And if you guys walked up there with guns, you'd be a target, correct?
Yeah.
And you agree to go home to Kyle's residence, and he'll turn himself into the police there.
Yes.
And he did turn himself into the police
Yes.
an hour and a half after you finally saw him at the car source, correct?
About that time, yes.
1:20 a.m. That's what the video shows. You don't dispute that.
No.
And you talk about discussions whether or not he should leave. That was his mother who was making those discussions, correct?
Yes.
Kyle wanted to turn himself in. Correct?
Yes.
Yes?
Yes.
And he did.
Yes, you did.
Very good.
And eventually you were asked to come down to the police department, correct?
Yes.
And when you were asked to come down to the police department, you brought the guns.
No. The police had met us there at the apartment, and then they took them.
Okay. And then you drive then down to the police department
Yes.
with Kyle's 2 sisters.
Yes. No. Yeah. Yeah, I believe so.
And shortly after you get there, that's when that first interview happens with you, correct?
Yes.
And at that point, you are worried about the fact that you had given Kyle the gun, correct?
Yes.
And you talked to your girlfriend, his sister, at the police department and asked about coming up with a story to protect you regarding the guns, correct?
I do not remember that.
If she said it happened, you wouldn't disagree, correct?
I would disagree.
Okay. And
That's interesting. That was a sneaky move.
Detective Antaramian asked you a
Uncomfortable,
question
I would
on the
disagree.
morning of the 26th. So when did you first see the gun? You. About when we were getting into the car, when we walked outside the house. Detective Antaramian. Okay. Did you talk to him about it at all? No. I had a lot of stuff on my mind. You remember that exchange?
Yes.
Okay. Nothing bad had happened at that point, correct?
Correct.
So what did you have on your mind that was interfering with you saying, hey, Kyle, don't take the gun?
Kind of scared to go down there, not knowing what to expect.
You wanted Kyle to have the gun, correct?
It wasn't really an opinion in my mind at all.
You wanted a gun.
Personally, for myself, yes.
You had no objection or voiced no objection to Kyle, your brother, having the gun, correct?
It wasn't a thought in my mind.
Well, he walks out of the house with an AR-15, and you don't say boo, correct?
I didn't say anything, correct?
And you had the ability to speak.
Yes.
If you wanted to object, you could have said something to Kyle, correct?
Yes, I could have.
And you didn't.
No.
Because you wanted him to have the gun for protection.
Not that reason exactly.
You wanted a gun for protection.
Yes.
Not bad.
That's
Not
well
bad.
played by him.
Nice save.
This is a statement that you made to Detective Antaramian on the morning of the 26th. But that's what I knew of it. Basically, we go down there and we walk up, and it's coincidental. We walk up and there's Sam, and I'm like, oh, Sam, I just met you not long ago or whatever. And he gives Nick keys to the building and showed him where the ladder was, correct?
Yes.
You guys had permission to be there.
Yes.
He wanted you to protect his property.
Yes.
And he wanted protection at the 59th Street address and the 63rd Street address.
Yes.
And once you found out there wasn't any protection at the 63rd Street address, you sent Kyle down there, correct?
Yes.
Nice. Shows why Kyle moved to locations. Very good.
He's also subtly had this kid admit to sending Kyle down there.
And
not Nick Smith, but himself.
initially,
twice.
Nick was acting like he was in control of everything, correct?
Yes.
And he was leading the people from the West Bend area who you didn't know, like he was even the owner of Car Source, correct?
Yes.
He wasn't, correct?
No.
Do you remember telling Detective Antaramian the only person I saw actually help people was Kyle?
Yes.
Because he was, correct?
Yes.
He might not have been a trained EMT, but he was providing first aid.
Yes.
And that big orange box in Exhibit 30 that I showed you, that was the stuff he brought from either his house or his employment, correct?
I'm not too sure where that came from, if I'm being honest.
Do you remember telling
The only person to help.
Detective Antaramian the only person I saw actually help people was Kyle?
Yes.
Because he was, correct?
Yes.
He might not have been a trained EMT, but he was providing first
Listen to
aid.
this again.
Yes.
Yeah, I
Video
thought I
just
saw
looped
this.
back.
I thought I saw the stream
Orange
link
box
out.
in Exhibit
Yeah.
30 that I showed you, that was the stuff he brought from either his house or his employment, correct?
I'm not too sure where that came from, if I'm being honest.
Water bottle, and then poof. Detective Antaramian,
Yeah,
what
I missed it.
the bottle hit you? No, it was actually, I was on the roof, but the wind was blowing towards me, so it was a bunch of just like a tear gas bomb, just a bunch of smoke in the air. It came towards me, and my eyes started to burn. Do you remember that?
Yes.
So they were throwing gas bombs at you on the roof.
Yes.
There were gas bombs on the ground.
Yes.
Now, do you remember talking to Detective Antaramian about somebody on the roof who was upsetting you because he was taking a laser pointer, not on a gun, but a laser pointer and pointing it at people?
Yes, I do remember.
Okay, that wasn't Kyle, correct? Because he was never on the roof.
Correct.
Now, who was that?
One of the people that came from out of town. He was about in mid-30s, I want to say mid-40s. He was on the...
Is he depicted in Exhibit 30? If you have to walk closer, go ahead.
I don't think I see him. No, I don't believe so.
But it was a laser pointer, and the individual would point to demonstrators, rioters, correct?
Yes.
That upset them
Yes.
because it was pointing them out,
Yes.
and it also upset them because they could have thought it was a weapon.
Yes.
And you told him to stop,
Yes.
and he just kept laughing about it.
Yes.
Detective Antaramian asking you on the 26th, okay, anyone have an audible? Kyle, he disappears out of view. You. Nick somehow finds out that there's nobody there and there's people trying to break cars. And he tells Kyle and the other dude that he was on the ground with to go over there. So did he tell him this in person or on the phone? Phone. Do you remember that?
It was on the phone.
But you're not sure who called.
Yes, I'm not sure.
Later on in that same interview, you speaking. He was actually on the roof at that point. Nick kept on going up and down, up and down. He called Kyle. Before he called Kyle, he told me, like, there's nobody there. They're trying to set cars on fire. I was like, oh crap, oh crap. And he called Kyle and he tells him, and then Kyle starts running and he bolts for it. Do you remember telling the detective that?
Yes, no, I do.
And you
So
stated
now
you
Nick
saw him
called
run
Kyle.
from the gas station, correct?
Yes.
Could you see the fire extinguisher in his hands?
Yes.
Because you're only, if you're on the roof of the car source number 2, you're like 1 block from 60, not 1 block, less than a half a block from 60th and Sheridan Road, correct?
Yeah, that's pretty accurate.
You had a clear line of sight directly to the ultimate gas station.
Yes.
Detective Howard, to you on the 26th. What makes Ryan supposed to be with Kyle? Why do you say that? I wouldn't say supposed to, but they were with each other the entire night. Every time Kyle left, so did he. So they were always together.
Yes.
And when they're going out to provide medical attention to people, they're going out with the buddy system. Is that a fair statement?
Yeah, that's fair.
And when Kyle would go out and put out fires that were going on, he would go with somebody else, the buddy system, correct?
Oh, this is
Yes.
good.
There was a time where he left with the female Joanne Fiedler with the white helmet and went and put out a fire by the church. Do you remember that?
I believe so.
And you stated, so I figured they wanted to team up and go out and help people,
Yes.
telling the detective.
Ask why they went out in pairs. Establish that Kyle
This is
would get
Detective
scared when he's
Antaramian
alone.
questioning you on the 26th, asking you if you remember this. Okay, so then at some point, you guys, so I mean, I guess, and I'm not trying to make you look worse, but I want to make sure I'm factually accurate here. I mean, the fact that he buys the sling for his gun, it's likely he's going out to take it with him that night. Well, the intent was to buy a sling for me. You remember that exchange?
I do not.
But even Detective Antaramian questioned you about the sling and the timing of it, correct?
Yes.
And how hard was it to attach those slings?
I don't really recall.
Do you remember the detectives wanting your telephone?
My phone?
Yeah.
No, I don't believe so.
Didn't they talk to you? And I'm reading from Detective Howard at that same interview. So we're just going to apply for a search warrant. But absolutely, as it's laid out in that form, you have the right to refuse. Dominic Black. Okay, so I'm not understanding as far as what I believe. I believe I'm going to be here for a while. Okay? And I have not talked to the authorities yet, so I don't know. Do you remember the discussion about that?
Yes, I do.
Okay? And they wanted to download your phone, correct?
Yes.
Yes?
Yes.
And eventually you said to them, fine, you can download my phone. I don't have anything to hide.
Yes.
Good move.
Now,
terrible move in my opinion, but
Yeah, it's a terrible move.
never make them get the warrant. Always make them get the warrant.
And that interview regarding the incident regarding your phone, and I'm sorry if I misled you, that was the November 6th incident, correct?
Yes.
Okay. And at that point, you were already under arrest.
Yes.
And the detective, both detectives interviewed you that night.
Yes.
And when you were in that interview, as it was wrapping up, they told you to have your lawyer, who was a different lawyer than Mr. Cotton at the time, reach out to Mr. Binger. He needed to talk to him about working something out.
Yes.
Okay. And from that day, they wanted you as a witness, correct?
I wouldn't necessarily say from that day, no.
Okay. Your trial on your charges was set back in September, correct?
I don't exactly recall.
Looking to his lawyer for a nod.
Not trying to trip you up on dates. Your trial on these charges, which Mr. Binger is prosecuting you for, was before today.
Yes.
Okay. About a month and a half ago?
Yes.
Okay. And you, your lawyer, and Mr. Binger walked into this courtroom and asked that the matter be set over until January of 2022.
Yes.
After you testified here today, correct?
Yes.
Hopefully the jury's listening to this. His testimony in favor of the state is entirely suspect.
Before August 25th, 2020, that gun that Kyle Rittenhouse possessed on the night in question had never left the state of Wisconsin, correct?
Correct.
And you guys had the gun and you took it to Illinois so he could turn himself into the police.
Yes.
Okay. And you and Kyle did the taking off graffiti, correct?
Yes.
And that was in the late morning, right around lunchtime of the 25th, correct?
Correct.
And in that photograph is you, your stepfather, and your girlfriend, Mackenzie, correct?
Which photograph?
The photograph of this photograph right here.
My stepfather isn't in that picture.
He's not in that one?
No, it'd be my brother, and then Kyle and Mackenzie.
Okay.
Look
So-
at this photograph.
You are where?
It's not in that picture at all.
He's not.
Might have been when I left to go get like the sandpaper.
Okay. And Kyle's wearing the olive green shirt with his hat turned backwards.
Yes.
And who's that standing next to him?
Mackenzie?
Okay. And you guys had spent the night before at your dad's house, correct?
I'm not aware of where he slept. I don't really remember.
Could have slept at your house?
He could have.
And Mackenzie slept at your house that night.
I'm not aware. I can't remember.
Do you remember watching live streams of the riots?
No, I do not.
Did your dad talk to you about the riots and that's the reason he got the guns out?
He did previously that night, yes.
Do you remember him talking to you as you told the detectives that there was a plan to board up the windows if the rioters came?
Yes.
Okay. So all that was going on, you're aware of it.
Yes.
And when you guys are target shooting up north, there was nothing strange about that, correct?
No.
Kyle handled the gun appropriately,
Yes.
and he shot at those small little, you're saying clay pigeons,
Yes.
about 4 inches in diameter?
Yep.
You shot at the same things?
Yes.
Nothing out of the ordinary?
No.
I have nothing further, sir. Thank you.
It was a good cross.
Mm-hmm.
Good
Very
stuff for
good cross.
Kyle.
Up where that left off there, it sounds like there was a plan with your father to have the guns available, board up windows to protect the house that you live in. Is that right?
Yes.
But you decided on the night of the 25th to leave home and go downtown to protect Car Source. Is that right?
Yes.
Why didn't you stay home? Protect your house.
The riots had been going on for a while. The house had been ready to be boarded up. All the guns have been out for, I want to say, ever since the riots started, and nothing happened. I felt that the house would be safe.
The timing of all this, if I understand you correctly, is on Tuesday afternoon, late afternoon, 4 o'clock or so about, is when you and the defendant take the guns from your house and come downtown.
Yes.
Is that about right?
Yes.
You were somehow aware of stuff that had happened on Monday night and on Sunday night, right?
Yes.
That's part of the reason why you went downtown.
Yes.
But you decided at 4 o'clock on Tuesday afternoon there was no danger to your house that night?
I mean, I kind of figured, it's not just me that would be staying at the house. I have a lot of brothers that live there. It wasn't entirely my responsibility to make sure that the house was safe. I felt that it was safe. Nobody was going to harm the house. Nothing in the area had happened.
Okay. On this particular evening, when you're at the Car Source at 59th and you're up on the roof, where was Nick Smith during that evening?
He was up and down. So he was on the ground, he was on the roof, he was inside the building.
Did he ever have a gun that night?
I believe so. To the best of my memory, I think he did.
Do you remember if he had it the whole evening or just a short period of time?
I don't remember.
Is it fair to say that Nick Smith stayed at that location physically the whole night?
Yes.
And you did too?
Yes.
You've been asked by me, you've been asked by Attorney Richards, several variations of the same question. And I don't know that I think we've done some.
Don't comment on the witness's answer.
Who told the defendant to go to 63rd Street Car Source?
I'm not 100% certain.
Wasn't that you?
No, it's been both him and Nick Smith
At
so
any
far.
point that evening, did you personally receive information from any other person that there were problems at the 63rd Street Car Source?
The only person I figured that out from was Nick Smith.
Do you know where he got that information?
I do not.
To your knowledge, did he physically ever go down to 63rd Street after you got to 59th, when he finally got all set up? Did he ever leave later in the evening to go check and see what was happening at 63rd Street Car Source in person?
No.
You said at some point in the evening, someone up on the roof was using a laser pointer to aim at the crowd. Is that right?
Yes.
Okay, thank you. So we're talking about something like this, shining it on a person. Is that right?
Yes, but a lot bigger.
Okay. Was it your understanding that the people who had this pointed at him felt like that was a gun
Yes.
pointed at him? You were
Speculative.
telling us that it wasn't actually a gun, but the people on the ground thought it was.
Yes.
Speculative.
And you were upset
Yeah.
by that.
Yes.
Why?
Because he shouldn't be doing that. There's no reason for it. And it's drawing attention towards us.
I'm still
Did
curious
you
what the
feel
relevance
that
of
it
this
wasn't
laser pointer from the
appropriate
roof
for
is.
anyone on the roof or on the ground to be pointing a gun at anyone?
I think the
No,
reason
I
it's rational.
really
I
feel
think
like that
someone
was
is testifying that
necessary at all.
Kyle did it, so we have to establish who else did it.
Stated my question. Let me
I
just
think.
make sure I'm clear
Here
on
we go.
that.
Hold on.
Would you agree with me that it was not appropriate for the members in your group to be pointing their guns at people?
Yes.
You mentioned earlier when I was asking you questions that someone was throwing rocks. You said in response to Mr. Richards' questions that someone was throwing some sort of water bottle or gas bomb up on the roof. Is that right?
Yes.
When these folks were doing these things to you and the other members of your group, did you point a gun at anyone?
No.
Did you fire at anyone?
No.
Why not?
because there's no need to. I mean,
Did you feel that by these people throwing rocks at you or throwing a gas bomb at you, that you were in danger?
Pain, yes, but not danger. I knew it wasn't going to kill me.
So you felt like it wasn't enough to use deadly force?
Correct.
You were asked some questions about the discussions that you and I have had during the lead up to this case. Have I ever put any words in your mouth?
No,
What was the number one rule that I told you that I wanted from you when you testified?
nothing but the truth.
Final question I have for you.
Sorry.
Those slings, you were asked about how hard those slings were to attach to your body. And I forget, what did you say about that?
I don't truly remember.
Once they were attached to your body, did they hold that gun sort of dangling in front of you?
Yes.
Could we show that photograph of them? I think it's number 30, what you just used. Okay. Yeah, I'll hold it. That's okay. I'm going to show you, Mr. May I approach on it? I've got this photograph that you've already seen. It's exhibit number 30, and it's showing you and the other individuals at the 63rd Street car source. Is that right?
Yes.
Are you wearing the sling in that photograph?
Yes, it appears.
And is that sling holding that gun in the front portion of your body?
Yes.
Does the defendant have his sling on with his gun being held similar to you?
Yes.
Was that sling strong enough to hold the weight of that gun?
Yes.
He's trying to establish that with the
Was
sling
that
on,
strong-
Kyle
was that
couldn't be
sling
in
strong
fear of
enough
someone
so that if
taking
someone
his
tried to
gun,
pull that gun away,
which is
the
stupid.
gun would be held to your body?
Yes.
I have
Oh,
nothing
really?
further.
Can you redirect or recross rather?
I would move exhibit 30 into evidence.
Is there an objection?
No.
Received. You may step down, sir.
You're not an
Let's
expert
take a
on
break.
sling tension strength, are
let's,
you?
Aim for about 20 after. Please don't talk about the case during the break.
Okay, so we have a couple minutes to talk about it.
Yeah.
On the whole,
oh,
I thought both sides did very well.
yeah, they're doing fine getting their stuff out there. I think the back and forth, to me, the most interesting part is the back and forth on the that's Huber's dad back there. I just saw him.
Mm-hmm.
On the back and forth on the potential of not a plea agreement, but a plea inference or a deal inference at sentencing or for a plea. Binger tried to weasel his way. Well, we haven't made an agreement yet. But then what was interesting to me is that Richard says, well, did your lawyer, that I asked your lawyer if we could talk, right? And he's like, no, I didn't know that. It's like, oh, that's kind of interesting. That to me is, and I don't know if the jury sees it this way, but that to me says, okay, yeah, you got a lawyer who's not communicating with his client about these sort of conversations. The client may not be too privy to what the prosecutor's saying, but there could be some deals going on between the prosecution and this lawyer. That was what I got out of it. But that to me was a very interesting portion of it.
Yeah, and there was that one where he's like, oh, really, to some question. I thought, oh, we're going to impeach. And then that never happened.
Yeah, I was waiting for something to come of that, but maybe they checked it and he was right. I was thinking he was going to bring up that interview and have some contradictory statements from the early time, but that didn't ever seem to manifest.
Yeah. So both, I thought the prosecution made its case as well. I think they're on break for 10 or 20 minutes or something.
Yeah, before they just
made,
pictured the seal. Sorry.
Yeah. The prosecution made its case well. They asked the questions that put them in the best possible light, which is what you would expect. The defense cross-examine wasn't quite as tight overall, but they weren't bad by any stretch. And prosecution and cross can be a little bit more sketchy by nature. But I thought they asked a lot of really good questions. They showed Kyle's motivation for moving from place to place. I'm still confused on who asked Kyle to move, because I was pretty sure the witness said both me and not me.
Yep.
So that was confusing.
The one thing I found interesting is in Kyle's favor from this witness, and it came out during direct examination, was how much he set up that reasonable people would be concerned for their safety just in this general environment, and that having a gun was there. I thought it was a little limp of him to say, oh, well, I brought my gun for protection, but I wouldn't use it even if I was. That was a weird thing, and I don't think jury's buying that. That seems a little strange.
And I made this point midstream, and I think I made it earlier this stream, but I'll make it again. The reason the prosecutor is asking the questions they appear to be asking, it's like, why would they do that? It appears to be that they're trying to argue, like, we'll just take this guy, for example. It's like, you had smoke bombs thrown at you, you didn't feel the need to fire back. You had rocks thrown at you, you didn't need to fire back. Okay, why ask that question? Well, because Kyle Rittenhouse had a bag from the hospital thrown at him. So the idea is, because when gas bombs were being thrown at me, because when rocks were being thrown at me, because when other chaotic things were happening in the street, other acts of violence, other acts of things, like, none of these people apparently concluded that their life was in danger. So since a similar thing happened, this is the prosecution's argument, it seems. Since a similar thing happened to Kyle Rittenhouse, it must therefore be objectively unreasonable for him to feel his life was in danger. Now, of course, the counter from the defense is, but the specific situation, though. So they're trying to extrapolate, because it's true in all these other situations, it must be true in this situation.
Right.
Seems to be where they're trying to go.
They're also
it's a strategy.
At the end, he indicated that he's trying to get at the idea that Kyle pointing his gun at people, I'm guessing, was instigating. That Kyle is, that this guy, Dominic Black, he didn't point his gun at anybody, so therefore he wasn't attacked in the same way. I think that's going to be part of closing. Is that part of the reason that Kyle was attacked is because he was pointing guns at people, and even this Dominic Black guy, he thought that was people shouldn't.
Was he pointing guns prior to, like, the incident of the first shot? Was he pointing guns earlier?
Don't know, but Binger asked the questions in a very muddy way to make it seem like that happened. And he used the laser pointer guy on the roof to make the inference that Kyle and others were pointing their guns. And it went back to a piece of Dominic Black's testimony early on that some people had pointed their guns when they felt threatened, and then the other people backed off. So not quite sure if Kyle was included in that. It all got lost in the gloss there, and it was really well done by Binger to ask those questions. And maybe Kyle was involved in that, and if he was, maybe that's why Richards didn't challenge it, or maybe he was just focused on other things. But it was an interesting way to draw. They ended the stream. What is with the... Seriously, what is with these places ending these streams on breaks?
and then we get it. It's a couple questions into the start. It's like, wait, what happened now? Why is this guy talking? It's like, yeah.
Oh my gosh. They're all shut down currently.
I did really like the answer from the defense cross when they pointed out why Kyle wasn't on the roof, because the prosecutor asked during his questioning, you went on the roof because it's the safe place to be. All right, so why wasn't Kyle there? And then we got the answer from the defense attorney. Because he was requested to stay down on the ground, because he's a medic. That's why he was where he was. Good answer. And I also liked the defense's lawyer save on the issue of whether or not he was taking the gun for his safety.
Right.
So there was a series of questions there. It's like, was he taking it for your safety? It's like, I don't know. It's like, but you took it for your safety. Yes. So you just rest on that, and you let the implication flow.
Right.
Which was a nice move. Good job.
Let me read a couple chats, and then I got to run to the bathroom before we get back to the thing. I did find...
It's okay, I'm going to get a beer before we get back.
Sounds good. Horowitz, Feinberg, and Horowitz says, apparently he was on a rooftop, but forgot he was not Korean. Perihelion says, hey, Nick, sing this to troll my wife. She can't get it out of her head and is watching right now. Give it up for the feminist boys. I love you, honey, says Perihelion. Gross. Gross. Snuggle Struggle says Jack Posobiec's Twitter has the FBI vid and never before seen vid as well as showing clear usage of self-defense. New York Post covering Kyle's yawning towards his homicide trial, clearly attempting to make him look to not care. Yes, the media is going to spin very hard. Well, I'll have to check out the FBI video. I haven't seen it yet. And Knucklefist says, epic stream, guys. Thank you for not talking all over the proceedings as some other streamers are doing. He said, we're going to add our commentary, but we want to hear as much
Yeah,
as...
we want to hear as much as you guys. Like on some of the stuff earlier when Nick was streaming, some of it's just blah, blah, blah. So it's a little bit different. But in this case, I want to hear what's going on.
Yep.
And I found his testimony overall credible. I thought, the defense did a good job extracting from him.
Yeah, we'll see. That's the first witness, and that's the guy, that's them having to have a lot of questions around that charge that doesn't have anything to do with probably any of the other witnesses, which is going to be that possession, a minor in possession charge. Is why they had a lot of testimony from him that was kind of boring, especially at the beginning and not really related to the event. They still have to lay foundation, a factual foundation for the charge. They have to get the facts of how he got the gun. They're trying to infer it was a straw purchase. The one thing I will say about that kid is he did defend himself from a straw purchase sort of situation by saying, no, it was not his gun. It was my gun until he turned 18. It's not recommended, but you can hold something in trust without a formalized trust agreement. That is okay. And especially if they demonstrate it. No, it stayed at our house. It was locked up. He could not have it until he was 18. He may have used it to go outside and do some shooting on a firing range. And that's probably okay. That has nothing to do with straw purchase. He wasn't taking it home. He wasn't in sole possession of it. He was technically supervised by an adult the entire time. It's an interesting distinction how much 3 months of age or whatever it is can make on that. But
you guys draw a line somewhere, and sometimes it leads to these kinds of results.
Yeah. So I'm curious how Dominic Black's trial is going to work out, but we just won't know until January. It's strange. I thought that was really good, by the way, of Richards to say, when did you last meet? Oh, you didn't meet here this morning. You didn't meet here today. And then the whole thing about you had a trial date scheduled in September, did you not? Well, I don't remember. No, but you did. And you came in with your attorney and Mr. Binger, and you asked together for an extension of time to January. And he did. Some people in the chat were like, he needs to follow up with a why. Why'd you guys do that? No, he doesn't. No, let the jury draw the obvious inference. Because what if he said, well, I did, but I'm going to go in for surgery or something happened. Yeah. Like, you don't want to give him an excuse. Don't
ask the one question too many. It's a cardinal sin. Lawyers do it all the time. The one question too many. And also don't ask a question you don't know the answer to is also a good rule.
Right. I'm going to run and grab, go to the bathroom and
that sounds like fun. I'll do those things too.
Yeah. I'll see you in a minute. All right, chat.
Okay.
We'll see you in just a second. We will be back for the remainder of the hearing, which should be probably one more witness.
What's up? You heard my pee? Noted. I use a hand sanitizer rather than soap and water, so I'm all covered there. But yeah. Yeah. So what can we guys talk about? By the way, Guinness is the beer of choice, low calorie, so, and also it doesn't taste too bad. Yeah, Guinness is exceptionally low calorie. It's actually one of the lowest calorie beers you can buy because of its ABV. Guinness is only 3.2% alcohol. It's 154 calories per 12 ounces as I check the back of the label. It is 125. I was off by a lot. Yeah, it's 125 calories per 12 ounces. It's actually one of the lower calorie beers you can buy. Cheers.
Cheers. Oh boy. So I'm excited to see who's next. I don't have a witness list or an order list or anything. Wolvenar says your guest gave us a great audio clip of his bathroom break. Reality is reality. Reality is real. Okay.
Is there commentary or we're just putting up the instruction for no particular reason? Slides from earlier.
Yeah, I wonder if this is. God, this is why I hate having a news station do this. It's muted though.
Yeah.
Right now I have the Washington Post thing up, so they're probably trying to fill time. Fox 6 News Milwaukee has a stream. Let's see how theirs is doing. They're doing the same thing. Wait. Did they show the picture of Rosenbaum being held like a doll? Gosh, that's a great picture. There's a picture that was just showed on this other one, and someone is holding back Rosenbaum, but it looks like he's up in the air, and it looks like he's being held like some sort of toy. Oh, it's beautiful. There it is. Look at him on the left.
Looks like a babe.
I'm going to bring my Rosenbaum with me wherever I go.
That's right.
Oh my goodness. Whew.
So what else you got? What do you got going on for your stream later today?
I have no idea yet. Last night I was covering that America's Got Talent lawsuit.
$2.09 gas. Yeah.
Those were the halcyon days. Ryan Case. Nah, I'm not.
I work in that business.
Not dying for one of those right now.
I am at that business.
Okay.
Well, that's a good picture right there. That is quality. Can you even say with certainty that that was Kyle?
If we actually get the actual video, is there any video of this?
There is from Jack Posobiec. Or here we go. Okay, so there's McGinnis. I'm guessing Rittenhouse is in the white. Okay, so then it changed. Yeah,
I didn't get a lot out of that.
no, I don't think the jury will either. I mean, the prosecution's going to spend a bunch of time explaining it.
Oh, I have no doubt, frame by frame. Here's where he turned around and is chasing him.
You know what's really interesting? So the best I can figure, that video was not available to the expert for the preparation of his expert report, right? John Black didn't have that video because his report was turned in before they mentioned it.
Oh my God, I am.
So that's an interesting idea. I wonder if they're going to ask him about it.
He fucking shot him! Get in there! He fucking shot him! He fucking shot him! He fucking shot him!
Take a screenshot. That dude shot him. That nigga just shot that dude. Cranium that boy. He just shot him, man.
Okay, so interestingly, the lady.
Hey, what are you doing? You shot somebody? Who shot? Who shot? Hey, stop him!
The lady who is screaming, he shot him, is Mrs. Zielinski, who is allegedly friends with Joseph Rosenbaum. Or I don't know about friends, but they had met up during the evening. And Kyle Zielinski is the Mr. Zielinski or whatever, is the guy who fired off into the air. So he fires into the air. I said Kyle. I don't think that's his name. He fires into the air. Rittenhouse turns around, plugs Rosenbaum just a bit after that, 2.5 seconds, I think Binger said. And then they're the ones yelling, he shot him, all that. So there's some interesting instigation questions there.
Yeah.
Yeah, Edward C., I know this is the defense outline 1 to 40. We know what it's from. I just don't know why it's playing. That's the real question, is why they.
I forget. At some point, I asked some question. The chat went crazy because I was like, "Why did you make that sentence?" And because the defense lawyer said something, I was confused by why that specific statement or something. Oh well.
Yeah, it's hard to say, 'cause that's the thing. These things go on a long time, so it's hard to say exactly what is, or hard to remember everything that you see.
Someone asked about Guinness beef stew. That sounds promising.
Falixard makes an interesting point. He says the crowd behind where Kyle finally shoots Rosenbaum move away as one because of some stimuli before Kyle turns to shoot. Apparently they were afraid of harm. That stimuli is the first shot from Zielinski. Zielinski fires into the air, and the people start moving right after that because there's a gunshot. And then more people move when the 4 gunshots follow.
Yeah, I also asked a question about why they took the guns out of the safe. I was wondering why they took Kyle's guns out of the safe, or Kyle's gun out of the safe, and someone said for self-defense. But Kyle wasn't planning on staying at the house, so it just was slightly confusing.
I think I think the clarification, which was not really done on testimony, but just by inference, would be that they took all of the guns out of the safe, which was in the garage, and moved them into the house, thinking they would be safer from people like trying to rob them or something like that.
Yeah, that doesn't make any sense to me. If the purpose of moving them is to protect them from theft, it's better in the safe, even if it's in the garage. The safe is going to be, you can't break into that thing, and it's not going anywhere. So I would think leaving it in the safe would be better. If your motivation is to have them ready for self-defense purposes, I was unclear why they moved Kyle's gun. That was the question I was attempting to ask, at least.
You know what's kind of funny? Oh, I keep mixing up. I'm Zeminski. I keep mixing him up with Kyle Kalinske, who I think is one of the Parkland kids, the Republican Parkland.
Yes, you can break into a gun safe. It's going to take a lot of effort if it's any good. It's possible.
What was I gonna say?
Sorry.
No, that's okay. I interrupted my own thought with the Kyle thing. Oh, yes. Interestingly, no one's being prosecuted for it, but they had unsafe storage of firearms with a minor present. That minor ended up allegedly taking one of those guns and then going and using it to allegedly shoot 2 people to death and injure a third. That's negligent storage of a firearm on behalf of Dominic Black's stepdad or whatever. You can't just, guys, if you got a minor in the house, you cannot just leave a gun and ammunition in access, or you could be liable for whatever follows.
I love how we turn the chair around like a count or something.
And there's an issue. What's up?
Judge, the only issue is that we are intending to call witness this afternoon. He has a criminal record. That would be Corey Washington. I believe he'll be the witness after this next witness, who shall be relatively brief, so I thought we should bring it up now. Mr. Washington does have 3 adult criminal convictions. In 2008, CF 262, it's a 2008 case, criminal damage to property misdemeanor and a disorderly conduct misdemeanor. And then in another 2008 case, CF 1409, he has possession of THC. I had disclosed to the defense that there is a juvenile arrest in 2004. I spoke with Mr. Washington, and he indicated that anything ever went to court for. It seems that it was an ordinance, so I do not believe there are any actual juvenile delinquencies. It's the state's position that given that these cases are 13 years old, given the nature of them, that they should not be counted as priors. I believe the defense feels otherwise.
Judge, I don't know if you have a 10-year rule on that. I don't know. I'm sorry?
No, because it's not been adopted in Wisconsin, which tells me it's not the rule here. And my rule is that, I don't have a rule, but my guiding principle is that if there's a lifetime history of lawlessness, I'm more likely to consider more remote convictions. And of course, the nature of the offense enters into it. I will tell you that.
Guys, quiet.
I hear a couple of 2008
He's a mile from his mic.
misdemeanors, not related to truthfulness. And another, was that also in 2008?
There's a possession of THC 2008.
Yeah, okay.
And then a disorderly conduct and criminal damage to property in 2008.
Yeah, I don't have a 10-year rule. On the other hand, I don't think I would consider those.
If I don't have a strong, I just wanted the court's final ruling on it.
Okay, well,
If you're not going to let him in, then you're not going to let him in.
yeah, I don't think so.
Very good.
Okay.
Yeah, those aren't really relevant to his testimony
I
here.
agree.
Where do you go?
Yes.
Yeah, those, both the damaged property and the THC possession were in 2008. That's
They're not character issues.
both misdemeanors from 13 years ago.
And I don't believe there was a defense objection on that.
No.
I don't want to speak for them, but
16 years ago.
do something different. We need to do it now because this
Okay.
is the time.
This has been discussed, and there are good valid reasons for it, which I'm not going to take the time to go into right now. But there will be no photographs or motion or video of any kind during the testimony of the next witness.
Oh.
Any question?
Oh, so this is a protected witness.
So no audio, no video?
He said no video of any kind.
Well, maybe we'll have to talk about something else.
They said it's going to be very short.
Yeah. The one of the reasons might be because it's a minor.
Yeah, that could be.
But it's not secret to anyone who's in the court. So it would be, you can look for news reports, but they don't want it broadcasted live. Presumably, not their voice, not their image, because it might expose them in some way. So it's not secret to the jury. It's not secret to the people in the gallery. It's just not broadcast. So fair enough.
Yeah,
we'll talk about
we'll
something
see.
else. I don't think there's going to be subtitles either. If there were subtitles, that would be hilarious.
It would be. That's why I turned them on. Just in case. But no, it's yeah, I think you're right. It's gonna be a minor that is not supposed to be videoed. I'm surprised that they're not gonna let the audio recording through though.
Yeah, they did the same thing in the Floyd trial with the audio, but not video. So
Ryan K says, so much for transparency, the court to the public. And yeah, I know minors and whatnot, but it is still open to the public who are there present. And it will presumably still be available on transcript of the court, just with the minor's name abbreviated or censored in some way. So it's one of those measures that they take to where they say that the impact on the transparency of the courts is de minimis. And it is outweighed by the desire of the legal system to protect the integrity of a minor.
And the chat points out it could also be a federal agent of some kind who's undercover or some other reason that not to disclose. Again, it's not going to be secret to the people in the room. But
and maybe it's the drone pilot.
Maybe it's the drone pilot. We don't want their face exposed to prevent retaliation. It could be something like that. I don't know if they do it anymore, but I think I read about cases where the idea was they're so sensitive that maybe they can testify behind a screen, so we'll only see their shadows. That's how worried we are about exposing them.
I think they stopped doing that.
Yeah, I think they stopped doing that because you have to be able to see the witness's full body language.
Yeah, as the defendant, you have a right to confront your witness, or you have a right to confront your accusers. Which
it's a Fed with a THC possession conviction, so good for them, though.
No, that's the next guy. The next guy is the THC possession conviction.
You're correct. I misspoke.
How
you
dare you? Oh my goodness. This is riveting. Very good.
Yeah, it's riveting commentary. Yeah, so it's either a minor or it's a undercover police officer.
Right.
Of some variety.
Yeah, and I who knows? Without the witness list, we have no idea. Their names going to be censored.
Names, didn't they? They did yesterday, where they mentioned all the names, didn't they? Of all the people that could theoretically be called.
Yeah, they did.
So it's like, well, we could go through all their names and see if any of them pop.
See if I can find this. I'll see if I can find this FLIR video from Posobiec.
Yeah, see if you can find a better version of it or one that's marked and can actually show us what the hell we're talking about. That'd be great.
Here we go. This is 3 hours ago. Posobiec posts never before seen FBI footage of the Kyle Rittenhouse shooting. Interestingly, this footage is not the FLIR image.
Okay.
So I'm kind of curious about that. Here we go.
Further.
Yeah, these stupid white.
These stupid white people. So here's Rosenbaum.
Yeah, they definitely need that trash can to put their garbage out.
Rosenbaum and Rittenhouse are right next to each other there.
Blocking the road.
Oh, is this the same
further.
Okay.
So this This is good.
I see a large crowd over here smashing the SUVs. I think.
So I think that's where this chase ends. Chase like before the incident. Rosenbaum is in front, Rittenhouse is behind.
Hey!
Okay. So at least I finally understand what the prosecution was saying when they said that it appears at least, that he was chasing Rosenbaum, because at, something like T minus 20 seconds or give or take, Rittenhouse is running, or Rosenbaum is running in that direction, and Rittenhouse is also running in that direction behind him. So obviously you could characterize that as chasing, although there's a million other explanations.
Yeah.
But the prosecution's allowed to argue any explanation that is reasonable from the evidence. So one of them would be he's chasing him. So that's where he's going from. Great.
And the counter argument is obviously that he doesn't follow Rosenbaum past the cars. He approaches the Zeminskis, and Rosenbaum immediately comes around the cars and appears to confront them. And the prosecution's going to have to rely on the vagary of there not being audio recordings of any potential exchange of words that may have happened there, which is, and he suggests that there's a confrontation. We actually don't even know if there's a confrontation. The first thing we hear is "get him," which was kind of interesting to like.
I'm not sure who we're getting.
Yeah, and we don't know who's saying it. We don't know who they're saying it about or to or anything like that. We don't know what proximity they are to the cell phone camera that's recording. Yeah. So that is that's a very interesting piece of footage. It's really hard to discern what's going on. It's not going to be great for the jury, in my opinion, but
Profiteer in chat asked, how do they know that was his motivation? And as I was trying to say earlier, the prosecution is allowed to argue any inference that is reasonable from the evidence. So Rosenbaum is running a direction. Kyle Rittenhouse is running in the same direction behind him. So is it reasonable to argue that, or reasonable to infer that Rittenhouse is chasing? Yes. Are there 1,000 other explanations? Of course there are. But which one's the prosecution going to choose? The one that's most damning. So it is a potential extrapolation that is available. So it's a legally cognizable argument.
Yeah. Not
that doesn't mean
saying
it's
we
not bullshit,
agree
by
with
the way.
Yeah, not saying we agree with the
bullshit.
argument. But they get to make that. And remember, the defense just has to, well, it doesn't have to. The defense has the luxury of providing any reasonable doubt. Yeah. So they can say,
which the chat is having no trouble thinking of. They just happen to be running in the same direction for no particular reason would be a valid argument too.
Right. And we saw from just a moment before that Rosenbaum and Kyle are next to each other at one point without apparently having a conflict or anything like that. No confrontation is occurring, and they're right next to each other. Then they move apart. One of the interesting ideas would be to suggest that Rosenbaum was trying to ambush Kyle Rittenhouse, and that's why he ducked between those cars and then came back immediately as he runs past, for example.
Right.
So there's a million other reasons. We know we're not making the defense's or the prosecution's argument and saying it's correct. We're exploring how the prosecution got there at all, because up until now, for us,
up until there now, we're confused how we're getting there. But now we understand how they're getting there.
Right. So
someone in chat pointed out that luring is a game of words. I'm like, yes, this is also why I was so critical of the defense for their opening, because the imagery might have been good. The words left a lot to be desired, in my humble opinion.
Yeah. The other interesting thing was how the seems like the FBI guy is cycling through, different filters and lenses and viewing options available as he's going. Because at one point it switches to like a true color, but it's way too dark, to see. And it's just neat to see how those drones work and what they base a lot of this stuff on. I mean, they've got a drone.
Was it a drone? Because I assumed it was from a helicopter, but was it a drone?
I believe they said it was a drone.
Okay, fair enough.
Yeah.
Cool. I didn't really know drones could really do that. I guess I shouldn't be surprised, but I've never seen footage like that from a drone before, so first for me.
Oh, dude, yeah. The military and the high-end law enforcement drones are they're really impressive.
Excellent.
But you still wish they had a better camera than that. I mean, because he like zoomed in and it didn't get better and it didn't focus on what he wanted to focus on. That's why he zooms right back out. It was strange.
Now, the question that I think I know the answer to, but why they switch from different modes. I assume that's being done in real time.
That's
and
what it looked
the other
like,
modes don't exist on video. So why the operators made those decisions, who knows? But there's no editing of it by the FBI except maybe to label people, but otherwise it's unedited, right?
I don't know, because there is a weird spot where it jumps and they may have cut time. The only way to verify would be to check timestamps, and I wasn't paying that much attention. That takes a lot more attention than I'm able to give it on
Well,
this
they have
live
an
stream.
expert for that, so if that's the case, is show a time jump, yeah.
Right. But if anybody in the chat notices the time jump, if there is a time jump in the timestamp, because it is on the bottom, there is a running timestamp and you can see what's going on there.
Cool.
Show the video again. I don't know how long this witness is going to take. I mean, I guess I could show it one more time.
It's supposed to be short.
Yeah, but short can mean a couple different things. Short can mean short can mean 30 minutes.
Yeah, everything's in the eye of the beholder, right?
Here, I'll show the whole thing one more time. It's 2 minutes long. There's no. It's interesting. It does say this is version 3. Oh wait, no, this is edited video because they added the graphical effects to it.
Yeah.
Adam A., the person testifying now could be the Fed drone operator.
Further.
I don't know that they'd need to testify secretly, though.
Yeah, these stupid white.
Finally, someone said it. These stupid white people.
Yeah, they definitely need that trash can to put their garbage out.
See there, Kyle.
He's blocking the road.
Kyle and Rosenbaum. Right next to each
further.
Social footage.
Okay, a large crowd over here smashing the SUVs. I think.
Like it cuts away right when it would be interesting.
I think there are at some times. There do seem slight jumps in the seconds if I'm looking correctly.
Man, I gotta say, if that video doesn't show self-defense, I mean, with those audio, Kyle saying friendly, 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 them saying get him, you ain't gonna do shit, get him, get him, get him.
Yeah, and the audio, what's like the audio at the very beginning. Also, what's the context for that? Is also unclear.
I mean, you notice what's really interesting. So the prosecution does suggest that Kyle Rittenhouse was chasing Rosenbaum, but there's there's an important gap in the footage where you don't actually see that chase occur. Did you notice that? Like, we know that Rosenbaum makes a move this way, the Zeminskis make a move this way, and we see Kyle running, but we don't actually see the context of the chase prior to that. It's
well,
about
we definitely changed
away.
our perspective on the Fleur video from it being full screen to only a very small part of it. We can't even see timestamps anymore at some parts of it.
Yeah, I'm confused upon that. It looks like there should be more video than what's presented there. That and they, since as they've combined those two things, I mean, I think that if the defense doesn't have access to the full video, then something is amiss. But maybe the defense
if they don't have access to the full video, I would go crazy as the as the defense.
Right.
It's like,
but
I need the originals.
The video that was played by the defense was a snippet that did not include that cell phone footage next to it. Right. So clearly those two things are different. Posobiec has posted something that we have not seen in court. It included a portion of what we've seen in court, but he did not post the exact same thing. So I'm not sure what that is, who did those edits. I don't know. And that's an issue with that video. But yeah, the question is, does the defense have access to the full unedited FLIR video, at least surrounding the relevant time frame? So, the couple minutes that he would be involved there. Mm-hmm. That's the question. Mm-hmm. And we don't know these answers, unfortunately.
Nope. We don't. But they better have the originals. So otherwise, if all they have is the compilation, that doesn't make any sense. Because compilations necessarily make an editorial judgment about what should be shown where and what position and all the rest of it. So, yeah.
Right.
And if they're going to try to make the argument that Rittenhouse and Rosenbaum had some sort of confrontation prior to the gas station, then that video at least doesn't show it.
Yeah, and he said specifically that video did show it. He said that video would show that Kyle Rittenhouse had a confrontation with Joseph Rosenbaum at the car that Kyle Rittenhouse instigated, which to me, it doesn't show anything of the sort.
Yeah, I agree.
And if their argument is going to be, that would be a fun thing. If their argument is going to be that they had a confrontation prior to that, I mean, that kind of feeds into the reasonableness of the self-defense claim, in my opinion.
Yeah.
Because if they had a confrontation prior to that, then this other event happened, then there's a chase, and Kyle is retreating. I mean, you're talking about attenuating time from any potential instigation, but also giving a reasonable idea that you might be in danger. It's very, very interesting.
Yeah.
Come on, guys, get done questioning this witness.
Yeah, can we turn to another witness so we can't stop vamping? No, we'll just do like 24-hour news and just keep talking forever about nothing. That'd be good.
We can revisit. I mean,
we can just talk about the same things we've already talked about again, like 24-hour news.
I guess I can try and get to the super chats. My window did a weird reset, so I've got to
do some super chats.
I've got to bring them up in the alternate thing. God, I hate how they do this. I really do. I've got to find out where we left off, and it was.
I still continue to be bewildered if it's true this guy testified on a hope and prayer that maybe the prosecutor would be nice to me.
There's no way. There's no way that there's not. His lawyer probably said something along the lines of, well, I'll talk to him about it. We'll get something set up. But trust me, I think this is a really good plan, but you don't need to know about it. That type of thing, which is not supposed to be how it is. But frankly, not all attorneys act the same way, which is unfortunate, but it's just a reality. I mean, just the fact that he didn't communicate with his client, the the desire for the defense to have a discussion with them is a little bit suspect to me.
It's a little weird.
Okay, G-Man says, wait. Oh my gosh. Are we way back here? This is it. G-Man says, so if martial law is attacking me, but Melinda Scott's 12 children are playing with her tripod behind him, I'm required to cross the street first to save the innocent socialist piglets. Got it. Yes. Yes, absolutely. 200 Watt Studio says, my self-defense was perfect, done very perfectly. No one shot better than me. It was amazing. Frankly, I was amazing. Gen X Medic says, self-defense with a howitzer would depend on if it's high explosive rounds or a canister shot. Mandalore Wise says, what would make alternates necessary post-closing arguments? A stubborn juror or a sudden heart attack?
Something like that. Or
not a stubborn juror.
Yeah, some sort of cause that's discovered during deliberations. Weird things have happened.
One of the jurors goes into the deliberation room and turns around and says, hey, guys, I watched the news last night. You know, something like that. Some weird thing where it comes out after. Yeah. Someone walks in the jury room, pulls open their Wisconsin flannel shirt, and it says "Free Kyle USA" on it, right? Like,
yeah, something like that.
Silent Vash 27 says, so open carry of a field cannon is out of the question. Cannons are not firearms.
Yeah.
They're not categorized the same way. In fact, that's one of my favorite things is when people argue about cannons. Like, you can actually legally own a cannon.
And if it's prior to what, 1896, no FFL, right?
No, I mean, I think you can own one right now. They don't have a rifle.
I know that. I was just trying to make a joke.
Oh, and I cramped all over it. Sorry. Yeah, they don't have a rifled barrel. The rounds, if you have an explosive round for the cannon, that's different. Those are regulated in a different way. But if you just have a cannon, yeah. Malcolm Kex, thank you for the donation. False Profiteer says, off topic, but did you see Don Lemon's interview with Chauvin jurors? Might be nothing, but the reasoning for guilty on the second charge seems odd to me.
Well, the second charge with the third degree murder continues to baffle me legally. So yeah, I'm with you on that.
I think it would be overturned if Chauvin can get an appeal out. I'm actually really curious about.
Apparently, he's pro se now on his appeal. That's fun.
Yeah, because they denied him a public, the informa pauperis proceedings, and they denied him a public representative. Which I think is a little bit troubling.
It's a little sus.
But I think if I'm charitable to the judge, just for the sake of argument, I think it's because he testified that he had a retirement plan, but if he withdraws his retirement plan, he'll be quote unquote underwater. But that doesn't actually mean that you're unable to afford an attorney. And so just because you would be in a worse financial position is not justification on its face to do so. Because, I mean, it might cost him $100,000. His retirement plan might have $120,000 in it. So after penalties and taxes, he's out of money. But but we don't know the details. G-Man says, do you think Twitter paid to get named in the jury instructions? Could have just said social media in general.
No, you want to give some examples. I think it was prudent.
Yeah. 200 Watt Studio says, why didn't defense object to the phone thing? I actually didn't see anything in that examination or cross-examination that merited an objection. Personally. If that's what you're talking about. But this might have been before during opening arguments, and I don't remember the phone. Oh, the phones for the jurors. Because there's no objection. I mean, if the judge is going to allow phones, then the judge is going to allow phones. But it wasn't entirely clear. I'm just surprised. Rogue says, so the jury is supposed to ignore the rioting. Nope. It's up to the defense to establish the rioting as present sense impression. Anti Omnia Libertatum says neither railguns or air guns are considered firearms under federal law and most state laws. Mr. Cobblestone says firearms are dangerous weapons. Right, Alec Baldwin? Mandalore Wise says, what's the chance that any of the jurors know/care what the meaning of beyond any reasonable doubt is?
They tried to explain it, and I thought they did a pretty reasonable job of explaining it.
And they'll explain it
pretty
again.
well.
They'll explain it again at close. Actually, I would imagine that the defense is going to spend a lot of time talking about reasonable doubt on this stuff, and the prosecution will try and spend a lot of time talking about reasonableness, similar to what we saw in the Chauvin trial.
Mm-hmm.
Not applicable says this instruction is going to wreck the entire case. I don't know that it is. It's just confusing. Scipio says, juror, please judge. I'll vote however you want if you just stop talking. Jim Satala says these instructions almost guarantee an appeal. That is a possibility, but technically the judge will restate the jury instructions at close more completely. And that'll be, I think that'll be the issue. In fact, aren't they given written jury instructions?
I honestly don't know. Some states they are. I don't know if this is one of them.
Pirate Skeleton says judge seems to be taking special care to emphasize innocent until proven guilty. I'd speculate he has chosen a side. I don't know. This judge just seems to be consistent and pretty much follow the rules so far. At least his interpretation of the rules. Philip Coggin says Kyle Rittenhouse should have hired Ronnie O'Neill for the opening statement. I agree.
I really feel like I could have done better. I know it's a bit pompous, but still.
But could you have done better than Ronnie O'Neill III?
I don't know.
You remember that guy, right? The Florida guy with the crazy hair? I
Yep.
love him.
Yeah.
Not applicable says, wasn't him reaching for the gun a huge argument? Yes. It was a weird thing for the state to include, but he's trying to mitigate the facts. He's trying to get them into the minds and then pass them up. Snuggle Struggle says, has the supposed FBI recording been handed over the defense yet or not? Sorry, came in late. I think so. I think we assume it has. They haven't raised a stink about it. They used it in their opening statement. FP Silver says, stay back, aim. Adam A says, I'm going to lose it if the jury gets up and claps. Not applicable says, so arson doesn't kill anyone. I didn't know that. Yeah, someone mentioned that there were 10 bodies in one of the burned out buildings. Did you hear anything about that? I'm not aware of that.
I don't know. I don't know anything about that.
Pirate Skeleton says, this prosecution sounds like projection. The only chaos tourists were the peaceful protesters there to riot and loot. Not applicable says, they're going to argue skateboards can't kill you. John O'Brien says, the cross on black is going to be interesting. I agree.
That was good.
Oh! Oh, these
fix it, Boomer.
I'm working on it. Why are they ending they're ending their streams? It's not actually over yet. Nothing is over.
I guess the most logical conclusion is they just finished the witness and went to a small recess in between witnesses, which that's the reason they've cut them off so far. So I guess we're done with, we'll presume, FBI guy. Are we back?
This is a different feed from AB. I didn't want a feed with a freaking watermark on it.
Yeah, no, I don't want a watermark either.
I'm going to see if I can find an alternate one, but that's the only one I saw right now.
I'm not 100% sold on the state seal, by the way.
Yeah, it's a weird one. I noticed when I type in Kyle Rittenhouse live that my stream does not show up.
That's sad.
Very frustrating. Considering we're one of the highest watched streams on this issue that's available. The only higher one, right, was the Washington Post. Actually, no, we're now higher than any other stream.
You passed the Washington Post? Well, I feel honored to be here.
Well, because it ended. So now the next highest is this one at 3,800.
Nice.
But yeah, we're dominating that. Here, I have this other one from Fox 6 News Milwaukee, which doesn't have a watermark. So I'll keep this one up until we get back. But
okay. The faces on the people in this state seal leave something to be desired.
The art in general, proportions are way off. Look at these high-rise pants this man has.
Yeah.
These pants are approaching nipple territory. Very dangerous. Very, very dangerous. Okay. Fractal Machine says a jury is inherently not people of ordinary intelligence. All of those were smart enough to get off of jury duty.
Some people have a sense of civic pride, so.
Troy Amanga 000 says everyone here should look up how 1920s how 1920s bootleggers avoided getting sentenced despite overwhelming evidence against them. Snuggle Struggle says maybe I'm mistaken. Didn't the leadership of Kenosha stand down law enforcement in a sense? The police also made it sound like their hands were tied. They had a line. They had a line that where there was lawlessness beyond it. The prosecution talked about that, and the defense talked about that at a previous hearing. Ying Kong says, my guess is the prosecutor is going to argue that Kyle knew that the crowd was not friendly and there was clearly a risk, but yet Kyle willingly got in the midst of the crowd. I could be wrong. No, I think that's apt. You Can Call Me Al says he couldn't stay at his girlfriend's house because it was a school night. Oh, stop. Nick Ricada. Oh, wait, no, read that one. Silent Vash 27 says, how is it Kyle's fault he followed the danger willingly, but somehow his actions don't matter? Phoenix Lord Asserman says that was painful. Snuggle Struggle says, I didn't hear the part where the first shot says, shoot me N-bomb. And I also didn't hear Kyle saying, I'm your Huckleberry. The mob is at fault. JD Free says, is he really arguing that Kyle shooting makes him uniquely reckless after admitting that there were other gunshots? Yes, he is arguing that. I Hate Yankee says, why isn't the R slur who fired a warning shot being charged with something?
Good
Anybody's guess. Anybody's guess. Wouldn't make a very popular headline, and I assume he's going to testify as a witness. Zeminski may be testifying, and if Zeminski is testifying, then you'll know why he's not being charged. Gerald Armstrong says he lied about Rittenhouse chasing Rosenbaum. We kind of covered the FLIR video there. I don't think he was chasing him, but I can see a lame attempt at making the argument. Otter says anybody worth shooting once is worth shooting more than once. Fatal System Error says this is the hardcore commentary I've been looking for. Here's the money. Great stuff. Tomorrow V says the shot in the back line is not for the jury. It is for the MSM to run with. 200 Watt Studio says Nate oiling up and putting on the knee pads for the prosecutor. Lol. No. Prosecutor did a good job. He did. Expert Spectre says Tony Hawk's Protester 3. Rumpley Depew says, thanks for the coverage. By the way, I'm so excited. FedEx just delivered my Kyle Rittenhouse autographed skateboard. I think the holes in it are for aerodynamics. Johnny Stoffel says, can't we trade this schmuck in for legal bites? Come on, Uncivil. Choose your guest. Choose your guest. Legal knows hosts better.
They don't like me, man.
That's a weird sentence. Glenn Carver says, great content. Cheers from the motherland. The European one. Okay, the big one. Thank you, Glenn. Jim Satala says, by bringing up Rosenbaum's hospital stay and trying to present Huber as a good man, does that not open up past criminal acts for humor and mental hospital? Maybe. I think it meant Huber, but yeah, it's very possible. Nick Ricada says, the former Marine threw Kyle under the bus in the New York Times vid recap. Marine basically said was gradually apparent to him Kyle was looking for trouble. That's interesting because that would be speculative.
Yeah.
Right? You would object to that. I guess I could get present sense impression as a maybe exception to the speculation. No, that's a hearsay exception, not.
Yes. So yes, it's a hearsay exception. Yes.
Not speculative. Yeah, I don't know. We'll have to see. I would object to it. Whether you can win or not is a different question. Expert Spectre says Kyle left a legitimate one-armed man. Meme magic.
Nice. Cute.
Mike Lombardo says, Nick, wouldn't the prosecution introducing character evidence of Huber allow the defense to introduce negative character evidence of Huber? It might. We'll have to see. They'll have to try, but that'll be it's an interesting one since Huber's not testifying, being dead. How you start to introduce that character evidence. That's the challenge. You have to have foundation for the evidence you're introducing, and you have to introduce it typically via a witness. And so introducing that, you have to have a witness with some personal knowledge. They may have one. We'll have to see. A fuzzy creature says Posobiec is claiming special info withheld. I'm betting he's over-promising and it's going to be nothing important. President-elect Austin M. says McGinnis ricochet might have hit Rosenbaum in the back. Let's see. The Scott 16 says, hey, Nick, just wanted to apologize for yesterday. Damn, I'm such a Canadian. My first super chat in over a year, and it was to naysay something you enjoy, and not even with a joke, kind of uncool of me. Oh, I don't even remember it. I don't even remember what you said. There's no need to apologize. You can naysay whatever you want, buddy. Doesn't bother me at all. Texas Red says, objection, Your Honor. Jump kick man was clearly engaged in a dive kick. I'm not here says, can the defense ask Rosenbaum's girlfriend why he was in the hospital? Anger issues, drug problems, sexual deviancy? Possibly.
Yeah, possibly.
I think if they bring her on the stand, that's going to be something that's really likely to come up.
Yeah, he came to your house. Do you know where he was before that? Hospital. Do you know why he was there?
He was at a hospital, wasn't he? It was a mental institution hospital, wasn't it? It's because he likes to touch kids, isn't it? Can you imagine? That's the...
I mean, there seems to be a dispute over whether or not it's a mental hospital or not, but if he went in for mental health, what difference does it make?
Yeah, exactly. Rico says, judge is going to be indicted for murdering the DA. Pirate Skeleton says, prosecutor's objection, TLDR. Prosecution should have as many benefits as the defense. Jacob Fabisiak says, Binger lied about Grosskritz's actions when he confronted Kyle. Texas Red says, Mark Richards is poking himself in the eye while Thomas Binger is putting a shotgun in his mouth. That was at one of the arguments portions, I believe. I don't remember. Zero says, on a scale to 1 to oh shit, how much did the prosecutor mess up the hospital issue? I don't know that the hospital issue is overly prejudicial in general, to the case of Rosenbaum, or to the Rosenbaum issues. I think because unless they can provide evidence that he's in the hospital for still being attracted to kids after his charges years ago, if that were the case, that would be prejudicial. If it's he went to go, he needed to stay a couple nights for some reason, like he was at he had a personal crisis or whatever, he had a suicide attempt, something like that. I don't know that that's overly prejudicial, personally, but maybe they could show that he's willing to die, right? If he had a suicide attempt or a suicide scare 3 days prior or something like that. But yeah, they're making they don't want anything about his past coming out. And the problem is because one thing about his past leads to the next thing and the next thing and the next thing. And I really do think that the any testimony about his initial crime, which is an awful child abuse crime, I think that is very prejudicial and mostly irrelevant to the actual facts of the case. I think they really want to avoid it.
Mm-hmm.
JP says, I think prosecutor wanted to paint Rosenbaum as a sympathetic person with regards to the testimony of the girlfriend, the contents of his bag. I do too. Oh, he couldn't even stay at his house. He had to carry around his belongings in a bag. Oh my gosh. Right. Like that. That's what he wants.
Yeah.
Peter Bemis says, if the prosecution has a brain, they just decided to axe the girlfriend's testimony. Very possible. Frankly, I don't know what relevant issues the girlfriend is going to testify on. The contents of the bag?
Yeah. What was in the bag? And but she starts testifying as to his behavior and mental state, man. Yeah.
Even if she testifies what's in the bag.
Or what
okay,
she
where'd
witnessed,
he get the bag?
Or to the extent that she was able to witness anything personally, she could testify as to that.
Yeah, but she wasn't there because he had a no contact order with her. So my impression is that she stayed home and he left.
Okay.
but I don't know, I just don't see if she wasn't there to personally witness something involving Kyle, then she has basically no value to her testimony, and they should probably cut it. Andre Tukulescu says they effed up taking Barnes off the case. Maybe you could get him get him a couple times in the live stream now. He's invited. It's up to him and what his schedule is like. Imni, thank you for the donation. Deli8079 says Kyle's done for. Lamau. One thing I want to say again about the Barnes thing, I kind of griped at someone in chat who's been talking to me about the Barnes thing for the past couple days. Yes, it's frustrating that Kyle's defense team has turned down potential help. They may have good reasons for it. They may not have good reasons for it. But whatever the case is, it's done now. And now that is irrelevant to what happens going forward in the case. It's done. So sitting constantly belaboring it, and a lot of people keep talking about it. A lot of people are asking me about it. So I'm just going to address it here. What happened there happened. Barnes is the best source for it that we know of because he's one of the people directly involved. The other source would have to be Richards, I guess, or David Hancock or something like that. And you got to go talk to them about it. I'd just be speculating. We don't know what would have happened, but that was for jury selection. Jury selection is passed. Now I got to focus on what's in the case and who's actually trying the case and how that's going to go. That's the most important stuff going forward. So that's why I'm not really super interested in talking about it, because it just be us going, oh man, would have been nice to have them. Maybe, okay. That doesn't really help. Expert Spectre says lawyers rise up. Bottom text. Gigantor068 says, going with the hard R. Good luck explaining this to YouTube. It wasn't me. I get the Shaggy defense. Imni, thank you again for the donation. Looks like you're getting censored by YouTube there. Pseudosnark says, thanks for the coverage. Cheers. Agree with the take. Excellent upgrade to Kurt AI. HR behind you. What is the HR behind me thing? I don't know what that means. Not applicable says freaking.
Probably saying something controversial, so you're going to get fired, I guess.
I don't know. Not applicable says freaking. Why would he testify? What? No. That's about Kyle. Infinity223 says, hey, Nick and Uncivil. Heard something about a fire extinguisher, and I was wondering if Uncivil still believes that one Capitol police officer dies from one.
Never did, but thanks for playing.
But did he almost die from one? No, I'm just kidding.
There was a Capitol Hill police officer that was in fact struck with a fire extinguisher. It wasn't the guy who was pulled out. And this was a whole meme on my channel for a while. And
then a Capitol police officer died. Ergo, ipso facto. Not applicable says turn it off. It's over. If he testifies, he's done. I wouldn't go that extreme, but I don't think it's a good idea. Johnny Dowie says, I can't wait for the big dance party. There will be civil war if this keeps up. Mr. E says, Kyle needs our boy Ronnie to stare down the prosecution. Jamie Pulliam. Jamie? Says, what is your opinion on the defense attorney? Is he hurting or helping Kyle? I haven't seen him do anything to hurt Kyle at this point. You? I mean,
he didn't, other than the opening argument, which I criticized. I thought the cross-examination was pretty solid.
Yeah. And I mean, him having a less than stellar opening argument doesn't mean he's hurting Kyle necessarily. I mean, it could, I guess. I didn't think his opening argument hurt. It maybe could have helped more or been better, sure.
Hey folks, this is this last witness. We're going to leave that right where it is right now because there's some technical matters that have to be worked out, communication issues, and that should be easily resolved, and we'll get that taken care of. And then in the meantime, we're going to bring another witness up so as not to waste the time. Okay.
I'm confused.
Me too. The audio is really low on the feed.
Corey Washington?
Is a witness testifying remotely?
Maybe. I can't turn the volume up, guys. We can try and find a different feed real quick.
Yeah, maybe the feed is bad.
Good afternoon.
What's going?
Could you make sure you pull that microphone really close so we can hear you well?
Sure.
Could you state your name for the record and spell your first and last name?
Corey Washington. Corey spelled Koeerri. Washington is Washington.
Are you, what is your current?
Okay. Hold on. This is louder. But it's got a stupid watermark.
Yes.
But we can actually hear it, so that's better.
Good afternoon.
How's it going?
Could you make sure you pull that microphone really close so we can hear you well?
Sure.
Could you state your name for the record and spell your first and last name?
Corey Washington. Corey spelled Koeerri. Washington is Washington.
Are you, what is your current employment?
I'm self-employed.
What kind of work do you do?
I'm social media influencer.
And would that include doing live streams on Facebook?
Yes.
Now, do you live here in Kenosha?
Yeah.
How long have you lived here?
My entire
Guys,
life.
how
I
many
was
subs
born
does
and
he
raised
have?
here.
And did you go to school here?
Yes.
Whereabouts?
Starting from elementary school.
Middle school and high school.
I went to Washington Middle School, Ruther and ITA.
And you mentioned that you do some work on social media. Were you involved in doing some live streaming on the night of August 25th, 2020?
Yes.
Why were you out there doing that on that particular night?
There was a lot happening in the city.
What was your purpose in trying to document that?
Just create transparency.
What do you mean by that?
When things are going on, there's a bunch of opinions. You never know, what really might happen. So people like myself tend to go out and document situations just so there's a record of things. A lot of the time, especially, the media, there's sound bites and things that can be utilized. And in my opinion, people like myself make things better for everyone because it helps show at least another side of the full picture.
Now, tell us what was going on in Kenosha around the time period of August 25th, 2020, in your own words.
There was a lot of protesting. There was a lot of property damage that ended up happening throughout the week. Some would say riots, civil unrest. Some would say uprising.
Would it be fair to say that that began after the shooting of Jacob Blake on Sunday night, August 23rd?
It definitely began after the shooting of Jacob Blake.
When did you personally begin your process of live streaming or documenting what was going on?
The night the shooting of Jacob Blake took place.
Sunday night?
Yes, Sunday night.
Tell us about what you did.
Starting from the beginning.
On that particular night after the shooting, I assume you made some sort of decision. I need to be out there taking video.
I mean, it was a Sunday night. Typically, I try not to work on Sundays. I had just taken a lady friend of mine to dinner. We got back, received a phone call, received a message with a video, saw the video. They said, hey, we're probably going to need you to come document. And I was like, of course. So I just went out, went to the location where the shooting took place, kind of just watched and, documented as people kind of gathered onto the scene as things kind of progressed throughout the night.
Do you recall approximately how long you spent out there that night?
Several hours.
All in the area near where the shooting occurred?
No. So, the shooting occurred. There was, bedlam took place. The police ended up leaving. A march ensued. I followed the protesters to the courthouse here and the safety center and kind of just followed along wherever everything was kind of taking place.
Tell us in your own words what you observed about what was going on with the protests and things like that.
From that point,
let's start with that first evening, Sunday night. You said there was a march from the site of the shooting to this area. What did you observe?
So Well, when I arrived on the scene, there was a crowd already there. It wasn't too large of a crowd, but over a period of a few hours, the crowd began getting larger and larger and larger. You could start seeing license plates and people from out of town showing up on the scene. Once there was, I'd say, too many people, I guess, for the sheriff's department to handle in that location. They spoke with the gentleman. After they spoke with him, I guess they decided to leave. They came back to the police station, and then afterwards, the crowd was there, and they're like, "All right, let's head to the courthouse." So I just followed along the way.
By the time the crowd got to this area by the courthouse, can you give us an estimate of how many people were involved?
Few hundred people, maybe. It's hard to say. It was, by that time, it's incredibly dark outside. There was a heavy police presence. I believe by the time the protesters got to the location, there was already, I believe, police from neighboring counties and cities already here to help. So to me, maybe 500 people. I'm not sure off top. There was definitely a lot of people over time, and it kind of seemed to just kind of keep growing as things progressed throughout the night.
Now, once the crowd got into this area by the courthouse, did they primarily stay here, or did the action move elsewhere?
So as far as I could tell, initially things kind of remained outside of the safety center building. There was a lot of, sheriffs and police in riot gear kind of lined up. There were protesters kind of going back and forth with police officers, things of that nature. At a certain point, I don't know what happened. There was like tear gas deployed. People kind of started, spreading out. People were getting shot with rubber bullets. I had got shot and stuff like that too at the time of all of the disbursement. Took a few minutes to kind of, gather myself, got some attention, someone kind of patched me up or whatever, get out out here to face Civic Center Park right out in front of the courthouse here. And that's when I kind of noticed things were, I guess you could say, out of control. Throughout the entire summer, there had been a lot of protests going on, activists kind of going out, peacefully protesting, letting their voices be heard. So I was out, documenting all of that. But the moment when I came out and we had the roads blocked off with the garbage trucks or whatever, kind of to, I guess, contain the crowd or whatnot. But when I came out, I noticed all of the garbage trucks were on fire. That was kind of the point where I was like, oh, all right, this is not like anything that's been going on all summer. So,
did you see other incidences of property damage after that?
Yeah.
What can you tell us about that?
There was a lot that was kind of going on. There was people, of course, the trucks were on fire. I filmed someone going into the back of a truck probably a few minutes after it had exploded from the gasoline catching fire, going to the back trying to find debris or something to, break windows or whatever it may be. Captured someone throw, it seemed like a napalm or something onto the courthouse. That got extinguished. And then there was another point where, some masked individuals in black were trying to burn down the dinosaur museum. So for the most part, I try to not involve myself. The situation with the dinosaur museum, I involved myself in the situation just because, we don't have much stuff around here, and I'm a father, I have kids, I've grown up, I've gone to the dinosaur museum. So at that point, I kind of realized, I suppose it was not like, this is getting way too out of hand, not saying that I condone people, being aggressive towards police or the courthouse or anything like that. But I could understand their grievances, I suppose, in the situation. But when it started leaking out to other stuff like the dinosaur museum and stuff like that, that's when I was like, okay, well, this is...
The dinosaurs didn't do anything wrong.
Yeah, it has nothing to do with anything that was going on.
What did you do to involve yourself
wrong.
with the dinosaur museum?
I stepped up, I kind of shouted at the crowd, like, hey, like, what are you doing? Kind of slightly interrogated one of the people that I assumed was involved. He seemed pretty passionate about burning it down or whatever it may be.
What's your
and from
passion?
there, kind
Burning
of
down
people
a
in the crowd,
dinosaur museum.
I
That's
guess,
my
I don't know,
passion.
kind of be like, hey, yeah, he's kind of making a point or whatever. And then from there was kind of a dispute, and I kind of found a way to kind of get myself out of the situation because it seemed to be getting pretty heated. So.
Did you observe any property damage that first night, Sunday night, in any other parts of Kenosha?
What's your response?
Well, I think first of all, it lays sort of the context of the whole situation. But second of all, there's been a lot of allusion to the fact that the defendant was motivated to come down here in response to this. So I think it's important that we get evidence about what it was that was going on. You may continue.
So for the most part, of course, there was people that kind of trickled into other areas. But as far as I was able to see and document for the time that I was out there, which was quite a while, most people were kind of staying together in the same group, in the larger group. But of course, in a hot situation like that, of course, there's going to be people with their own motives and objectives that may go out and do other things as well. So
I guess my question was, did you personally witness property damage along, say, 22nd Avenue, for example, or 60th Street or any other parts of town?
So no, not that I recall. Of course, when the march was happening from the location of the shooting to the courthouse, I mean, there was, traffic stoppages and things of that nature, but people weren't being violent with random pedestrians or anything like that. It was really just like a march to this area.
Okay.
And until we got over here, that's when actual damage started taking place.
Now, I believe you indicated that there were times during the summer where you were out recording people who were letting their voices be heard here in Kenosha. Is that fair to say?
Yep, multiple times a week.
Did you kind of get an idea of who kind of the main people were involved in those sorts of events?
Mm-hmm.
Is that yes?
Yes.
On this Sunday night, after Jacob Blake was shot,
right,
did there appear to be a different type of crowd to you?
Yes. So in my opinion, initially, the people that were on the scene are familiar faces. As things got more and more heated and more people started showing up, faces started to become more unfamiliar. I noticed at a certain point, I know for a fact the gentleman that talked to the sheriff before the sheriff's department and the police department ended up leaving was a gentleman, I believe, from Black Lives Matter, Milwaukee. But I had not seen him before. And I mean, if you review some of my footage, I recall saying several times, like, who is this guy? Why are they talking to this guy, to kind of figure out what's going on? Because at the end of the day, most of these people seem to just be people that are passionate about what happened, but not organized at all. So. And
when you were out on that Sunday night, were you live streaming on Facebook?
Mm-hmm. Yes.
Is it possible for folks to still go up and see that on your Facebook page?
Everything that I've ever recorded, unless it was taken down by Facebook, I haven't received any notice that anything has been pulled. It's all live on my Facebook.
So let's fast forward to the next night, Monday night, the second night of protests and whatnot. Were you out live streaming that night?
Yes.
How would you characterize the events of Monday night as compared to Sunday night?
So at nighttime, I would say it's worse because there was more people here. It seemed, in my opinion, it just seemed that it was, I guess, the best case scenario for something like this to happen, just with everything that was going on in the nation. There was a giant migration from the West headed to Washington. The situation with George Floyd was hot in Minnesota, and people were kind of close to get here. I'm sure everyone knows there's plenty of people from Minnesota that ended up in Kenosha that night and the following nights. The next night, that Monday night, there was protests and things throughout the day. As far as I recall and remember, during the day, everything was peaceful. There was talks of, hey, like we can't allow stuff like that went on before to go on again. But as nightfall comes, there's more mysterious people in the city. You don't really know, everybody. And again, everybody has their own motives really in a situation like that. So you definitely could tell that there was plenty of people being, I suppose, opportunistic about the situation.
Some of the more noteworthy instances of property damage during all this, I don't know if you're familiar with them or not. The Car Source lot over on the east side of Sheridan.
That talks a lot.
Burned one of these nights. Are you personally familiar with that?
Yes.
Did you witness any of that? Is that a yes?
Yes.
What night was that? Do you recall?
I believe it was Monday night.
There was also a lot of damage to the uptown area along 22nd Avenue.
Yes.
Did you witness any of that?
Yes.
Do you remember which night that was?
I believe that was Monday night as well.
And then I know the probation and parole office on 60th Street burned down. Do you remember if that was Monday night as well?
I believe it was. I'm sorry, I don't, it's not something that I necessarily really wanted to go back and review several hours of, with everything that kind of transpired. So I believe it was
this guy talks
more than likely that
more
Monday
than the
night. I
prosecutor
know
wants.
for sure when the parole office burned down, I was there. I saw people go into it. I heard people say, let's burn down the parole office, and witnessed it on fire.
So witnessed it on fire.
Witnessed it on fire.
So let's go to the night of Tuesday night, August 25th, 2020, the night when the events of this case occurred. Were you out live streaming that night as well?
Yes, I was.
And how would you compare Tuesday night to the previous couple of nights?
I would say it was calmer, much calmer. The crowd was more contained. There was a march that happened. That kind of ended towards the end of the night, maybe around 6:30 or 7 or so. That ended at Civic Center Park. The conversation that was had at the end of the march was, hey, everybody remain peaceful. Go home after this. If if you're seriously about, wanting change and wanting justice, to go home. After that was said, people dispersed. A lot of people did go home, but there was people that didn't go home, of course.
Did you go home?
And those people that didn't go home, they kind of stayed there at Civic Center Park there until at a certain point they were kind of driven out of the park.
Were you there to witness the interactions between those people in Civic Center Park and the police at this particular scene?
Yes.
On that night?
Yes.
Would it be fair to say that there were some fairly violent confrontations between the protesters and the police right outside of this courthouse that night? Would you agree with that?
Yeah.
Other than that, were you checking around the area to see whether there was property damage in other parts of the downtown area that night?
Yes, so I generally what I would do, I would always kind of survey the area to see what was kind of going on. I'd find the crowd, figure out where the crowd was, see what they're doing, kind of go in the general area around, a couple block radius or whatever it may be.
So when you were watching the crowd that Tuesday night, other than the demonstrations out in front of the courthouse, did you witness a lot of other arson, looting, property damage, that sort of thing on that particular night?
No, not on Tuesday night.
Now, there came a time in which you were recording your live stream along Sheridan Avenue. Is that right?
Yes, Sheridan Road, yeah.
And are you familiar with the Ultimate gas station?
Yes.
Okay. And that's at 60th and Sheridan, is that right?
Yes.
Is it fair to say that you spent some time that night recording some video?
Yes, yeah.
We're going to have play a portion of your live stream. Could we begin at 18 minutes, please? And this has been marked as exhibit number 11, and I hope so. Let me just make sure that the power is on and everything.
What do you think he's going for here? I think he's going for the idea that Kyle's an outsider along with these other outsiders causing violence.
I'm having a tough time getting a theory from this guy of what the theory of it is. Or from the prosecution's point of view.
Yeah.
I want to pause for 1 second before we continue. Mr. Washington, what we're seeing on that screen, is that the live stream that you recorded on the night of August 25th?
Yes.
And do you recognize the location that's being shown in that video?
Yes, that's the at the Ultimate gas station facing west, kind of looking at the church. I believe it's a church right there.
All right, thank you. Oh, I'm sorry. I meant to turn the power on, but it may not have kicked on. Oh, I get hit the
Boomers.
What?
Imagine a lawyer having tech issues. How embarrassing. Ridiculous. I've never even seen that in my life.
Thank you.
They're about to light up this garbage can. So they got fire in the street. I don't even downstairs. Excuse me.
That is riveting commentary.
It's right downstairs.
I'm going to pause 1 more second just to help everybody understand what we're looking at here. First of all, we just heard someone's voice. Was that your voice?
Yeah.
Okay.
Muffled because I had a mask on.
Sure, I
don't know what
understand.
sound like that.
Do you have that easel still? I'm just
You had a
gonna
mask on outside?
show us on this map so everybody's oriented to where
It's a
we're
different
at.
time. It's a different
I've got a
time.
map here of the city, so I just want to have you point out where we're at so that everybody can put it into context.
Okay.
I saw he had about 1,200 subscribers, by the way, is what someone said. So his job is social media influencer.
Living the dream.
All right,
Get
Mr.
it, son.
Washington, I've got a map up of the downtown area of Kenosha. Can you please point out where the Ultimate gas station is? Okay, and that is at the intersection of the southeast corner of 60th and Sheridan. Is that correct?
That's correct.
Okay. The video we were just watching, which disappeared for a second, but is back.
Hold on.
I was just going to ask that question.
No. Southeast of 60th and Sheridan. At least when I went past it on my way here this morning, I thought that was the Methodist Church.
So, Judge, the southeast corner is Ultimate Gas. The southwest corner is First United. On this map, north is up.
Did you see 60th and Sheridan?
I did.
What am I doing wrong?
You're failing to consider that an intersection has 4 corners.
I agree, Your Honor, that the ultimate's
Huh?
I don't want to disagree with you, but the ultimate is the southeast corner.
Where the Methodists been going to church?
That's across the street, Judge.
All right, I'm going to accept the correction.
So, Mr. Washington, just so we understand, you had described in your video that at one point, and I think at this point as we look, is that video now pointed west?
Yes.
And on the map there, it indicates that the Methodist Church is across the street to the west of Ultimate Gas. Is that right?
Yep, right there.
Okay.
That's what I said, isn't it?
Of course, Your Honor. Of course.
Nice. That's why I said yes. Sure.
Oh, yeah. That dumpster is about to be lit up.
There's the dumpster fire.
Why you do that? Why you do that? Why you do that?
Rosenbaum.
Pause for a second here because we're going to be viewing someone that I want to talk a little bit about. I assume since the night of August 25th, 2020, you're aware of who Joseph Rosenbaum is. Would that be fair to say?
Yes.
Okay. And let me just put you back in the state of mind of that particular night. As of August 25th, 2020, did you know who he was?
No.
To your knowledge, had you ever encountered him before in your life?
No.
Okay. I don't know if you're familiar with this video or not, but for the benefit of the jury, do you know, are you able to recognize Mr. Rosenbaum in this video? He's not shown on the screen at this very moment because we paused a little bit. I didn't call timeout.
Oh.
It was a little later. But let me just ask generally, are you able to recognize him if you see him on the screen?
Yeah, I would know what he looks like, yes.
And that's based on what you've learned since all this happened?
Yes.
Okay. And just, I don't think there'll be any dispute about this. I'll represent for the ladies and gentlemen of the jury that Mr. Rosenbaum is wearing a red shirt. He's got some, I think they're jean shorts, aren't they? And I don't think he's got anything.
Grown man unironically wearing jean shorts.
So he's kind of a shorter gentleman with nothing on his head, a red shirt. And you've got some video of him that we're going to see momentarily. So I wanted to let the jury know that. So as we're watching, you know what to look for. So go ahead. Thank you.
Probably not the smartest.
He's the shortest one there. That's how you
Yo, don't throw shit over here, bro. They about to. Bro. I'm not trying to fucking shot. Yeah, bro.
Stop doing shit!
Nah, people ready to fire on people, bro. We got people in position.
He's so happy with that gun. He look like he want to shoot somebody. Anybody do that shit? He ain't gonna shoot.
Pause for a second there, Mr. Washington. What you're seeing on the screen there, with all the people and all the action on that screen, at any point during this particular incident that we're watching, did anyone fire a gun?
No.
Did you see anyone get physically injured in any way?
No.
Please continue.
This is his route.
You too happy, motherfucker. You too happy. You too happy with a motherfucker. Yeah, because it's
There's a bunch of fire.
Yeah, they're not about to just let you
Objection, Your Honor. What the hell?
looks like the cops are leaving now. Looks like the cops are now leaving. Yo, don't. Come on, bro. What are y'all doing, bro? Yo, bro. Come on, bro. This shit is fucking. Come on, bro.
I'm just imperial.
Exactly.
Damn, dude.
I'm gonna shoot mine. If I bring mine now, we're gonna get shot.
Cops. left, and as soon as they left, things just got heated. I'm not about to stand in a line of fire at all. That's not going to be safe.
It's a long ass video.
No, I'm good, man. Yeah, really. Rocks. Definitely people throwing rocks. Be careful. Careful, because they're throwing rocks. Hey, how's it going?
How is any of this relevant?
I'm confused as well.
Yeah, it says.
Like there might be relevant video coming up. Oh, here's Kyle.
Which shows Kyle acting peacefully.
Oh my God!
This is a lot of setup for what they're trying to ultimately show. I don't think you need this much setup.
No. So are you under the impression that they're trying to set up that Kyle's not, or that no one's being shot right now, despite it being quote unquote heated?
I don't know why they're setting this up. But yeah, we haven't gone to like the punchline.
This feels like 30 minutes.
So there's a bunch of people standing around.
What's going on, bro? You all right?
There's no immediate acts of violence among the crowd that's there. Kyle standing around not committing acts of violence. We've been seeing this for a little bit now. So, okay, that's the situation at the ground state. I get it. We got it a couple minutes ago. We can move on. We all collectively understand the baseline.
Great, how long have you been here? For a bit.
Hey, yo, they trying to circle the shit. They trying to circle the shit.
Who's circling you in?
Organization go to this gas station all the time, so hopefully it'll be fun.
Don't worry. People don't have life insurance, but buildings do have life
Shout out to the
insurance.
ATM, because across the street it's more expensive.
And we're walking, and we're walking, and we're walking. It's like, you know.
Indeed.
I was literally saying that, and bitches got in my face. I'm like, bro, I was the one saying everyone calm down.
This is.
Everybody's just gonna have to agree.
I don't know what this is supposed to show, other than at this particular moment, the people in the immediate vicinity are acting in a peaceful manner.
Yeah.
Okay. Noted.
He said we're going to be talking about Rosenbaum, but where is he?
Yeah.
Like, I figured he was going to be front and center in this video. I thought that was the whole point.
So Rosenbaum apologized. Rittenhouse is not shooting at anyone when there's no threat. Great.
Oh, I hope someone starts twerking. Call it Drexel's Law.
I don't know any of them. Oh,
Mr. Washington, in that excerpt we just watched, I saw a number of individuals that were armed. Did you see that as well?
Yes.
And what was your understanding of what their purpose was out there that evening? If you have one.
I mean, honestly, I didn't talk to everyone individually, so I mean, it's hard to really answer that.
Sure. It appeared to me that there were folks that had long rifles like AR-15s. Are you familiar with those at all?
Yeah.
Did you see folks at the Ultimate gas station armed with that type of rifle?
Yes.
How many would you estimate you saw?
Four?
Consistently at like one time or throughout a period of time?
One time that we're all there.
Maybe,
one time.
maybe like 24, maybe a little more, something like that.
Where were the other 20 of them?
15 to 25 people.
And in the videos we saw there, or the section we just saw, it appeared that there were people kind of getting in the face or getting aggressive with some of those folks that were armed. Did you see that?
Yes. So as far as I recall, there was a lot of discourse happening, heated discourse, but conversations being had.
Did you see that lead to any violence? Anybody punch one another, shoving each other, shooting at one another, anything along those lines?
No, maybe there may have been nudging or something, not that I recall seeing, but nothing that would make you stop and direct your attention to it.
And I believe in that section we just watched, I saw two separate instances of dumpsters being set on fire. Did you see those as well?
Yes.
I don't know if that was the same dumpster twice or.
I believe it may have been the same dumpster.
Okay. And other than that being a perfect metaphor for the year 2020, did you see any property damage as a result of the dumpster fires?
No, as far as I recall, the dumpster was lit on fire because the police pulled up in an MRAP, and it seemed like protesters were like shoving it towards the police. It didn't seem like they were trying to destroy buildings with it or blow up the gas station or anything like that. There was a lot of people there. I don't know if people would let
Just a
them do that.
peaceful arson.
And
It's
I want to
okay.
ask that specifically because you're standing right next to the gas pumps in the video. Is that right?
Yes.
Did you feel like that
No.
was an unsafe place based on the dumpster fire or anything
No.
like that?
No.
Did you see anyone ever push anything on fire towards the gas pumps?
No.
Is that really why we're bringing this in for that?
I think it might be.
When you were doing your live stream,
All that for that?
were there folks watching that you were aware of?
Yes.
Were
How
you
many?
able to respond to them or communicate with them as the live stream was going on?
Yes.
Okay.
Throughout, I'm sorry to cut you off. That's why throughout like the live stream, I mentioned like going to the ultimate gas station to get cash out of the ATM. There is always viewers, some people from town, some people from out of town, some people with questions and stuff like that. There is a lot of, when we had protests for, I guess the big protest for George Floyd earlier in areas to see if people are spilling out somewhere, to see if, things are actually happening.
No, the audio was good. It was loud.
Watch, false rumors or whatever.
Your Honor, I do have an excerpt that I'm going to play.
They hate you, Nick.
It'll be about 12 or 13 minutes long. I don't know.
Oh my God.
Continue in the morning.
Will we end up breaking afterwards, even and without this witness being complete?
Yeah.
Well, I may be done with my direct at that point. I'm not sure.
Well, we have to have him back for cross anyway. So let's break for the day.
Thank
And-
God.
Okay. Please overnight, read, watch, or listen to any.
12 or 13 minute excerpt he's going to play.
Yeah.
And,
Was the sole point of that excerpt to stand for the proposition the dumpster was not pushed into the gas station? That's a lot to establish that.
I mean, it kind of seemed like it.
Arrangements and I'm sorry, Mr. Washington, you can step down. Thank you. And
I bet Kiori Washington has a whole bunch more subscribers after this.
hey,
We should invite him on for a collab.
everybody leave the room right away, except for. Pardon me. Well, are they going to stay here? These people have to. You people. All right, whatever you say. I'm going to turn it over to you. All right, thank you.
What do you mean, you people?
The jurors, the clerk wants to talk to them.
The clerk wants to talk to the jurors? Okay.
Or do you want them in here? Probably well, it's easier in here, but I don't know. How long is it going to take the media to scatter? Can I talk to you photographers for a minute? We have an issue.
Talking to the photographers in the courtroom?
Okay. Let's, would you? Yeah, that's probably the best. All right, you can go up to the jury room, please, and the clerk will deal with it.
Yeah, why you wouldn't have the jury leave through the approved place immediately and then have the media clear out just to avoid accidents is beyond me.
The police holding those pending the outcome of the trial? Okay. Or maybe you could just.
Did the stream mute? The audio's really, I know the audio dropped dramatically on me. It's not me. I can't change it. This thing's about over anyway. I can't boost the audio. StreamYard doesn't let you. Not on a shared screen. But I guess we're done, right?
I guess. Someone is texting on their phone in the courtroom. I don't know, man.
That's amazing to me. In here, you can only have a phone if you're an attorney.
Yeah.
Like, that's it. And basically because we need to schedule. And that's about or if you have notes on it or something. But even if you're sitting there with a phone out, I've seen bailiffs come up and just take phones from people in the court building.
The fact that they're able to turn their phones on in the courtroom, even though it's over, is a bit amazing.
Sean and Mark, I'm going to ask that you guys, and of course I already spoke about the shooting over the church. Can you not do any of these perp walk type things when witnesses come up? And you can take them on the stand.
No perp walks.
Wait till they're on the stand. Of course. Okay, great. Thank you.
Yeah. Don't take it until they're on the stand. That's fair enough.
Yeah, well, just there's not much space there. I mean, this place looks a lot bigger than it is from the photography, but courtrooms aren't huge. And so if you're sitting here trying to get a slow pan back as the guy's walking up, I mean, you're just in the way. Okay. I think that's evidence that we're done.
Yay.
All right, let me stop this.
Okay. So we can give our roundup for day one, I guess.
Yeah. So what do you think, man?
Well, I think I don't understand why this last witness is being called up to this point. And I don't understand why we saw so much video. It doesn't make sense why you have that much. If you're trying to show the dumpster moving through the frame, but you want to establish the initial state, which, fair enough. How much video do you need to do that?
A minute?
If that, right? So, why do we go on forever to show nothing happening? It was very confusing to me. So that was weird. The defense. As for the first witness with the friend, I thought both sides did a good job. I think the defense made some good cross-examinations that answered some questions. Why was Kyle on the ground, not on the rooftop? Here's the answer. Why did Kyle move from this place to this place? Because he was told to. Why were some of these decisions made?
Yeah.
It's okay, so it answered some of those questions, which was very helpful. And the prosecution did their best to mitigate, but the defense, I think, had the better end. They had the better end of the exchange, I think, overall. As long as we have someone who can actually wrap it up all at the end to distill it. But yeah, and I remain of the opinion that the opening by the defense was pretty bad. So yeah, that's the kind of where I'm sitting. So I guess we'll give the day to the defense.
I think the defense does get the day. The opening was bad, but I'll maintain that the defense's case is strong enough to just in general at this point is strong enough to overcome the mitigated performance of Richards on opening argument. Because I mean, the fact that everybody was asking me how long the state's opening statement was, and I kept saying 15 minutes, legitimately believing it was about 15 minutes.
If you had asked me to guess, I would have said 20. So yeah, but it was apparently 34.
Right.
And if you asked me to guess what the defense cases, I don't know what I'd say other than forever.
Methuselah.
Yeah, Methuselah.
It was eternal. It was really long. It felt a lot longer. So that alone should tell you, just on performance alone, the state performed really well on opening. The defense didn't perform very well on opening, but their case is really, really strong. They got a lot of stuff that they needed to get into there, and that's good. I think on examination and cross-examination, the defense is carrying the day on just what they're getting out of these witnesses. The state is doing an okay job of asking questions of the first witness. They're just not very big issues. The second witness, I can't even figure out where the state's going right now.
Yeah, I don't know where this is going.
Yeah,
I don't know where this is going.
It was awful.
When Rittenhouse started running to the gas station, was he running from the other gas station? Was that where the running started?
I have no idea.
Yeah, because that could be the only other thing I'm wondering, because maybe we show I was waiting for someone in the crowd to yell, there's whatever happening at the other gas station. I was waiting for that, and everyone starts running in that direction.
Yeah.
But that's not where that went. Apparently that went for the 2 seconds on screen where we saw the dumpster fire rolling through. All right.
Yeah. Now, we don't know what happened with the other witness. We don't know who that was. We don't know what their testimony was. We don't know anything about it. So that could change some things. I think the prosecution has to be getting frustrated with the judge at this point, though.
You think?
They're losing like every motion hearing and every objection except for there was one objection that was overruled, but like losing on the opening argument stuff, like why you're going to let them display a bunch of unadmitted evidence without foundation like that. I mean, I think it's funny that it happened, but at the same time, I'm like, I don't know that the judge should do this unless they've stipulated to the admissibility prior. If it's in both, if it's something that the prosecutor is intending to bring at trial, then okay, you can bring that up, sure. But the stuff that they haven't stipulated to admissibility, just authenticity, and they're bringing it in there, and the prosecutor had a good argument, like, you're going to allow this, judge? Like, we don't do that. But the judge hit him back with your office has done this.
That was a nice clapback. That was the ultimate clapback. It's like, your office has done it, so you can do it. It may not be your practice, and it's not necessarily even wise. I don't know if it was a wise decision, if it could be done better with the video. So whether or not it's a good idea to bring it in or not. Yeah. But yeah.
Yeah. Well, see, that's the other thing. His opening statement was what it was today. Without the video, would it have been worse? And that is actually a possibility, because maybe he's uncomfortable speaking without a visual aid. No. Someone in the chat mentioned that Richards did a lot better when there was an adversary, when there was someone to bounce off of. His questioning on cross was pretty good. Maybe without that, he needs something to refer to. I don't know. People speak in different ways. But if that's the case, he should have just had Sharif C do the opening statement, because that guy has very competently spoken throughout this trial, and he seems to be pretty good at it. But that being said, it is what it is. I do think the defense, from what we saw, I think the defense gets the better end of today. It doesn't really mean much. It's the first witness and the third witness that we saw on two relatively trivial issues. The ultimate stuff is going to be, I think at the end, they're going to have to just solidify. You heard a lot of testimony today from over the past 2 weeks over a whole lot of people about a whole lot of things. And what you really got to get down to is this 7-minute time period where Kyle Rittenhouse is involved in two altercations with 3 different people, and those people, or with 4 different people, and those people ended up being shot because he was afraid for his life. And that's what we got to focus on. Was Kyle Rittenhouse reasonably afraid for his life? Everything we've seen shows that Kyle Rittenhouse was subjectively afraid for his life. So you just have to determine if a normal person in that situation is afraid for their life. That's the question we're asking you today.
Yeah.
If you're being chased by a guy who has said, I am going to kill you if I get you alone, who is throwing something at you, you hear gunfire relatively close by.
Yeah.
Do you feel in fear for your life?
The prosecution is essentially going for this, basically the equivalent of the mostly peaceful protest. That's basically where they're going. It's like 99% of the time the protest is peaceful, therefore it was peaceful in this exact instant, says the media. That's kind of where they're going. Overall, people were having discussions. People were maybe aggressive in their verbal, but, there wasn't really any sort of confrontation. People were throwing whatever they were throwing, including rocks, including tear gas or whatever. And so for the vast majority of the situations, there was no need for self-defense. Therefore, this situation does also not require self-defense. So it's basically the mostly peaceful protest argument, which doesn't flow, because self-defense is going to base on what is happening in that moment.
Yep.
So what every other moment was like kind of doesn't matter in any way. Who cares much one way or another?
I think oh, sorry.
Yeah. No, I was just going to say, except to so much as Rittenhouse was aware of all this, and which seems to help Rittenhouse because he's aware that while it might not be life-threatening violent up until that moment, there is an air of confrontation, let's say, that informs the situation.
Yeah, and that's what I was just about to say. It seems like the prosecution is taking a really risky path where they tell people it's really dangerous out here. There's people getting violent with each other. There's arson happening. The police have pulled back. Like, they're telling people all of this stuff that normal people in normal circumstances go, okay, I'm feeling less safe with every one of these things that's happening.
Yeah.
And
fair.
so all you need at that point is the tipping point. And I think the tipping point is being chased by someone who's screaming like a lunatic and a gun goes off. I think that's
the gun going off is the big thing that I think tips the analysis for Rittenhouse. Because he has every reason, like everyone there has every reason to think they're the one being shot at.
Yep.
That would go to Rittenhouse too, especially since his back is turned. So he knows he's being chased. He hears a gunshot. He continues to be chased. There's a struggle for the gun apparently. He shoots in self-defense. It looks good. But in trying to analyze the self-defense, it's like how far back from the instant of shooting do you have to go in order to determine imminence? I mean, you don't really have to go much further back than 10, 15 seconds to really understand the full context. And everything else after that's just kind of gravy.
Yeah, unless you have that 10, 15 seconds, and I'm not saying this is the case here, although there's some indications that it might be, unless you have some specific context and then a break in the time. Like, for example, if Rosenbaum actually told Kyle Rittenhouse, as the defense has alleged, if I get you alone, I will kill you, then
that would be extremely helpful. Yes, then we would want to know that.
Right. Then him chasing him even 10 minutes later, that 10 minutes, nothing there matters, but the 10 seconds of him chasing and that statement from 10 minutes prior is huge.
You are 100% correct, sir, and this can go both ways, incidentally. If Rittenhouse somehow was the aggressor in some sort of earlier confrontation or said some things or whatever, that would read against Rittenhouse later. And for the exact same reason, if Rosenbaum was saying, I'm going to get you, I'm going to hurt you, I'm going to mess you up, or whatever those statements were, then he can rely on those statements as going to his intent. Why is he chasing me? I don't know. Maybe it's for the reasons he just told me about in relative past. So yes, it would go to inform his knowledge of what is happening. You are absolutely correct. So I overstated my case. Bad on civil law.
Oh, I wasn't even arguing with you. I was mostly in agreement with what you said. So
okay, well, I thought you had a good point, because I was like, oh, how much further back do you have to go? 15 seconds. Well, not necessarily if this is true. I'm like, damn it, you're right.
All right. Well, I think we've had a great stream. I'm gonna read a bunch of super chats. If you want to hang for them, you can. If you don't, you don't have to. It's been
I might just
8.5
bounce at the
hours.
middle for no particular reason. That's fine.
Up to you. All right, guys. To the chat, by the way, if you don't stay for the super chats, thank you for watching. Come back tomorrow, 9 a.m. We're gonna hit the next day, and the next day, and the next day, and the next day, and we'll see you there. Thank you, guys. To everybody who's new to the channel, welcome. Rogue says, rake the prosecutor of the coals in 1080p. I agree. Johnny Stoffel says, be sure to salute every time we see Kyle. For Chanimal says, that light behind the judge's shoulder makes me want a Big Mac. I don't know why. Andre Tukolsku says, oh, and he's gone. All right, just me and you, chat. Just me and you. Andre Tukolsku says, Jack Prosobiec just dropped never before seen video on Twitter. Giant Skill sent a ones up or whatever. Arlanius says, how hard is that opener getting chewed out during lunch? What a shit show. Well, he's the lead attorney. I don't think he's getting chewed out. Garrett Gutierrez says, those were the worst opening statements ever. No, the prosecution's was actually really, really good. Frankly, it was really good. As a defense, again, if you're the defense attorney on that case, you do not want a prosecutor. I got a bump now. You do not want a prosecutor who comes out with that opening statement. You want someone to come out being like, you want a dummy. Kingslayer Damocles says, to be fair, he corrected himself every time he said victim. Dan B says they showed the approach of Gross to exemplify Kyle's restraint during the false surrender, only using his firearm when Gross pulled a Glock. Yes, I know that's why they did that. And I just thought that the pictures that they chose don't show exactly what they say because of the different angles. I thought they could have done a little better there. Jason the Great Awakening says, can the defense approach be a technique to communicate the chaos of the night to the jury? So painting a picture, so length and apparent lack of structure makes sense to me. No, they're not doing a meta. It just kind of was messy. And the hard thing is, now Kurt's not here to defend himself on this, but he mentioned that the defense doesn't really have a strong narrative, whereas the prosecution did. The defense doesn't really have a narrative. They don't have to explain why Kyle is doing all of this stuff as much. I mean, they should give some explanation, but their narrative is pretty simple. He was threatened. He felt threatened. Anybody would feel threatened reasonably, and he's justified in using self-defense because he was threatened. Why he's down there, that's context. Okay. But that, aside from showing that he wasn't there to shoot people specifically, they don't have to tell that story. And so when you don't have to tell a story and you don't have to craft it, then you get stuck with, I've got all these facts that are really important. I want to get them out. Maybe that's what caused the chaos. I'm not here to dump on Richards. I think his opening statement could have been better. It got a lot better near the back end of it. And he got some good stuff in. Mean Sarton says, bang. Johnny Doe says, I disagree with Uncivil. This case needs to be facts-based with a solid timeline. Anything else is a story with people's emotions. Yeah, I mean, what it needs to be in the realities of juries are different. You're telling the jury a story because that's how people take in information pretty typically. And the jury is going to listen to stories more than just your recitation of the facts. Rumpley Depew says, I am from Northern Illinois and been around Wisconsin people my entire life. Problem isn't the accent. The problem is the lumbering, stilted non-rhythm of his speech. Stega says, as a Wisconsin with family in Kenosha area, they sound fine. I didn't even notice what the chat was talking about. Yeah, that's what I was thinking. Justin Wright says, keep doing what you're doing, Uncivil. I appreciate the devil's advocate setting you are using. And yes, Richards has a heavy accent. I live in Wisconsin. Is grating for me too. Phoenix Lord Asserman says, don't take salt from the chat personally, Uncivil. They're just giving knee-jerk reactions. You're doing fine. Walulu says Chad is treating Uncivil like he's Kyle and we're Rosenbaum and we're not afraid of going back to jail. Caleb Crow says this may only work for my personality, but one of the most effective aspects of defense was blowing up the state's narrative. The contrast in spin versus pointed factoids is almost jarring. And that may end up working. It's hard to say. The Dragon's Treasure says, can you explain problems with the prosecution's objection? Look, if you're going to object in opening arguments, it's got to be great. It's got to be a real reason with serious things. The worst part is they objected prior to opening arguments, were ruled against, and then they objected again on basically the same grounds. That's just bad. Ticks off the judge, and it makes the other counsel annoyed, looks bad for the jury, and it's just a rude thing to interrupt. And if you object on petty things a whole lot, the other side's going to start doing the same to you, and they'll win some of them too. And it makes everything stilted. Ava M says, I love you, Uncivil. Hope that helps. Ray Fernandez says, read that one. Scipio says, historically, how much advantage is that one juror thing really? If everyone else in your group goes one way, many people tend to fold. Yeah, it's actually all about finding the right juror. But how strong is that one juror? It depends on the strength of that one juror. If the one juror is resolute, they can turn an entire jury, or they can hold the line against them. You just got to fish it out there. Justin Wright says he feels military to me as well. It would explain the presentation, which is military PowerPoint, which would put anyone to sleep. Talking about Richards, I'm guessing. D says Jack Posobiec on Twitter posted the FBI drone video. Also, if convicted on all counts, could the gun charge being included be considered prejudicial if overturned on appeal, forcing a second murder trial? Maybe. I don't know about that, but maybe. Simon G says, Gunt is streaming the trial too, and you have 12 times his viewers. You can't trick the Nick, can't defeat the Ricada. Yeah. Well, like I said, I'm streaming. Whatever anybody else is doing is up to them. I've been waiting to stream this trial all year, and I'm happy to do it. Maud Dib says, hard R in the courtroom forces prosecution to argue that A is less threatening than hard R. Brilliant. Silent Bash 27 says, is it possible they will use his deposition instead of testifying? Possible wording issues. We don't know. I don't know that he's necessarily going to testify at all. I don't think Kyle was deposed in this case because you can't force him to be deposed either. He was interviewed by the police early on, but that's not testimony under oath. So it's a little different. I think maybe Richards misspoke, or maybe they plan to have Kyle on the stage. We'll see. Or on the stand. Thomas Minier says, Daily Beast saying Kyle will testify at trial. They posted that article 5 hours ago. If they say so, who knows? Catharga says, as a layman, watching that prosecutor stand there and spew sophistry for half an hour made my blood boil. Expert Spectre says, the CIA glow in the darks trying to knock your ass down. Lost Bullet says, uncivil just Joe Biden himself in front of Nick the Pope. Comrade Roof Korean the Based, I think, says, chances judge kept rifle charge to set precedent. No, I don't think so. Hunter asks, what are three? So low chances. First of all, his court won't set precedent. It would have to be appealed, and they'd have to win on appeal or lose on appeal. But I don't think so. Hunter S says, what are 3 other popular base YouTubers such as yourselves for a lad in his 20s? Gosh, I have no idea. As far as based YouTubers, I don't even know what that means. I guess you could check out podcast The Lotus Eaters is Sargon. Interesting stuff. Other people are probably way better at finding that than me. I don't know, because I only watch cooking channels. I just want to eat. Don Borvio says, FEC ruled that foreigners can finance U.S. referendum campaigns. So much for worrying about Russian interference. Sliding Edge says, being a prop is now a threat. Snuggle Struggle says, in Iraq, the people were terrified of boomsticks, not tactical rifles like AK-47s and AR-15. Shotguns are more scary. Saddam citizens would agree. Sagittarius A-Star says, the prosecutor looks like Gary Oldman as Jean-Baptiste Emmanuel Zorg. Yep, he does. Richard Grubber says, I cannot get it out of my head when the defense saying the evidence will show without thinking of Ronnie O'Neill the third. Wait a minute. Some of these we did read. I read these. This one. Base Shaman says, Sam, you mean Sam Hyde? I knew he was behind this, like he is in every shooting. The Scott 16 says, providing a firearm to a minor is a felony. Last I checked, the Second Amendment didn't specify adult. Citizens can keep and bear arms. Yeah, but they've upheld age restrictions in other contexts, I guess. And, well, no one seems to challenge it. Mr. Squiggle says, I know who he is now. Richards is the voice of Kronk from The Emperor's New Groove. Automata says, some people in the crowd were yelling that Kyle was trying to blind with the laser dot. That was some of the back and forth that night. Swinging Cod says, part of the defense's narrative is Mr. and Mrs. Z and Yellow Pants Man were accusing Kyle of flashing them with a green laser. He established that he couldn't. Azure Kaizen says, have you seen my friend Kyle? He's about this high. Seen Kyle this high? Nate, the lawyer, says, get to the effing point. This is getting bad fast. That was on the questioning, the cross exam. There was a lag period in the middle. I was feeling the same way, but then it got picked up pretty quickly. Mandalore Wise says, knowing Barney's opinion on juries, how likely is it that they've already have a verdict like Chauvin? I don't. They've probably made their opinion on Kyle and then seeing if it's going to change. Who knows? Deep Service says, check Chris Farley's grave. I think that prosecutor ate him. Dude, that guy, that's a big boy. Fractal Machine says, while in the Army, I recall it was really common for soldiers to be disciplined for their weapons being stolen, even with a sling. Also, when you're on the ground, the gun can just be pulled off of you. Phil James says, there were shots fired before Kyle shot that's different than smoke bombs or anything else. No? Yes. Correct. Dachshund's Rule Says defense also did a good job making sure the jury heard that if I ever get you alone, I'll kill you bit. The prosecutor skated over it. Yes. Warfighter Racing says the Law and Crime channel today at C always streams major court cases. Guess I can't send a link, but it's Law and Crime C. They also have ABD, etc. Yes. The reason I didn't use Law and Crime, I was originally, and they were during opening arguments, they were like panning down to the screen and then panning back up, and so the other places had the raw feed from the court. That's why I switched off of them. Hellsnake has best stream ever. Hearing someone go to the bathroom, washing their hands is great. Othamer says, and I personally like the accent in the starting every sentence with and. Sushi Joe says, you should totally watch the FBI footage at some point today. We did. Cullivar says, did you know second-degree murder in Wisconsin has no affirmative defense? I did not. J-Rock Gnome Sayan says, Nick, have you heard Total Eclipse of the Shart yet? If not, look it up. You're mentioned in it. I did hear it. Yes, thank you. Scott16 says, directions apply Rosenbaum to the burn area. Michael Hickson says, gun in the safe, people coming in the house. It's going to be South African farmers all over again. Eric Speculus says, the lockpicking lawyer has shown many times how to break into a safe. He loves lockpicking and is damn good at it. T. Miller says, the Jack Posobiec video on Twitter is synced with cell phone video and other cameras. Yes. Bass player 2011 IFY says, if it's a minor, this could be because during the Floyd trial, the minor was audio only. You could see her face in the video that went with her testimony. Sam says, it would be quite funny if an AC-130 Spectre started hammering the white specks with artillery. Grimsbar says, FBI zoomed in to hide Z's muzzle flash. If you see that, the sound is from Rosenbaum's direction. Kevin Dorr says, FBI running drones domestically, nothing creepy there. Also not sure saying you wish they had a better camera is wise in the long term. It's not what I don't wish they had better cameras in general. I don't actually approve of air surveillance, but it is a public street. I just wish for this instance that the camera was a clearer. JWC 7215 says, note in the video that the car where Rosenbaum hides has a bright white spot on a truck. That's a fire. That's where Kyle drops the extinguisher. All right, we've got some more here. Kyle drops the extinguisher. Here we go. Dachshund's Rule says, well, if you guys called it, the AP is already running footage of Kyle yawning at the witness table. Polaris 589 says, what's the likeliness that there's at least one juror that puts his or her foot down and insists Kyle is not guilty? I don't know what the odds, what the likelihood is, but it happens. It happens a lot. Alex M, thanks for the donations. He also says, as a lawyer, would you suggest concealed carry insurance? I don't know. I don't know how good that pays out. I know some people who swear by it, but I don't know anyone who's ever been defended by it. Eric Bloodaxe says, how is riding a bus from Portland to Riot not crossing state lines to be a chaos tourist? No idea. Hyperion says, man, the prosecuting lawyer really reminds me of Justin Hammer from Iron Man 2. Anyone else? Nice. The Lizard says, Uncivil is great. Disregard Ass Beans. Pro Gunner says, opinions are formed early. The defense is genius. Rogue says, is Bicep Boy testifying? That's going to be gnarly. Not going to lie. I think he will. I think that's the plan. Johnny Stovall says, I boomered my joke. Kurt is love. Kurt is life. Pappy Killjoy says, Zeminski won't be charged until after his trial. How would they blame Kyle if Zeminski's actions triggered this event? Just a thought. Because they will blame him. I mean, that should be clear by now that they're going to blame Kyle for his actions. Jacob Fabiziak says, Rosenbaum was not afraid to go back to prison. Really? Getting tossed in GP with Chomo paperwork would get him designated KOS before he hit the yard. Right, but he was in a hospital, not a prison, recently. Squishy Hunter says, from poll, Rittenhouse will win the case. Pack it up, boys. Keck has spoken. That's from poll number 345777777. Jim Tala says, if I remember correctly, F. Lee Bailey also dropped the hard R in the OJ trial, and that worked out good for OJ. Varick Phoenix says, Irish wristwatch, Irish wristwatch, Irish wristwatch. I hate you. DCV Titan says, what summer was he watching? Automata says, just to check, throwing a Molotov at the courthouse was okay. When you go after diner stores, then you've crossed the line. Yes. Well, that guy's an activist. Corey Washington is an activist, and he's out there activizing. And so, yeah, when something's going to affect his kids and their activities, it matters to him. And when it's the police and court, it doesn't. And a lot of people have opinions like that. Normally, outside of the context, I'm like, F the police coming straight from the underground. The Scott 16 says, viewers, psst, Corey, your bias is showing. Corey, oh, my bad. Zip. Nightmare 0 says, Nick, so do protesters just shapeshift and become mysterious at night? Yes. Eric the Red says, the DA looks like Gary Oldman's gay brother. Dan Campbell says, Dinos Lives Matter. Ryan McCoy says, would Kyle have any case against the care facility for negligence for letting Rosenbaum out if he was in for, say, rage issues too early, given it might have prevented the assault and surrounding event? I don't think so. He would have to be ruled to be, or determined to be, a danger to himself or others by the hospital, and then them let them out for there being negligence on their part. Sam says, when this no bend moved in the direction of the burning cars in the parking lot, he literally became South Korea. South Korea. Okay, yes. Hurdy-gurdy USA says, the media is going hard on defaming Kyle. Thanks to both of you and Uncivil for giving us a better understanding of what's actually going on through this. Nightmare 0 says, when did they get Sleepy Bob as judge? That's Joe's cousin. Snuggle Struggle says, this guy recording during the riot is high. You can hear his slurring. Ask any officer/expert. They'll say that's not a mask. Well, no, it's a mask. It's a mask. That's why I'm slurring. G-Man says, Mr. Washington, exactly how high were you on the night of the 25th? Would you say it was a 2 blunt night? 3? Not applicable says, can't believe this pathetic rabble is our society. Raymond Jones says, hypothetical, if allowed, what would be more damaging to the prosecution's case? Hammering home that Rosenbaum was suicidal or a pedo? Pedo. I think 100%. People do not care when pedos get killed. They just don't. They find it hard. I think that would do it. Nightmare 0 says, I feel that woman's gravity from my phone, Nick. Deep Service says, maybe Binger trying to establish that the Yehudi are the true threat, and it took this silly case to do it. Ryan Hayes says, isn't this the same social media influencer that helped the reporter get into the Capitol on January 6th? I don't think so. Zensway says, is this not helping Kyle's defense more? Corey Washington's video. Kyle's just standing there doing nothing harmful at all. I think overall it does help Kyle. I just think the prosecutor's taking that risk because they need some facts. Othamer says, $2 gasoline. What a wonderful dream. Versi says, the only thing I got from this video is gas price is $2.09. Nightmare 0 says, God, no, Nick. They twerk and the ground will shake, causing the camera unable to be held stable. Gigi Evans, 317 says, 2 dozen guns. Not Mastered Ultra Handsome Jack says, what did I miss, Nick? Give me the TLDR for the past 6 hours. Come check it out on the Krigler show. I'll be over there in just a minute. Marsupio Gamer says, so they were using the dumpster fire not to damage property, but to kill cops? Classy. Sleazy says, when I was a juror on the murder case, I remember it being after 4 and everyone looking at their watch. None of this is going to stick in their heads. Denilus says, how did all their mics go off, or are they actually just sharing one? I don't know what happened to the audio. Is something clicked on the stream and then it went really quiet. Cormac, thank you for the donation. Rob Price says, Nick, did you know Binger's middle name is Claire? No, it isn't. Nightmare 0, is it? Nightmare 0 says that witness got Clintoned. T. Cool says, according to Jack Posobiec, the hidden witness was the FBI admitting there's a second video they won't give to the defense. Check show research in Discord. I'll check it out. Absolutely. Echo to Papa 2 says, I served on a jury for a murder trial and had to watch several hours of the same event from 4 different officers' body cams beginning to end. Yep, that can happen. Crusader Saracen said, could Kyle's gun discipline be used against him? So he was not scared for his life. Can't stomach court proceedings, so I'm just popping in. I mean, they could try. They can, the jury gets to determine how they make that decision. Tor Theo says, Jump Kick Man and Yellow Pants Man are low tier scrubs. Easily got wrecked by Backwards Hat Rifle Boy. Jump Kick Man is that's brilliant marketing. They should label people with such monikers whenever possible. They stick. Cars in Depth says, can defense ask Washington how much he prepped testimony with prosecution? They could. It wouldn't go over well. Marsupio Gamer says, for base YouTubers, you can't beat hard bastard. Dapper Wolf says, hey, Nick, and then sent a bunch of Morse code. Don't know what that says. Crusader says, can defense bring up Rosenbaum pedo pass or irrelevant? Currently, it's irrelevant, but it may come in if the prosecution opens the door. Rob Price says, 100% Binger's middle name is Claire. Look it up. Oh, God damn it. Okay, we have... Pepsi Man says, please have Kurt read this article. I'll send it to him. Rico says, if his lawyer allowed him to testify without a deal, he should be disbarred. Well, they could have not a deal, but maybe an understanding about a future deal. I think that's what's going on. Pretty obviously, this kid knows that if he testifies favorably, that he's going to get leniency. They just haven't reduced it to a writing. Bruni says it's incredibly convenient under cross-exam when Black doesn't even remember things he was asked not but 5 minutes ago. He's been offered a deal for sure. The defense should impeach his testimony. Rico says last witness posted on Facebook about testifying this morning. Is this allowed? And if not, how boned is he and the prosecution? No, he can talk about testifying. Witnesses can talk about what they're doing, as long as what they post isn't completely improper, but can't stop a witness from saying he's going to testify without a specific order. There are none in this case. That's the show, guys. Check me out on the Adam Krigler Show. I'll be over there summarizing my thoughts for the day, and come back tomorrow, 9 a.m. Thank you all for making this a wonderful show. I will see you then. I'll also see you tonight, either on YouTube or Twitch or something. Catch you later. Peace. Peace.
Your Honor, I'm pretty sure we have a mistrial here, sir.
I'm going to mistrial my foot up your ass. You don't shut up.